Court is now in session. Please be seated.
Good morning, Your Honor. May I proceed?
Yes, please.
Your Honor, before the court today, we have the matter of Commonwealth versus Lindsay Clancy. Ms. Clancy is present. She is represented by Attorney Kevin Reddington. The Commonwealth is represented by Assistant District Attorney Jennifer Sprague and Assistant District Attorney Shane Buckingham.
Well, good morning, everyone. Good morning, counsel.
Good morning.
Good morning, Ms. Clancy. All right. The parties ready for the jury?
Yes.
All right. I'll bring them in.
Cora, all rise. Jurors entering.
All persons having anything to do before the Honorable William Sullivan, Justice of the Superior Court, now sitting in Plymouth within the floor of the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now in session. Please be seated.
Good morning, Your Honor. May I proceed?
Yes, please.
Your Honor, before the court today, we have the continuation of the jury trial in the matter of Commonwealth versus Lindsay Clancy. Ms. Clancy is present. She is represented by Attorney Kevin Reddington. The Commonwealth is represented by Assistant District Attorney Jennifer Sprague and Assistant District Attorney Shane Buckingham.
All right. Thank you, Madam Clerk. Well, good morning, everyone. All right. Well, you know how we're going to start this? I'm going to ask you those questions. And just in case you're wondering, does this podium up here mean that I'm going to talk to you for quite a while this morning? It does. All right. So first, let me ask you the questions. Has any member of the jury read, seen, heard, or overheard anything from any source about any aspect of this case that would affect your ability to be a fair and impartial juror? All right. Secondly, is there any other matter or concern bearing on your service as a juror in this case that anybody needs to bring to my attention at this time? All right. Again, as I've said for weeks now, thank you for following those instructions. And so where we are now in the process is, I just want to explain a little bit to you. We're going to do what we call the arguments in charge. All right. And that just means I'm going to give the charge as my instructions. All right. I'm going to instruct you on the law that you are to apply in this case to the facts that you're going to find. And then the argument part is we're going to hear the closing arguments from the attorneys. And the way we do it, the way I do it, is I kind of split it up. So I'm going to give you first half of my instructions. We'll talk a little bit about the specific charges in this case. And then after the closing arguments, I'll come back and give you some more general instructions about how you, the burdens of proof and how you are to go forward and do your deliberations and handle the deliberations. All right. So they take a while. All right. And they can be, well, they can't, I was going to say rather dry, but they are dry. And so what the parties and myself have agreed to do is I'm going to print out, we printed out the instructions that I'm going to read to you. So you'll have those with you, all right, as we go through this morning. And so some people find that helpful to read along and comprehend. Some people don't. So if it's distraction, you don't have to read it. But some people find it helpful, so we thought we'd do that. You also should know that you'll have these instructions. You can bring these with you in the deliberations. So you'll have this whole outline of what the law is so that you are to apply. All right? So at this point, if we could hand out the copies of the instructions. Oh, you already have those? Oh, geez. I forget how efficient our court officers here are. So what I'm going to do is I'm going to start the instructions now. All right? Now, so my instructions on the law are going to be delivered to you in two phases. As I said, first, I'm going to instruct you on the specific indictments that have been brought against Ms. Clancy. After I conclude my instructions regarding the charges, the Assistant District Attorney, Ms. Sprague, and Attorney Reddington will each deliver their closing argument. Remember, the arguments of counsel are not themselves evidence. They're provided to assist you in organizing and understanding the evidence that's been presented during the trial and the conclusions that each party would like you to draw from that evidence. At the conclusion of the attorney's closing arguments, I'll give you the second part of my jury instructions. And in that phase, I will go over a number of very important principles that will guide your overall evaluation of the evidence, your deliberations, and your eventual verdicts. The instructions are to be taken and considered in whole. All right, so the first and second part are equally important. So you to consider all of my instructions as a whole. You'll notice, as I said, I'm reading these instructions to you. Excuse me. I apologize for doing that, but I have to give these instructions clearly and accurately. So as I said, to assist you in your deliberations, I provided you with written copies of these instructions. However, those written instructions are not a substitute for the oral instructions I'm giving now, so please listen carefully. All of my instructions are equally important. You're not to overemphasize one portion of these instructions or ignore other portions. These charges have specific factual elements that the Commonwealth must establish beyond a reasonable doubt, and I'll review those elements with you in detail at this time. Now remember that the law presumes the defendant to be innocent of the charges against her. This presumption of innocence is a rule of law that compels you to find the defendant not guilty unless and until the Commonwealth produces evidence from whatever source that proves that the defendant is guilty beyond a reasonable doubt. So now I want to go into the instructions that are specific to this case. First, I'm going to have a drink of water. Thank you. Now, in this case, Ms. Clancy is charged with 3 counts of murder. I want to talk first about the issue of criminal responsibility. All right. Now, to prove the defendant guilty of any crime, the Commonwealth must first prove beyond a reasonable doubt that the defendant was criminally responsible at the time the alleged crime was committed. The Commonwealth bears the burden of proving beyond a reasonable doubt that the defendant committed the crime with which she is charged, and also that the defendant is criminally responsible for her conduct. The defendant has no burden to prove a lack of criminal responsibility. Criminal responsibility is a legal term. A person is not criminally responsible for her conduct if she has a mental disease or defect, and as a result of that mental disease or defect, she lacks the substantial capacity either to appreciate the criminality or wrongfulness of her conduct or to conform her conduct to the requirements of the law. The phrase mental disease or defect is a legal term, not a medical term. It need not fit into a formal medical diagnosis. The phrase mental disease or defect does not include any abnormality characterized only by repeated criminal conduct. It is for you to determine, in light of all the evidence, whether the defendant had a mental disease or defect. If the Commonwealth has proved to you beyond a reasonable doubt that the defendant was not suffering from a mental disease or defect at the time of the killing, the Commonwealth has satisfied its burden of proving that the defendant was criminally responsible. If the Commonwealth has not proved to you beyond a reasonable doubt that the defendant was not suffering from a mental disease or defect at the time of the killing, then you must consider whether, as a result of a mental disease or defect, the defendant lacked the substantial capacity either to appreciate the criminality or wrongfulness of her conduct or to conform her conduct to the requirements of the law. To establish that the defendant had the substantial capacity to conform her conduct to the requirements of the law, the Commonwealth must prove beyond a reasonable doubt that any mental disease or defect that may have existed did not deprive the defendant of her ability to behave as the law requires, that is, to obey the law. The word appreciate means to understand rather than merely to know. Criminality means the legal significance of conduct. Wrongfulness means the moral significance. The Commonwealth must prove that the defendant knew and understood that her conduct was illegal or that it was wrong. it's not enough for the Commonwealth to show that the defendant merely knew or was intellectually aware that her conduct was illegal or wrong. Rather, the Commonwealth must prove beyond a reasonable doubt that a mental disease or defect did not deprive the defendant of a meaningful understanding of the legal or moral significance of her conduct. The defendant must have been able to realize in some meaningful way that her conduct was illegal or wrong. In considering whether the Commonwealth has met its burden of proof, you may consider all the evidence that's been presented at this trial. You may consider the facts underlying the crime and evidence of the defendant's actions before and after the crime. You may consider the opinions of any experts who testified and give those opinions whatever weight you think they deserve. Now, in a moment, I'll instruct you on the elements of the offense that the Commonwealth alleges that the defendant has committed. Remember that the Commonwealth must prove to you beyond a reasonable doubt that the defendant was criminally responsible at the time that the crime was committed. That is, that the defendant did not lack criminal responsibility at that time. Therefore, it is the Commonwealth's burden to prove at least one of the following beyond a reasonable doubt. One, that at the time of the alleged crime, the defendant did not suffer from a mental disease or defect. Or two, that if the defendant did suffer from a mental disease or defect, she nonetheless retained the substantial capacity to appreciate the wrongfulness or criminality of her conduct and to conform her conduct to the requirements of the law. Now, as I have previously instructed you, your decision should be based solely on the evidence and the law of this case. If a defendant is found not guilty by reason of lack of criminal responsibility, the district attorney or another appropriate authority may, and generally does, petition the court to commit the defendant to a mental health facility or to Bridgewater State Hospital. If the court concludes that the defendant is mentally ill and that her discharge would create a substantial likelihood of serious harm to herself or others, then the court will grant the petition and commit the defendant to a proper mental health facility or to Bridgewater State Hospital. Periodically, the court reviews the order of commitment. If the defendant is still suffering from mental disease or defect and is still dangerous, then the court will order the defendant to continue to be committed to the mental health facility or to Bridgewater State Hospital. There is no limit to the number of such renewed orders of commitment as long as the defendant continues to be mentally ill and dangerous. If these conditions do continue, the defendant may remain committed for the duration of her life. If at some point the defendant is no longer mentally ill and dangerous, the court will order her discharged from the mental health facility or from Bridgewater State Hospital after a hearing. The district attorney must be notified of any hearing concerning whether the person may be released, and the district attorney may be heard at any such hearing. However, the final decision on whether to recommit or release the defendant is always made by the court. Now, I'm going to go over at this point the specific elements of the charges against Ms. Clancy. So I want to talk first about murder in the first degree. The defendant is charged with 3 separate indictments charging murder, 1 count each relating to Cora Clancy, Dawson Clancy, and Callan Clancy. The instructions I'm going to give now apply to each separate indictment relating to each child. There are 2 different degrees of murder. There's murder in the first degree and there's murder in the second degree. If you find the defendant guilty of murder, you shall decide the degree of murder. The Commonwealth alleges that the defendant committed murder in the first degree on the following theories. First, that it was murder with deliberate premeditation, and then second, and or it was murder with extreme atrocity or cruelty. To find the defendant guilty on any of these theories of murder, you must be unanimous. That is, all of the deliberating jurors must agree that the Commonwealth has met its burden of proving every required element of that theory beyond a reasonable doubt. You should check the appropriate box or boxes on the verdict slip as to each theory of which you agree unanimously. And I'll go over a little bit later the verdict slip and how that is going to be handled. Now, so if you're unable to agree unanimously that the Commonwealth has met its burden to prove beyond a reasonable doubt either of these theories of first-degree murder, you shall consider whether the Commonwealth has proved the defendant guilty beyond a reasonable doubt of murder in the second degree. So I'm going to begin by instructing you on the elements and the additional requirements of proof for each of these theories of murder in the first degree. And then I'll instruct you on murder in the second degree. All right. So number one, I'll first define the elements of murder in the first degree with deliberate premeditation. To prove the defendant guilty of murder in the first degree with deliberate premeditation, the Commonwealth must prove beyond a reasonable doubt the following elements. 1, the defendant caused the death of Cora Clancy, Dawson Clancy, and/or Callan Clancy. 2, the defendant intended to kill Cora Clancy, Dawson Clancy, and/or Callan Clancy. That is, the defendant consciously and purposefully intended to cause Cora Clancy's, Dawson Clancy's, and/or Callan Clancy's death. And 3, that the defendant committed the killing with deliberate premeditation. That is, she decided to kill after a period of reflection. I'll now discuss each of these requirements in more detail. The first element is that the defendant caused the death of Cora, Dawson, and/or Callan Clancy. A defendant's act is the cause of death, where the act in a natural and continuous sequence results in death, and without which death would not have occurred. The second element is that the defendant intended to kill Cora Clancy, Dawson Clancy, and/or Callan Clancy. That is, the defendant consciously and purposefully intended to cause the death. The third element is that the defendant committed the killing with deliberate premeditation. That is, she decided to kill after a period of reflection. Deliberate premeditation does not require any particular length of time of reflection. A decision to kill may be formed over a period of days, hours, or even seconds. The key is the sequence of the thought process. And it would be first, the consideration whether to kill, second, the decision to kill, and third, the killing arising from that decision. There is no deliberate premeditation where the action is taken so quickly that a defendant takes no time to reflect on the action and then to decide to do it. In deciding whether the defendant intended to kill the deceased and whether she formed that intent with deliberate premeditation, you may consider any credible evidence that the defendant suffered from a mental impairment or was affected by her consumption of prescription drugs. A defendant may form the required intent and act with deliberate premeditation even if she suffered from a mental impairment or consumed prescription drugs, but you may consider that evidence. Now, I want to talk about the second theory of first-degree murder, which is murder with extreme atrocity or cruelty. Now, you shall consider this theory of murder in the first degree regardless of whether or not you find that the Commonwealth has proved murder in the first degree with deliberate premeditation, which I just discussed. To prove the defendant guilty of murder with extreme atrocity or cruelty, the Commonwealth must prove the following elements beyond a reasonable doubt. 1, that the defendant caused the death of Cora Clancy, Dawson Clancy, and/or Callan Clancy. Second element, the defendant either A, intended to kill Cora, Dawson, and/or Callan Clancy, B, she intended to cause grievous bodily harm to Cora, Dawson, and/or Callan Clancy, or C, intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. The third element was that the killing was committed with extreme atrocity and cruelty. Extreme atrocity or cruelty, I'm sorry. I'll now discuss each of these requirements in more detail. The first element to this theory is that the defendant caused the death of Cora Clancy, Dawson Clancy, and/or Callan Clancy. A defendant's act is the cause of death, where the act is a natural and continuous sequence, results in death, without which death would not have occurred. The second element is about the defendant's intent, which the Commonwealth must prove in at least one of three ways. These are that the defendant, A, intended to kill Cora, Dawson, and/or Callan Clancy, or B, intended to cause grievous bodily harm to Cora, Dawson, and/or Callan Clancy, or C, intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. As you can see, to this intent element, the Commonwealth satisfies its burden if it proves the defendant's intent beyond a reasonable doubt in any one of those three ways. The first way of proving intent, that the defendant intended to kill, is the same as the second element of murder in the first degree with deliberate premeditation, which I discussed a few minutes ago. The second and third ways of proving intent are different from any element of murder in the first degree with deliberate premeditation. So, the second way is that the defendant intended to cause grievous bodily harm to Cora, Dawson, and/or Callan Clancy. Grievous bodily harm means severe injury to the body. The third way to prove this is that the defendant intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you to understand how to analyze this third way of proving the defendant's intent. You must first determine whether the defendant intended to perform the act that caused the death. So if you find that the defendant intended to perform the act, then you must determine what the defendant herself actually knew about the relevant circumstances at the time she acted. Then you must determine whether under the circumstances known to the defendant, a reasonable person would have known that the act created a plain and strong likelihood that death would result. In deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, you may consider any credible evidence that the defendant suffered from mental impairment or was affected by her consumption of prescription drugs. A defendant may have the requisite intent even if she suffered from a mental impairment or consumed drugs, but you may consider such evidence in determining whether the Commonwealth has proved this element. Now, the third element in this theory is that the killing was committed with extreme atrocity or cruelty. Extreme atrocity means an act that is extremely wicked or brutal, appalling, horrifying, or utterly revolting. Extreme cruelty means that the defendant caused the person's death by a method that surpassed the cruelty inherent in the taking of a human life. You must determine whether the method or means of killing is so shocking as to amount to murder with extreme atrocity or cruelty. The inquiry focuses on the defendant's actions in terms of the manner and means of inflicting death and on the resulting effect on the deceased. In deciding whether the Commonwealth has proved beyond a reasonable doubt that the defendant caused the death with extreme atrocity or cruelty, you must consider the following factors. 1, whether the defendant was indifferent to or took pleasure in the suffering of the deceased. 2, whether the defendant's method or means of killing was reasonably likely to substantially increase or prolong the conscious suffering of the deceased. Or 3, whether the means used by the defendant were excessive and out of proportion to what would be needed to kill a person. In considering whether the means used by the defendant were excessive and out of proportion to what would be needed to kill a person, you may consider A, the extent of the injuries to the deceased, B, the number of blows delivered. C, the manner, degree, and severity of the force used. And D, the nature of the weapon, instrument, or method used. You cannot make a finding of extreme atrocity or cruelty unless it is based on one or more of the factors that I just listed. You may consider the defendant's mental condition at the time of the killing, including any credible evidence of mental impairment or the effect on the defendant of her consumption of prescription drugs in determining whether the Commonwealth has proved beyond a reasonable doubt that the defendant committed the killings with extreme atrocity or cruelty. A defendant may have committed the killing with extreme atrocity or cruelty even if she suffered from a mental impairment or consumed prescription drugs, but you may consider such evidence in determining whether the Commonwealth has proved this element. Now I want to talk about murder in the second degree. In order to prove murder in the second degree, the Commonwealth must prove the following elements. 1, that the defendant caused the death of Cora Clancy, Dawson Clancy, and/or Callan Clancy. 2, that the defendant, A, intended to kill Cora Clancy, Dawson Clancy, and/or Callan Clancy, or B, intended to cause grievous bodily harm to Cora Clancy, Dawson Clancy, and/or Callan Clancy, or C, intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. The requirements of proof for murder in the second degree are the same as for murder in the first degree with extreme atrocity or cruelty, but without the element that the killing was committed with extreme atrocity. All right? And I discussed those elements earlier when I discussed the charge or the theory of first-degree murder committed with extreme atrocity or cruelty. So they're listed in that other section. All right, now, I want to talk about manslaughter. If you find that the Commonwealth has not proven the charges of first-degree or second-degree murder, you shall consider the lesser offense of manslaughter. Now, manslaughter is an unlawful killing unintentionally caused by wanton or reckless conduct. Wanton or reckless conduct is intentional conduct that creates a high degree of likelihood that substantial harm will result to another person. An omission or failure to act may constitute wanton or reckless conduct only where the defendant has a duty to act. To prove that the defendant is guilty of manslaughter because of wanton or reckless conduct, the Commonwealth must prove the following elements beyond a reasonable doubt. 1, that the defendant caused the death of Cora, Dawson, and/or Callan Clancy. 2, that the defendant intended the conduct that caused the death of Cora, Dawson, and/or Callan Clancy. And 3, that the defendant's conduct was wanton or reckless. I'll now discuss each element in more detail. The first element is that the defendant caused the death of Cora, Dawson, and/or Callan Clancy. As I've said before, the defendant's act is the cause of death, where the act in a natural and continuous sequence results in death, and without which death would not have occurred. The second element is that the defendant intended the conduct that caused the death. The Commonwealth is not required to prove that the defendant intended to cause the death. And the third element is that the defendant's conduct was wanton or reckless. Wanton or reckless conduct is conduct that creates a high degree of likelihood that substantial harm will result to another. It is conduct involving a grave risk of harm to another that a person undertakes with indifference to or disregard the consequences of such conduct. If the defendant realized the grave risk created by her conduct, her subsequent act amounts to wanton or reckless conduct, whether or not a reasonable person would have realized the risk of grave danger. Even if the defendant did not realize the grave risk of harm to another, however, the act constitutes wanton or reckless conduct if a reasonable person, knowing what the defendant knew, would have realized that the act posed a risk of grave danger to another. It is not enough for the Commonwealth to prove the defendant acted negligently, that is, in a manner that reasonably careful persons would not have acted. the Commonwealth must prove that the defendant's actions went beyond negligence and amounted to wanton or reckless conduct, as I've defined that term. So in deciding whether the defendant knew or should have known her conduct created a high degree of likelihood that substantial harm would result to another, you may consider any credible evidence that the defendant suffered from a mental impairment or was affected by her consumption of prescription drugs. A defendant may have the requisite knowledge even if she suffered from a mental impairment or consumed prescription drugs, but you may consider such evidence in determining whether the Commonwealth has proved this element. All right. So that's my instructions on the specific elements of the charges in this case. So at this point, I'm going to ask the attorneys to deliver their closing arguments. I just want to remind you, as important as they are, the closing arguments are not evidence. All right, and I'll go over that a little bit later, but I just wanted to remind you of that. And so after we go through the closing arguments, I'll come back and give you the balance of my instructions on the law. All right, and so, counsel?
About 5 weeks ago that we met like this, and I indicated to you that thank you for incredible service. That, all of us mean that sincerely. You took literally more than a month out of your lives and sat here attentively, incredible, through some of the toughest, most gut-wrenching things that any person can be subjected to, and I indicated that, sadly, jurors carry this trauma with them for years. And the service that you have performed, I have never seen before. You have listened to evidence. You have been fair. You have been objective. You've listened to the judge's instructions, and you've carried them into your heart, consistent with your oath, which is a very, very solemn oath. Passed between government and Lindsay, who has placed herself on her country, which country you are, as a jury of her peers. When you consider what's at stake here in the sense of what we've been dealing with, Cora, Dawson, Callan. She knows loss. And that's why we think of Cora, Dawson, Callan. For a minute. They are the victims of this case. They are the victims of the horrible, horrific act that has been laid at your feet as jurors to decide whether or not Lindsay is guilty. Beyond a reasonable doubt, as His Honor instructed you and will instruct you, what that means, that standard of proof that we as citizens in this country are so blessed to have, proof beyond a reasonable doubt before the government charges any citizen with a crime. I don't care how many cops you have in here, how many DAs are sitting here, how many people are sitting in the front row, and they're all going to sit there and be proud of this prosecution. I told you in the opening statement that this is a prosecution that has ripped the soul out of this girl. This is what they had. This is their family. How does this turn into this? How? Because of the damn medicine and the lousy medical care that she got. You can troop as many paid experts as you want to come in here and tell the jury, oh, well, she didn't say that she heard voices inside her head. She said she heard voices from outside her head. She said she was making chicken McNuggets. There was a bowl on the sofa. She wasn't making chicken McNuggets. She said something. As I think and I muse and I try real hard to tell you what my opinion is, that this woman was acting in her right mind when these children were killed. So, when you consider the evidence in this case, you consider the person who is in front of you, who is the defendant, as the government refers to her, and as His Honor will than likely tell you, even though a person is a defendant in our system of justice, you don't have to defend against anything. The government has the burden of proof. When the DA decides to charge someone with a crime, he has the burden of proof. His assistants have the burden of proof to prove, number one, that Lindsay is guilty of this offense beyond a reasonable doubt, and then prove, number two, that Lindsay, at the time, killed her children, was not suffering from a mental disease or defect that caused her to have a lack of substantial capacity to appreciate, to know, to realize that what was being done while she was in a psychosis. But we'll laugh about that. It's just another woman. I guess it's just going to make an excuse. She's depressed. GAD, general anxiety. Give her a couple of pills, she'll be all right. You know from looking at the objective evidence in this case, this young lady, believe me, I don't have many clients like that. This young lady did nothing wrong in her life. She was a nurse, a daughter, a wife, and a darn good mother. You can see from the objective evidence, you can see, and you'll have all the exhibits for you to look at, and you can see by looking at these photographs, which you will have in the jury room. You can see the Facebook postings. You can see what she indicates about, for example, I just randomly grabbed this one, a son, my prince, that they would have you think she killed him first, cruelly, because she didn't like him. That is repulsive. So she's living real life with Pat, her kids, having a great time that summer. Life is good. She had to go back to work. In an opening statement, I told you, I said, watch the evidence. Watch the manipulation. Because that's what this case was built upon originally, and how it developed as the case progressed until it's in front of you. And how does that happen? Well, in the very beginning, going all the way back to when the first 911 call that you had to suffer through was made, you could hear in the voice, Pat Clancy, the horror, what he had obviously experienced. You can see from the evidence that's before you the injuries that she suffered. You will have in the jury room the exhibits that indicated the extent of the injuries from, I don't have to go through all of them, the extent of the injuries to slitting her throat, to slashing her wrists, throwing herself out a window, blood all over the bedroom floor, window open, screen slashed. Oh no, the screen wasn't slashed, my bad. That's what she thought. It's called a delusion. She was in a psychosis when she thought that. Probably right here, sitting here, believes that she slashed the screen. She didn't. It's objective evidence. And why did we spend almost a week showing you the extent and the severity of that suicide attempt? The reason that we had to do that is because they were arguing that it was a fake suicide. Dinky little cuts, no bleeding. She didn't mean to kill herself. She's going to throw herself out the window, I guess, and slide down the house. Remember that one? Hanging off of the window. Sliding down the house, and Lindsay screwed up. And she hurt herself bad. You know that's not what happened. You know that she made, the testimony of Dr. Velkovich, that she made a very, very significant suicide effort, slashing her wrist, slitting her throat. And isn't it interesting when you consider objective evidence? Googling slitting a throat. Googling suicide. Googling drugs. Googling side effects. Googling ketamine treatments. Googling all of these drugs. Googling the effects of Tufts medications. Lorazepam, sertraline, hydroxyzine, lorazepam, buspirone, trazodone, fluoxetine, zolpidem, myrtazine, clonazepam, quetiapine, diazepam, quetiapine. It goes on and on and on and on and on. You have the chat, you have the descriptions to see. And obviously, she wasn't consuming all of these at the same time, because one thing this kid did was try to do what she was supposed to do. She took the drugs as she was told to take them. She was religious in her obligations to take care of her health. She went to Dr. Tufts when she was a young lady living in a house with a husband and her babies, respected nurse, wife, friend, mother. Should have kept drinking, huh? That was a big deal, wasn't it? Remember that? We're just going to assassinate this young lady in every which way we can. Remember that evidence? I was concerned. She was drinking 5 drinks a day. She was worried about, you heard the evidence up to 2019. What are they talking about? She wasn't drinking while she had her kids. She wasn't drinking while she's breastfeeding. She would have a couple of beers with her friends. That's bad. Put that over in the bad pile. Right here. We spent all that time showing through Dr. Lapasada's testimony that this was a legitimate, dreadful, horrific suicide attempt. You think about this beautiful young girl throwing herself out a window. That's a quarter. I don't know if you ever played pool. I challenge you to tell this jury why we spent a week showing that she committed, your witnesses.
Counsel, address the jury, please.
Said, their witnesses, serious suicide attempt. Remember that? Tried to kill herself. So now they'll back off on that, and they'll agree. A serious suicide attempt. That's why I say, watch the evidence. Watch the manipulation. Remember the argument with the bands. She took the bands out of the bag, put the gloves on, talks to Dr. Laposada on the Zoom, slams the bands down out of the paper bag, does the movement of the bands and yells at Laposada and says, wrapped. They were just wrapped. They weren't knotted because you gotta get Lindsay tightening the band, right? You gotta hold it. You gotta hold it for a minute. You gotta hold it for 2 minutes, 3 minutes, 4 minutes. That's why she needed the bands not knotted. And then she said, it's like this. And they sprang open. Remember that? Dr. Laposada said, yeah, I saw what you did. And she walked away like if the glove won't fit moment. Quarter number 2. What did Patrick Clancy testify to? You heard his testimony. He indicated clearly, unequivocally, they were knotted around the necks of those children, to the point where he had to struggle. And it's your memory, not mine. If I say something you don't recall, forget it. It's what you remember the evidence to be. But clearly, I would suggest, he struggled to get it off of Dawson's over his head. And a police officer saw through the window. This is horrific stuff. But it's objective. And it shows the manipulation. This government, this prosecution is a mess. They would take their evidence and argue to you that she did not tie a knot and walk away, because as Dr. Laposada said, you're talking about 4 or 5 seconds, so somebody passes out. No, they got to have the 4 minutes, and that's not what the evidence shows, is it? So, as we move on, Lindsay's in the hospital. And this whole thing about conversations, and she's talking to people, and the kids are in the basement, her throat was crushed. You heard the 911 team. You draw the inference, whether or not there's a conversation about where the children are. I tried to kill myself, the kids are in the basement, all that. You determine whether or not that was something that could be discerned. And the police investigation, because as His Honor indicates, there are two things here. Number one, proof beyond a reasonable doubt that she's guilty, and number two, proof beyond a reasonable doubt that she was not suffering from a disease or defect, as His Honor instructed you at the time of these killings. Those are the two things they have to prove. And when the police charge somebody with a criminal offense, they have an obligation to investigate. At the end of the day, when you're talking about, well, we've got the charges are before the court, you can sit there in the court, you can feel proud of yourself. Did you do a good investigation? Do you even know what this, you'll see the photograph of the cup and the powder. What is it? They don't even analyze it. Did they take pictures? Did they analyze? Did they test the blood? Lousy investigation of this. Well, that's okay, because she was guilty, and they put her in the hospital, and she's the evil woman that killed the 3 innocent kids. And they're going to stand there while she's chained to the bed, paralyzed. You heard testimony from Dr. Zeisel. They weren't little fluffy cuffs that were securing her to the bed. They were handcuffs, not the medical treatment. Medical treatment would be, like restraints, so you don't do whatever, pull lines out and things. We're talking about when the big men were in there with their guns and their badges, and they're sitting outside the door, and they're going to make sure that Lindsay Clancy, paralyzed, chained to the bed, doesn't get up and run away from the hospital, I guess, and they just have to suffer their way through. I guess I worked 8 hours, I had another shift I had to work that night. This is the treatment. And what's important about that is what kind of treatment did this young lady get from the healthcare providers. Remember Meg Collins? She came in this court, Meg, you might remember. Tall woman, short blonde hair, squared away. Unbelievable. Unbelievable. She was not only a nurse taking care of her in the hospital, she advocated for her. She stood up for her patient. She protected her. During the pandemic, you know that Meg Collins was in that emergency room when half of us were hiding at home behind our computers, hoping that we're not going to die in a week, drinking our Chardonnay at 11 o'clock in the morning. Meg Collins was in a hospital treating people and advocating for them. That's an example of what nursing is all about. Not having attitude, not treating somebody like they're to be disdained. And what's even worse, she comes out of a coma. She is intubated. She has had major surgery of her broken, crushed spine, vertebrae, rib, thyroid. Massive, not my words, medical records, massive testimony, blood transfusion for the blood loss. And when someone, you've heard evidence, comes out of surgery, they are delusional. You've had anesthesia. You've had think about having your tooth pulled. Think about the trauma that somebody has when they're in a hospital bed laying there, paralyzed, unable to feel the lower half of their body, but able to feel with the meds and the pain medication and everything else, the damage to the spine. And then the hospital has a meeting. Remember the other doctor, I think it was Dr. Shah, the Indian woman? Wicked impressive. She was amazing. She had the facts. She was able to tell you exactly what she observed. She was able to tell you what they were doing to treat Lindsay. She treated her like a human being. She was a damn good doctor. Came in here and told you all of her observations about her and told you one of the things that ultimately that they were concerned about is they had to have this big confabulation about, we're going to take her off the, the healthcare process. They had to have lawyers. They had to have people there. They had to have her signing documents. They had to determine whether or not she was going to be signing something to have her parents take over because Pat was not going to be responsible for her care. Lawyers, cops, handcuffs. Do I need a lawyer? Write that down. Where are you? You're out there somewhere. Write that down. Boy, she wanted a lawyer. That's a bad thing. Must be guilty. Let's put that in the guilty pile. That's why she said that, in a delirious state, dealing with all of these people about that issue. But what's even more nefarious, you think about it, as I said, your eye on the ball because of the manipulation. Paul Zeisel, big deal. I'm friends with the guy. You heard evidence that I called him. I was with Pat a night or two after this incident in the bedroom with all the blood. I was with Pat taking evidence that the police didn't even see in their thorough investigation. And I was able, as you know now, certainly, to grab this. Why wouldn't the police have grabbed this? They're all empty. You can see when they were prescribed. You can see what they are. You can see what she took. You heard the testimony. It's tough to take a handful of pills. Remember the guy saying that yesterday? Tough to take a handful of pills. Well, no. They were crushed. Oh, shit, they were crushed. Okay. Where's the residue? Where's the crusher? Where's anything? Doesn't matter. Doesn't matter. Great investigation, guys. So you have a situation where they leave this behind. They don't even look at it. One of them, and again, your memory not mine, one of them testifies, well, they might have looked at it and saw it and just didn't seize it. Seriously? They go down to the kitchen, they seized every pill bottle that was in the cabinet, along with the books. And speaking of books, one of the things that they found, smoking gun. Good moms have scary thoughts. Hallelujah. Put that in the guilty pile. We're going to put this in a plastic bag. We're going to show it to a jury so they know that this young lady had scary thoughts. Turns out that Jolada gave it to her. So you have this evidence. You have evidence of sleep aids. You have evidence in the bag. Because obviously this stuff was just thrown in there. It wasn't in a bag when I saw it inside this thing here, and we seized it. And we held it for 3.5 years. Anybody care about it? No. You had evidence that the police knew that I had it. They could have it, they could look at it, they could analyze it, do whatever they wanted. They didn't have to. This here, you heard evidence. This is a little wish jar that they bought on their honeymoon in Hawaii many years prior to even having kids. And when you look inside it, you see that there's all sorts of little folded up pieces of paper. Some of them are dated, some of them aren't. They go all the way back to 2017, 2018, 20. And they reference her wishes to have healthy kids, her wishes for her kids to be successful, her wishes to have a good birth. Second time around, hoping for a good birth, worrying about the child with the, what do you call it, I forget, where they rub the thing like. This woman lived for her kids until she had the pleasure running into Dr. Tufts of her 2 months experience. And after she ran into Dr. Tufts, it was not a wonderful life anymore. And what did Dr. Tufts do? And everybody laughs at me. I said the television. Okay, I know it's a telemedical thing on your telephone or on a Zoom. Take more pills. You have the medical records. You heard the testimony. You know her concerns. You know her fears. Does this seem like a young lady that didn't care and wanted to score more drugs off somebody? That's another repulsive allegation. I think the evidence is pretty clear. There's no basis for that at all. She was scared. September into October of 22, young, vibrant, hardworking, you've heard all this, not my words, witnesses' words, holding goals for herself. Hardworking nurse, hardworking mother, would take the kids to the Kingsbury Club. That's another thing. Sounds pretty snooty, doesn't it? Oh, they're at the Kingsbury Club. It's a swimming pool and a place where you can exercise. Watch the manipulation. Because now you've got a situation where you've got manipulation with the Kingsbury Club, you've got manipulation with these other items here, and you've also got manipulation of Paul Zeisel told Lindsay what to say. Say that you're hearing voices. Think about how ugly that is. Because you know, beyond a reasonable doubt, even though we don't have any proof, we have no burden. You heard from Sheila. Remember Sheila, the woman that's the reverend or whatever, she's the chaplain at the Brigham and Women's Hospital. She didn't know Lindsay from anybody that night when she came in all broken up. And she told you that she continued. She was there when Lindsay came out of, was extubated. She was there when Lindsay was going through her treatments. She was there for 8 days before Paul Zeisel even knew Lindsay existed. But they would be in here telling you that Lindsay saw the psychologist because the lawyer went and got the psychologist to go and speak to her. And then you have these guys here, the cops. They're having meetings, talking about it. They're talking about it. Must have been the shrink. Must have been the psychologist. Must have been Zeisel. He's the guy that told her what to say, and he did not. How can you ruin a man's reputation with the career that he has had and still has, thankfully, to put him in a position where he tells a broken young woman who is vilified by our society for killing her 3 children, that he goes in the hospital and tells her to say she heard voices? Disgusting. So now you know that she told Sheila first that she heard voices. Command hallucinations. She didn't say command hallucinations. I heard voices. It was a male voice. Told me. You had these other guys that came in. The government's rebuttal witnesses. Very, very impressive. Very, very impressive. The first 2. Mac, put him aside. You've got the other doctor as well. So Mac is, why he was freaked out when I asked him where he stayed. And the other guy looked at me like his eyes were bugging. Why did I ask where he stayed? Whatever. Point is, they don't see her for years. Years. And why? The other guy, Halburn, I think it was Halburn, he had to wait until maybe it was the last man, I forget. They had to process his payment from the DA's office through the school. Who cares? If you have an obligation to try and be objective, to try and even look as though you're competent and objective, why would you wait for so long? Why would you go with another guy? Why would you take this young lady and have her in a room and question her, one right after the other? Wouldn't you like to sit there and be questioned by Dr. Mack? Boy, that'd be an experience for 3 hours, 4 hours. And the other guy is going to pepper his questions at her as well between that period. And the next day, she can take tests. And then go back at it again with Mack and with Halbrun. And she was cooperative. She was pleasant. She was friendly. She answered the questions, and she owned what she did. Huh? She never ran from anything. She's gone through evaluation after evaluation after evaluation, recorded. You'll have the video to look at as they're questioning her, as she's sitting there in her wheelchair, hour after hour after hour, 3 years after this incident, but that's okay. They're busy. Paul Zeisel was there, literally, in Brigham and Women's, because I called him. Because I was asked to represent this young lady. You heard evidence. I saw her in the hospital. I saw her laying in the bed broken. I saw her laying in the bed practically dead. I reached out to Dr. Zeisel. And I asked him, please, can you talk to this woman? Concerned, as he testified, for her mental well-being. What kind of demons, what kind of horror was in her mind as she lay there paralyzed and hurting and medicated, swollen, tubes, pops, chains. He went and talked to her. Big deal. I asked him to go. You judge the credibility of a person. Did Paul Zeisel have the ring of truth when he told you that he's there out of humane feeling to try to help this young lady? And he's been by her side for 3.5 years. Same thing as Sheila. Why would Sheila, for all this time, visit with Lindsay as she testified at the Tewksbury Hospital? She's not getting paid. She's not a hired gun. She's not somebody that's coming in to say something at my request. She loves Lindsay. He's a good kid. He's a beautiful soul. So you have Zeisel that has been with her all that time. You've got Sheila, who's been with her all that time. You've got evidence that her mom and dad, who lived in Connecticut, come up and they stay and they visit with her, and that they sit with her, and God forbid they actually sometimes had dinner. Remember that? They got the Tewksbury records. Boy, there's a good score. Let's go through the Tewksbury records and see what she's doing on the anniversary of the deaths. How about on their birthdays? Can you see them sitting there going through the medical records? Okay, doctor, what did she do then? She propelled herself down the hallway, met with her parents, laughed, had dinner, watched TV, talked on the telephone. God forbid. She's not curled up in the fetal position, wailing, self-flagellating constantly. For 3.5 years, she's acting like a human being trying to exist. But they go through the records and they want to get those dates and use them against her. Manipulation. And then you consider we're 3 weeks away from a trial. And the guy yesterday that's looking up to the heavens while he's testifying, Caesar, tells you that he wanted to establish a rapport. Can you imagine? You know that you're 3 weeks away from your murder trial, and you know that this is doctor number 3 who's been hired by the government to come in and evaluate you and testify against you, and he's going to establish a rapport. There is no rapport, but yet she was cooperative, she was friendly. Interestingly enough, just like the treating doctors don't talk to each other, they don't communicate with each other, they don't have access to medical records. She signs the HIPAA forms. They don't know what her records are, but they know for sure what Dr. Resnick had in his report. They know for sure what Dr. Zeisel had in his report. They know for sure what Meg Spinelli had in her report, and they incorporate that into their report. But then you have the MMPI and the other psychological tests that were administered to her on the second day of the Mac Heilbrunn team interviewing, interrogating, questioning her. She passes the MMPI. Testimony is presented. She answered the MMPI honestly. And they're pertaining to state of mind. They're pertaining to questions about what occurred. They're questioning this young lady as to what her state of mind was then, in the middle, and now. And she didn't lie. She didn't malinga. She didn't exaggerate, and more importantly, if anything, she minimizes. But she certainly was off the chart on the suicide scale. And then you have testimony from Dr. Resnick, Dr. Zeisel, Dr. Condon. And they were paid for their testimony. We're all paid, like I said, not the jury so much, but the judge, myself, Chrissy, everybody gets paid. These doctors came in and testified. Phil Resnick, the man is something out of a scary movie. He has the world record of investigating, examining, and treating people in psychosis that kill their children, filicide. He has a world-renowned record for checking fakers to see if a person is malingering. Their doctor agreed that his article on Voices is a leading article with research in the world. Their doctor agreed that he, Bill Resnick, is an expert on malingering. You heard him testify by Zoom because he had surgery. But he showed up by Zoom and testified that, again, 4 months after this incident, he met with Lindsay, he evaluated Lindsay, compared, looked at all the records, just like all the rest of them, everyone says. They looked at all the records, the police reports, grand jury minutes, everything else. He indicates clearly, in his opinion, that she was in a state of psychosis at the time of this death times 3. Has any of the government doctors rebutted that? One of them, Halburn, said it's possible either way. That's not proof beyond a reasonable doubt. The other one, Mac, you can accept his testimony if you wish, but I suggest that you probably won't. And then you're left with the doctor yesterday who didn't even know what killing during the course of the psychosis was. And when I was questioning him about it, he agreed. And I said, don't just agree with me. You're just agreeing with me because I said that? And he basically said, yeah. What kind of expert testimony is this? It's a mess. But the government uses them to try to rebut a man like Phil Resnick, who tells you that she was suffering from a horrific mental disease and defect at the time of the killing of her beautiful children. Why, the how, and the fact that under the law, as His Honor has given you, she's not criminally responsible. And the burden is on them right here. Prove to you that at the time of the killing, as Dr. Resnick says, that she was suffering from a disease or defect, as Dr. Zeisel said, that she was suffering from a disease or defect, as Dr. Condi said, she was suffering from a disease or defect, and Condi took you down the road of all of these medications as a psychopharmacologist, as a doctor that specializes in prescription medications. And you got the evidence, so you're able to look at that and determine, see what the side effects are, what she was complaining of, and look at her records. I mean, they have really turned her inside out. I mean, they've got every single text, every single email, every single picture, everything that she did in college. Oh, that's another thing. She lied, according to the guy yesterday that testified, she lied to Pat about being on Prozac. They were dating for 3 months. She's living in Boston. She meets this kid. She thinks that she might like him, and they're dating. Oh, excuse me, before you go out with me, let me tell you that about a year ago when I was studying for my exams, because I'm nervous about talking in public, I got on Prozac. Seriously? That's what the government is arguing in this case. You're going to have this journal, which talks about her being, this is how controlling she was, manipulation. In the opening statement, you may recall that the district attorney said that she was a hard-charging, manipulating woman that was controlling, and everything in their life was controlled, and she ran it to the water, to the carrots, to the beets. You look in this book, and as you might recall, Ms. Rossi testified when asked, did you feel that she was being controlling of you? Because she says, for example, Monday, 10:24, Callan, put down for a nap. Hopefully we'll nap for 2 hours. If he wakes shortly, let him resettle himself. Bottle when he wakes up. Then it goes on and on. Make salad, romaine lettuce. He likes peppers, broccoli. Cut the sweet potatoes in chunks. Thank you, with the heart. Another good score. You look at her journals that she took. You'll see, as you go along, in the dates that she's recording in these journals, she's talking about the drugs that she was prescribed. And look at the first page. Look at how detailed. Dates, how she felt, 10 milligrams Prozac, and it goes on like that, goes on through November into December. December 9th, 10th, 11th. Horrible, intrusive thoughts. Horrible thoughts in the AM. Horrible thoughts. Horrible thoughts. No motivation. And then finally, horrible thoughts, no motivation, deeply depressed. Then, that's around the time she went to Women and Infants Hospital, right? Looking for help. Look at this. As she runs into January, there's nothing other than little chicken scratches because her mind was gone. In January, as she's on these drugs and she's suffering from what you've heard is postpartum depression, that can lead to postpartum psychosis, and you have these men coming in here that don't even know psychosis from schizophrenia as experts, telling you that if a woman doesn't have these symptoms, like it's a disease, symptoms of postpartum depression within 4 weeks, that's it. Lights out. You're not a person that can be considered. You're not a real person for purposes of postpartum depression and or postpartum psychosis. Well, I suggest that he's wrong. I suggest the second guy's wrong and the third guy. Well, actually, I don't even know. It's your memory. If the gentleman, Mac, even knew, I think he said 4 weeks. It can go up to a year or longer. But we don't really know because you heard the evidence. There's no evidence. There's nothing in the DSM, but that's the Bible. God forbid you should go to Europe. You should look at the World Health Organization records. You should look at the way they treat pregnant women that have problems with their children. No, we're the most advanced country in the world. But we still have doctors that come into court on a murder trial and talk about 4-week cutoff on something that they don't even know exists. They've never treated it. They've never written about it. You have terrorism experts. You have an expert that comes in and talks about his focus and his interests, and it's about juveniles and drugs, and like I said, kids that like to drink and smoke weed. Those are the experts, quote unquote, to support their burden to prove beyond a reasonable doubt that Lindsay was not suffering from a disease or defect at the time she killed her children. You all remember this. October. This is not an evidence, it's marked for identification. It's too big, so. But basically it shows clearly and unequivocally the depths of despair that this young kid was in, trying to raise 3 kids, trying to be a wife, ready to go back to work. Did anyone say that she was just lazy or just didn't want to go back to work? Manipulation. They're arguing. She didn't want to go back to work. She didn't want to go back to work because she didn't want to leave her kids, especially Callan, because she loved her children. They were her life. Manipulation. And when you consider the journals, I don't know, you ever watched the movie there, The Shining, with Jack Nicholson? Remember the scene when he's sitting there in a state of complete psychosis, and he's writing a book and he's typing, and the wife finds the book and opens it up and looks at it and says, all work and no play makes Jack a dull boy. All work and no play makes Jack a dull boy. Repeated after repeated after repeated. And he says, do you like it? You look at the records of her Googling drugs. You look at how many times, how many hours of the night in the afternoon she's looking this stuff up, in between taking care of the family, in between all of the stuff that was going on with visiting doctors, seeing doctors, going to Rhode Island, being told, no, we can't help you, calling a suicide hotline, we can't help you, calling another suicide hotline, we can't help you. My God, what does she have to do? She was reaching out for help, and she was not getting it. She turns herself in to McLean Hospital. You saw the doctor, nice woman. She's testifying. She didn't know. I suggest to you that she didn't know hardly anything, let alone psychosis involving a young lady like her going through what she was going through. The government bears the burden of proof beyond a reasonable doubt. They bring, for example, Ian Whiffen. The guy, you might remember him, was the guy that's, I guess he developed or helped develop Celebrate. What you got when you look at the records, you don't measure on an Apple Watch. Well, I shouldn't say Apple Watch because we know that they didn't have the Apple Watch, but on a cell phone. You don't measure going down the stairs. You measure stair climbing, right? That's what the testimony was. And there were 3 stairs that were climbed. Okay. The last record is 5:38. At 5:38 p.m., we went through that on cross. What happens to the phone? Don't know. It was on the bed. Was it dropped on the bed and it left there for 20 minutes? She could have been anywhere in the house during all that period of time, right? Right. You've got a compressed period of time that Patrick leaves to go to the restaurant to pick up the CV, and you heard the guy yesterday say, and then she sent him off to go to CVS. It's on the way. It's on the way. She didn't want him out of the house long. She was in distress. She wanted him home to help with the bathing, to help with the kids, to help putting them to bed. How long is he going to be gone? She Googles it. Is that something that is so nefarious? You think that goes right along the line with the book about good mothers having bad thoughts. My God, she actually Googled the time frame that Patrick would take to go to 3B and pick up the food and then leave, and stop at CVS on the way. So I guess the government is suggesting she's not in a psychosis. So she's Googling Miralax because the doctor earlier that day told her that the baby Cora needed Miralax. Why would she do that? Because remember the government's opening when they told you she wasn't suffering from the psychosis. She was a woman that didn't want to live a life anymore, wasn't happy being a mother, didn't want to live that life. So she's going to kill her kids and hopefully throw herself out the window and not paralyze herself, and then she could run off into the sunset, I guess. That's what their theory was. Along with the fact it wasn't a real good suicide, it was fake. Well, now we know, don't we? The mess that this young lady was in her brain, my brain is being damaged. I will never be better. That's the evidence. That's the evidence that we have in this case. Burden of proof is on them to prove to you that at the time that she killed these 3 beautiful kids, that she just wanted to move on with her life. And I suggest to you, just as there's no chicken nugget residue, and then when you look at those photographs, there's a slice of a cucumber, there's a slice of a carrot, there's no chicken nuggets in that bowl. Patrick wouldn't know what the kids were eating. She was the one that would cook their dinner. She was in the refrigerator, but the guy yesterday is like, oh no. Patrick said that the child was eating the chicken McNuggets in the bowl. No, she was getting food out for the 2 kids, not the little baby, 2 kids for dinner. There's no evidence that she's lying. There's no evidence that she's malingering. And finally, remember, there was a big deal about whether or not the voices are within the head or whether or not they're outside of the head. Dr. Resnick's article with the largest research on voices malingering in the world indicates that 38% of almost 1,000 people that were examined report voices from inside their head, and it stops. You're going to buy that guy yesterday? He doesn't know what he's talking about. This young lady is not guilty of the killing of her children because she was suffering from a disease and defect, as His Honor instructed you. And they're not going to be able to prove otherwise. And it's their burden, not ours. Thank you.
All right, Como.
There's no dispute that Lindsay Clancy was suffering from mental illness and that she tried to kill herself. There's no dispute about that. All of the evidence that you've heard, even the experts that the Commonwealth put before you, say that she was suffering from mental illness and she tried to kill herself. That's not the issue in this trial. The issue is whether, at the time she killed Cora, Dawson, and Callan, she knew the difference between right and wrong, and whether she could conform her behavior to the requirements of the law. This case is not about our mental health system or how it treats women or what's in the DSM-5 and what's not. That's a distraction to get you angry and passionate about an important issue, but an issue that's not on trial here. what's on trial here, what the issue is here, is what Lindsay Clancy did the night of January 24th, 2023, and what her mental state was at the time. And you can use her psychological history and records, the treatment records, to look at both before and after she killed the kids, to look at how she got to that point, what her thought process was, what her motivation was. But it's not the system or the DSM or any of that that caused her to strangle her kids. In fact, she had more access to treatment and care and support than a lot of people do. She had health insurance that covered multiple doctors, multiple specialty programs, treatment at South Shore, at Mass General, her stay at McLean. She had prescription coverage to cover the different trials she went through. She had support at home. She had 18 weeks of maternity leave with the opportunity to extend that as much as she needed, which is excellent, which is what all women should have. But she had that. She had support from both sides of her family, hers and Patrick's. The two older kids, Cora and Dawson, were in preschool 3.5 days a week. And she had the nanny, Elaine, who helped with Callan 3 mornings a week. And she also helped her with housework and with food prep. This wasn't a woman suffering from a lack of care, a lack of resources. She had an abundance of help, an abundance of care. She had all of that and more. And, you know, this doesn't mean that she wasn't struggling, that she wasn't dealing with mental health issues. She was. She had depression. And whether that's from bipolar or major depressive disorder or postpartum depression, it all boils down to she was depressed, right? And she was trying to deal with that, trying to get help for that. But it wasn't the fault of the providers that she was struggling with this or that she wasn't getting better. They were doing the best they could. You have the records, you heard the testimony. They were doing the best they could with the information she provided them. And that wasn't always accurate information. That wasn't always the full picture. And they were doing the best they could with her level of cooperation and compliance with the plan. Take her medications. You know from the records and from the pill bottles what she was prescribed and how she was supposed to take those medications. And you know from the pill bottles what she actually took. And sometimes those two things didn't align with what she told her providers, what she told Patrick, what she told her mother. You take the Zoloft, for example. The prescription was for 1 25 milligram pill a day for 7 days, and then to go up to the 50 milligrams after 7 days. She told Dr. Tufts that she took the pills as prescribed for 7 days, went up on the 8th day to 50 milligrams, and that's when she had the insomnia and the other side effects and symptoms. She told Patrick that she took the pills for 7 days and they had no effect, so she called Dr. Tufts, who then told her to increase the dose. Well, you know what she told Patrick is not accurate because the pill bottle says, take it for a week and then increase it. That was the plan from the beginning. That wasn't the result of a phone call to Dr. Tufts. And you know what she told Dr. Tufts isn't accurate either because only 7 pills were taken from the bottle. So that leaves you 2 options. Either she took the medication as prescribed, 1 pill a day for 7 days, and then didn't increase it, which she says is what caused the side effects and the insomnia, or what she did was not take it as prescribed. She didn't do it 7 days and ease into it and then increase it. She either missed a dose or increased it early before she was supposed to. Either scenario is not good. She knows as a nurse the importance of following the instructions of your medications. She knows how important it is to follow the plan and do what's on the bottle and do what your provider tells you and to give that accurate information to your provider. She didn't say, I went up to 50 too early. Maybe they could have adjusted that and tried the 25 milligram for longer and eased her into it. But no, she told her that she did what she was told and then went up and had these problems. So You can see that in a lot of the medication she has. You have the pill bottles that were turned in by Patrick, and a lot of them don't even have many pills missing from the bottles. Some of them have none. The Buspar prescription, the first one, there's only 2 pills missing. The second prescription, no pills missing. The Lamictal, she never took those pills at all until the night she tried to kill herself. So there's a lack of compliance there, a lack of follow-through, a lack of communication with her providers about what was happening with her and how she was taking the medications. And defense wants you to believe that this is a woman who's begging for help and willing to do anything and everything her providers tell her to do to get better. And she was asking for help. She wanted help. She wanted to get better. But she wanted to get better on her own terms, doing things her way, the way she thought she should do them. And as a nurse, she knew that's not the right way to approach it. She knew that an accurate medical history, accurate information about your side effects and symptoms, what your thoughts are, that's important for your providers to know. And she didn't do it. And it seems that the reason that she's not necessarily fully compliant and she's doing what she wants to do is she has this desire to be herself again. She just wants to go back to who she was. And she wants it now. And she doesn't want any side effects. She just wants to be herself again and wants it now. And that's understandable. That's relatable, to want to get that magic pill that will fix you immediately and you can go back to being yourself. But she knew that's not how it worked. And you know that's what she was thinking, because in the searches on her phone, she's searching for things like, which antidepressant works the fastest? How fast does Wellbutrin work? And she's searching all of these different medications for the side effects and symptoms, some of them that she never even discusses with her doctors. And, again, it's relatable that she wants to get back to where she was, but she had discussions with her providers about how these medications work and that it takes time for them to get into your system and it takes time for them to work. She even texted her mother about that, about how she knew that she had to be patient, that it took weeks for the amitriptyline, for example, to get into her system and worked. And she knew all of this, and she couldn't be patient. She couldn't wait. She wanted faster. She even told Dr. Tufts, it's a note in the records, that she knew the problem was that she wasn't focusing on one provider and following one plan. She knew that going from doctor to doctor, practice to practice, South Shore to MGH, to different programs, not the best way to deal with the situation. She said it in her own words to Dr. Tufts, I need to stick with one provider and stick with one plan to see if it works. And she actually turned down help from at least 2 locations at various points. We talked a lot about the women and infants records, and you don't have to believe what I say about them or the witnesses say about them or defense. You can look at the records themselves. Page 9, it says right there, Patrick was the one who said over-medication was the issue. Not the doctors there, not the people evaluating her. What they put was depression, RO, rule out adverse medication effects. That means they have to look into it to see if medication's a problem. But there's a difference between an adverse effect, a symptom, or a problem with a medication, and being over-medicated, taking too much of a medication or taking too many at one time. There's a difference there. And women and infants never says she was over-medicated. What they also don't do is turn her away. It's not that she went there and they said, can't help you, go away. They told her, it's in the records, based on the onset of her symptoms, they weren't sure if it was postpartum or peripartum. They saw she had an issue. They wanted to help her. It says there, we offered her. They offered her 3 programs. They offered her the inpatient medical management program. They offered her a partial hospitalization program for general mental health. And they offered her an outpatient program. It shows they put a lot of thought into that, into offering her this care. When they gave her 3 separate options, considering she's a young mom, maybe she doesn't want to be away from home, but we'll give her the option of being in the hospital and getting her medications right. But we'll also give her the option of the partial hospitalization, where she can, be here during the day and go home to her kids in the evening. And then that third option of being an outpatient and being able to be at home with her kids and come in for appointments. It was very thoughtful of them. It was very well planned out to give her these 3 options. And it's kind of the exact opposite of just turning someone away and saying, go away, we can't help you. And her response, well, I'm going to talk to my provider about it for guidance. And she goes to Dr. Tufts. She sees Gelada at some point. You look at the records, she never discussed those options with them. She told them that women and infants turned her away and said she didn't qualify for the program. She didn't discuss those 3 programs that they offered her. So basically, they give her this offer of help, 3 different forms of help, and she says, no, doesn't want to do them, and doesn't discuss it with her provider. And also that first time she goes to Mass General, to the emergency room, they offer her a bed at McLean, and she turns it down. She wants help. No one's saying she doesn't want help, but she's making these decisions and doing these things that aren't helping her get help, that are turning away help, because she wants the help in a certain way, in a certain time frame. And, you know, all during this time, between September and December of 2022, she's interacting with friends, with family, teachers, gym staff, the nanny, people at gymnastics, interacting with them in public spaces, in public ways, driving her kids around, all throughout that time, able to know the difference between right and wrong, able to conform her behavior to the law and to the requirements of society, and interacting with others and presenting herself as a functioning adult, a functioning mom. You know that she knew the difference between right and wrong during that time because she had those thoughts at the beginning of December of harming her kids. And she told Patrick and her mother about them. But who she didn't tell is important and very telling. She didn't tell a single provider, not Tufts, not Gelada, not Jennifer McAllister, not Dukes, no one at McLean, no one at MGH, no one at South Shore. Didn't tell any of them. And why? Because the police might take away her kids. That's a rational thought. That telling mandated reporters that you're having a thought of harming your kids, that they might be taken away for their safety, that's a rational thought. And it also shows she knew it was a bad thought, a wrong thought. Because you don't think someone's going to take your kids away because you're thinking something positive or neutral. It's because it's bad, it's because it's wrong, it's because it's against the law. So she knew that it was wrong. And she was able to conform her behavior to the law because she didn't tell those providers. She went in and met with them and talked about what she was experiencing and talked about her depression. And not only did she not tell them, she lied to them. They asked her, are you having thoughts of harming others? Do you have homicidal ideation? She told Tufts no. She told Gelada no. She told Dukes no. She told Goodhart no. Every day at McLean, she said no. At MGH, she said no. So not only is she hiding it, she's lying about it. She's controlling her behavior. She's controlling the presentation she presents to her providers. And then we get to her being admitted to McLean. You know, up to that point, all of the drugs she's taken from September through December, they weren't given at the same time. The most she ever had at one time was 2 to 3 medications. And usually if it was 3, that third medication was the Benadryl or the hydroxyzine that's like Benadryl, or the Ativan or Valium as needed for anxiety. But most of the time it was 2 medications. And the way they did those medications, you heard from Dr. Satoff, a man who's examined thousands of patients with psychosis, who's treated women with postpartum psychosis, who's treated women who have killed their children, that man who apparently has no expertise. You heard from him that the medication trials were reasonable and rational. She tried a medication, it didn't work, or they had side effects, they stopped the medication. They tried something else. They tried a different combination. And unfortunately, with mental health, there's no blood test or CAT scan or MRI that you can do that says, well, you have bipolar or you have schizophrenia. It unfortunately doesn't work like that. So what the providers have to do is rely on what the patient's telling them. Hope that information is accurate. Rely on what they're observing about the patient and make a diagnosis. And then based on that diagnosis, have a treatment plan. And every patient reacts differently to medication. One patient could do fine on it, the next not. So they have to do that trial and error process, and it's normal, it's typical, it's reasonable. And that's what they did for her. And even if you believe that the number of different medications she took over that time or the combination of those medications affected her negatively, after McLean, they were out of her system. Some of them had been out of her system for months. Zoloft, she stopped in October. Other pills she stopped in November or December. And that last one, the Seroquel, that she really had a bad reaction to, is out of her system. The only medication she's on leaving McLean is trazodone for sleep and Valium for anxiety. And that's it when she leaves there. And why does she leave there? He wants to go to Cora's birthday party. And that's relatable, that's understandable. She wants to be that mom again who can throw her daughter a party and enjoy it. It's completely understandable why she would want to leave, but she also knew she wasn't there. She knew how she was feeling. She knew she was depressed. She knew she needed help. But she wanted to be that mom she was more. And there was nothing McLean could do to keep her there. She said she denied suicidal ideation. She denied homicidal ideation. She said she wasn't hearing voices or seeing anything. They saw the entire time she was there no signs of psychosis. In fact, every doctor she saw, from Tufts in September all the way through Tufts at January 23rd, none of them saw any signs of psychosis ever. So they're all wrong. All these different doctors at all these different practices, they're all collectively together wrong. That doesn't make sense. But she shows when she's leaving McLean, no signs of psychosis. And they even give her a task to do to see if she can manage her mental health outside of the hospital. Make an appointment, pick a doctor, make an appointment. And she does it. She decides on Dr. Tufts. She makes the follow-up appointment. She gets the documentation and gives it to them, showing she can manage her mental health. They have to let her go at that point. She's there voluntarily. There's no grounds to keep her if she's not showing she's a danger to herself or others. So they let her go home. And at home, again, all throughout January, she's showing her ability to know right from wrong and to conform her behavior to the requirements of the law in all the activities she does in January. First, there's the birthday party. She's throwing the birthday party. She's monitoring the kids, making sure, typical mom birthday party stuff. Everyone's eating, getting cake, singing happy birthday. You saw her in the video. She appeared happy and smiling, normal. Everyone that interacted with her said, seemed a little tired, but okay. The Museum of Science. You have that video. The Museum of Science in Boston can be crowded and overwhelming on a good day. And she's there with 3 kids under 5 with her husband. You see her monitoring them, caring for them, doing the exhibits, showing them what to do with the exhibits. If you watched that video and you didn't know who the Clancy family was, and we asked you, pick out the woman who is depressed, pick out the woman who wants to kill herself, pick out the woman who's about to kill her kids, you couldn't pick her out. She's completely calm. All her behaviors are typical and normal because she's able to control her behavior. She's able to be suicidal and feel those things, but control her behavior, control her thoughts, and present that image to the world. She's able to do it at the Cape Cod as well. Similar scenario. She's able to watch the kids when Patrick goes to brunch. She's able to watch the boys when Patrick and Cora go skiing on the 16th. She's able to interact with the Carneys on January 22nd. And yeah, they both initially said she was quiet, but then they both admitted she was always kind of quiet. But she was able to interact with them, chat with them in the kitchen, seemed okay. In between January 7th and January 21st, her mother never comes to the house to intervene. Her sister, a licensed social worker, a mandated reporter, never comes to the house to intervene or help, never makes a report, and they're in contact with her every day, texting with her, calling with her almost every day, and never see any signs that they should be concerned or worried or intervene. And you have those text messages between the defendant and her mom. And her mom, obviously, was very attentive, very caring, asked very pointed questions. How are you doing? How are you sleeping? How are the medications? Obviously, a very concerned, loving mom. How does Lindsay answer? I'm getting a little better. I'm sleeping better. She said the only time her sleep was interrupted is if Cora had a bellyache or one of the kids was up. But she's doing better every day. She's sleeping better. She's feeling better. She still says, I'm not myself. I'm not where I want to be, but she's moving in the right direction. And we have that text from her mom the day she leaves on the 22nd, headed back home. I'm glad to see you're doing so much better. Now her mom wants you to believe that she lied to her, that she wasn't doing better and she was just trying to encourage her. But there are so many things you can say to your daughter who's struggling with mental health other than lie to her if you want to encourage her. You've got this. Take it day by day. I'm here for you. We're going to get through this. But she wants you to think she lied to her when she said she was doing better. But you know that wasn't a lie. You know that she was doing better, or seemed to be, and that her mom said, I'm glad you're doing so much better, because Patrick said the same thing. He said she was doing better in January. Every day was better. The 24th was the best day. They had hope, because that's what she wanted to show them. The only person during that time that she gave even a little glimpse of maybe she wasn't doing that much better was Dr. Tufts. And she told Dr. Tufts that she was feeling depressed, which is why Dr. Tufts prescribed the 10 milligrams of amitriptyline a day. Very low dose. And then she told Dr. Tufts again, still not helping. And so Dr. Tufts raised it to the 20 milligrams. Again, a very low dose, a dose a child could take. And that shows how cautious and conservative Dr. Tufts was being in the treatment of this patient who had had those interactions with medications previously. She was being cautious and conservative and acting with care for the patient by slowly increasing the medication. But even with Dr. Tufts, she still denied having a suicide plan, denied wanting to hurt anyone else, denied voices, denied visual hallucinations, showed no signs of psychosis, all the way up to January 23rd. Nothing. And if you look at their journal, you look at this journal that defense counsel showed you, she's very detailed, excuse me, about when she took medication, what she took, the amounts she took, what the effect was for months, starting in October and going all the way up to January. And where it stops, January 18th. Someone who's been so meticulous about everything all the way up to January 18th, and it just stops. It's as if she's decided she's done trying. She's decided that it's too much, and she doesn't want to do it anymore. And so she just stops keeping track of the prescriptions. And then we get to January 24th. Everything that happened that day, every person she interacted with, every situation she was in, shows you she knew the difference between right and wrong, and she could conform her behavior to the law. The doctor's appointment first thing in the morning. She's able to drive there. She's able to interact with medical professionals. She's able to seem absolutely fine and normal. And this is a doctor who's treated the kids since Cora was a baby. This is a pediatrician who's known the family and has known Lindsay for almost 5 years. A woman who's trained in recognizing the signs of postpartum depression. She told you she looks for flat affect, she looks for teariness, and some other things that she told you. She saw none of that. She was able to control herself and interact with her in a perfectly normal, concerned mother way. Able to get home from that appointment. She plays with the kids, she takes them outside, she's sending those messages and photos to her mom and to Patrick, basically saying, look, this is a good day. I'm having a good day. Everything's good. I'm getting better. Here's proof. This is what I'm doing. You start to see the planning at about 4 o'clock in the afternoon. And this is on her phone. You can see her search for Miralax, kids Miralax at 4:02. And then a little while later at 4:13, you see her search for takeout from 3V. And then immediately after, she does the Apple Maps search to see how long it takes to get to 3V. Well, defense wants you to believe that, she was checking that because she didn't want him gone for too long. She wanted him home. She was in distress. If you're in distress, don't send him anywhere. Make food at home, have him cook, get delivery, get DoorDash. Go to one of the other restaurants that Patrick mentioned that were 2 minutes down the road. And she didn't have to look up on Apple Maps to see where this restaurant was. You heard from Patrick, they had been there at least 3 times in the months before. She had lived in that area for 4 years. She knew where it was. She knew generally how long it would take to get there. What she needed to know was how long specifically on that night it would take to get there. Because she knew she would have a limited amount of time to do what she wanted to do. And what she had decided to do was to kill the children and then kill herself. And so she needed to know, not generally, but exactly how much time will I have. And then obviously sees that that's not enough time. So then she searches CVS. And not only does she search CVS, she calls them. Calls them and asks them if they have kids Miralax, and they say no, but they have Pedialax and one other medication. And then she asks, is it in stock? Because she needs to know not only what they have, but is it in stock? Because she's adding to this errand that she's sending Patrick out on. And she has to make sure she's not interrupted. She doesn't want that call at 5:33. She wants him to go to CVS and have the medication there and get it and then go on to 3V so she has time to do what she needs to do. So that's why she's calling to see what they have and make sure it's in stock. It's a level of planning there and thinking and decision-making that Dr. Satoff referenced. And then after that, she texts Patrick, it's been a long day, can we do 3V? And he's on board with that. And she's like, okay, check out the menu, let's get on this. And he asks her what she's getting. She tells him the Mediterranean Power Bowl. He says he's getting the pork belly risotto. 5:10 p.m., she's calling that order in. She's talking to the hostess. She gets the order accurate. She is able to answer questions about how she wants her food. She's able to recall and give Patrick's phone number and his name as the person picking up. And then Patrick's leaving to go get the food. And as he's leaving, the kids are in the living room on the couch eating. The defendant's in the doorway near the basement door. And she says to him, oh, by the way, can you go to CVS? Acting like it's this last minute thought, like, oh, by the way, can you get this? And not something that she's been planning for over an hour. She knew about the Pedialax and she knew about 3V and she knew all of that before she even asked him about dinner. But it's like, oh, can you go to CVS on your way and get kids Pedialax? And he, of course, is like, sure, I'll get that. And he heads out the door at 5:15. And that's the time he leaves because he says to her, yeah, just text it to me. And that's such a normal kind of interaction that we have in your common sense and life experience. You're headed out the door to run an errand and someone in your home says, oh, while you're out, could you get me X, Y, and Z? And you're like, yeah, sure, just text it to me. Because you don't want to get there and be like, oh, what did they want me to get? It's such a normal interaction, right? Can you get this for me? Sure, text it to me. And he heads out the door and she texts it to him at 5:15 p.m. And then he goes to CVS, even though she's told him what to get and they have it, he still makes that call at 5:33. She calls him back at 5:34, and then he heads out to 3V and then comes home. And when he gets home, puts the things on the counter and it's quiet. It's quiet in a way that a house with 3 kids under 5 should not be during waking hours. So he calls out to them, no answer. He goes to the basement door and opens it and yells down and no answer. And he closes the door. He calls her phone, no answer. He goes upstairs and is able to unlock the door and see the blood and see the window open and go down to her. And when he goes down to her, she's no longer actively bleeding. He doesn't have to put pressure on any of her wounds. And he says to her, what did you do? And her response is, I tried to kill myself. And then it's, where are the kids? In the basement. It's not, I heard a voice, I was compelled to do this, I didn't want to do this. Go help the kids. They're hurt, they're in the basement, go save them. No. It's, I tried to kill myself, and the kids are in the basement. And defense wants you to believe that conversation couldn't have happened because of how she sounded on the 911 call. But you heard from the doctors, people can deteriorate over time. When he first gets there, she's able to talk to him. And as that progresses, she's losing the ability to talk. And there's nothing in the medical records about her throat being crushed or her thyroid being crushed. You can look at that. Her thyroid was bruised, her vertebrae were broken, but her throat wasn't crushed. She had the ability to make sound and to communicate. And if you listen to the 911, he's talking to her, and then he's answering the 911 dispatchers about what she said. So even if we can't hear her clearly and we can't understand what she was saying, he could. You know from all of the evidence that you have, putting aside the experts, but all the evidence you have in terms of crime scene photos and videos and the witness testimony and all the medical records, you know how she killed them, where she killed them, what time she killed them, and the order that she killed them in. Even without what she told the doctors about the order, that's something you can infer from the evidence. Because you know, in order to bring the kids to the basement and strangle each one of them, and then come upstairs and get a knife and have a phone call, and then go upstairs to the second floor and either take handfuls of pills or crush them however she did it, take the pills, and then cut herself. And it's not just 3 cuts, it's the hesitation marks, and then the cuts themselves. And then you know she bled in a couple spots for a little while because you heard from Sherry Crook how the pooling in front of the mirror is someone, basically the blood dropping down and someone there for a period of time. And then over closer to the window, the same thing. So she's bleeding in front of the mirror for a period of time, over by the window for a period of time, and then she goes out of the window. And whether she dove out or climbed out and slid down, whatever you think that evidence shows from the shingles and everything you've seen, whatever happened, she goes out of the window and she's on the ground. And by the time Patrick gets there, she's no longer bleeding. So for all of that to happen in that short amount of time while Patrick's gone, she had to have started killing the kids immediately after he left. Now, defense wants you to believe that it was after the phone call, that after the phone call, she heard the voice and killed the children. But there's a few things about that don't make sense. First is what she told Dr. Satoff, that when she gets the call, she's at the fridge getting chicken nuggets out of the fridge to make dinner. You heard from Patrick, when he's leaving, Dawson is sitting on the couch eating chicken nuggets and green beans out of a bowl. There's the crime scene photo of 2 bowls on the couch. Yes, the pink one seems to have some vegetables in it, but there's the blue one there as well. And Patrick saw Dawson eating the chicken nuggets and green beans. So why would the defendant make that up? Why would she say she's doing that during the phone call? Because if she's already killed the kids because of a voice and being compelled and it being against her will and she's like a puppet, then she can't get a call and miss it and then call the person back and have a conversation and then hang up. A puppet can't do those things. Those are decisions and choices and actions that she's controlling. So she has to explain away the phone call because her behavior and her ability to have the phone call don't make sense if she's being compelled by her voice, if she's not in control. And you, further on that, you have the phone. You have the flights climbed. There were 2 flights climbed. You can see, you have Ian Whiffin's report. You can see there were 2 flights climbed. The first ends at 5:33. So it makes sense that she has killed the kids in the basement and she has come up the stairs, and at 5:33, she's in the kitchen and she's getting the knife. And then Patrick calls. Everything she's done, everything from the research to making sure what they had, to telling him to get it, to making sure it's on stock, all of that, and he still calls her, he still interrupts her. And then she gets the knife and she goes upstairs, and she's at the top of the stairs by 5:38. So the phone calls from 5:33 to just before 5:35. So if you want to believe that the voice happened after the call, and the killing of the kids happened after the call, between 5:33 and 5:38, she doesn't go down and come back up and come back up and come back up. There's nothing on that phone about that. And there wouldn't be enough time for her to bring those kids down to the basement and strangle each one in 3 minutes. You heard from the doctors, and Dr. Lapisato included, it could take up to 30 seconds for each child to go unconscious. And then strangulation would have to continue for another 1 to 2 minutes to cause death. And Dr. Lapisato wanted you to believe that the band could just stay there around their necks by themselves. But you have the bands. They're exercise bands. You pull them, they resist, you let go, they snap back. I had to hold them up to show her in circles like around someone's neck. And when I let go, they expanded. They don't stay around someone's neck on their own. You have to pull them. And you know they weren't knotted. Patrick never testified that they were knotted, so I'll take this one. He testified that he didn't have a clear memory, but he remembered that they were possibly looped. And I asked him, like, when you're tying your shoe, that first loop before you do a bow? And he said, yeah, kind of like that. So not knotted, not tied, but even his memory wasn't the best. You heard him on that call. And that's why we had to play the call for you, because you could hear him. You could hear when he found each kid. And you knew that he had the phone with him when he found each kid, because his voice, it never sounded like he was in another room. It always sounded so painfully right there. And so you know he's holding the phone and he's not untying knots, and he wouldn't have had the time to untie knots in that short amount of time. And then you have the firefighters looking in the window, seeing him with Dawson, and he's not untying a knot or unlooping something. They say they see him in an unwinding motion, unwrapping. That's why you had to listen to the 911, to show that she did stand over their limp bodies and strangle them for 1 to 2 minutes after they went unconscious. Because those weren't knotted, they weren't tied. They don't just stay there on their own. And even if you wanted to believe that at 5:38, she goes upstairs and puts the phone on the bed, and then she goes down and kills the kids, and she does everything. 5:38 to just after 6 p.m., because he's making the call to her at 6:09. There was not enough time between 5:38 and just after 6 p.m. to kill all 3 kids, to get the knife, to take the pills, to cut herself, to bleed, to go out of the window, to stop bleeding, and Patrick to get there. In 20-odd minutes, it's not enough time. So you know she killed those kids as soon as he left. And when she got the call from him, she had already strangled them. And she didn't tell him. She didn't ask for help. She didn't say, oh my God, what have I done? She's a nurse. She didn't go down and try to do CPR and help them. No, she lied. She stayed calm. She presented herself as normal. She had complete control over her behavior and her emotions. She had a normal conversation with him because she didn't want him coming home, because she needed to finish her plan. She still had to kill herself. So why did she do it? Defense would have you believe that a mother who was this good, who loved her kids this much, which we're not denying, would never harm her kids this way unless she was so mentally ill that she was hearing these command voices and had no choice. But that's not the world we live in. Dr. Resnick told you, most women who kill their children do it in child abuse. Most women who kill their children don't do it because of mental illness. Mothers kill their children, and it's horrible and it's awful, but it happens. So why did she specifically do it? She was depressed. She was exhausted. She was done. She didn't want to try anymore. She felt damaged. But those kids were her protective factor. Those kids were keeping her from ending her misery. And so she had to remove the protective factor. And I'm not saying she was happy about it. I'm saying that it was what she had to do to end her misery. But it was a choice. It was a choice. She could have kept trying. She could have, moved down to her mother's. She could have killed herself and left her kids alive. But it was a choice to take them with her. It was a horrible choice. And it's a choice that we don't want to think about that a mother could make, because that doesn't make us feel safe or comfortable in this world. But it's a choice she made. She knew it was wrong because she sent Patrick out to do it. She could conform her behavior because she waited until he was gone and didn't tell him what was going on those phone calls, didn't call 911 for help, didn't lock herself in a bathroom upon hearing this voice. She knew it was wrong. She didn't take advantage of this situation. She created this situation, this opportunity to do what she wanted. And when she woke in the hospital, and she knew she was alive and the kids weren't, she knew what she did was wrong. She said she felt horrified. And then, while still with a tube in her throat, she's asking, do I have a lawyer? And it's not what defense said. It was after surgery and she's delirious. Look at the records. She had surgery on the 27th. She's asking if she has a lawyer on the 26th. Do I have a lawyer? Because she knows what she did was wrong. And then we get the justification, the excuse of the voice. And there are a few reasons why the voice doesn't make sense. The first is she immediately obeyed it. Dr. Resnick, their expert, the one who knows everything about postpartum psychosis, he teaches other psychiatrists and psychologists. He writes books and chapters and articles about how this is a huge red flag if someone immediately obeys a voice. You heard him talk about Andrea Yates, about how she heard voices to kill her children for months. And what did she do? She committed herself 5 times. She tried to kill herself twice to avoid harming her children.
Counsel,
Said that was all accurate.
let's move on from that.
Lindsay Clancy hears his voice one time and does it. Doesn't try to lock herself in the bathroom, call Patrick, call 911. Doesn't try to leave. Leaving little children alone for 20, 30 minutes, not the greatest option, but it's better than killing them. She doesn't try any tactics to avoid the voice. She just obeys. Another red flag that Resnick was asked about and teaches and writes about is that she only heard the voice one time. She never heard it before, and she hasn't heard it since. So how that works. It's a red flag that she's making up the voice. Another one is that what she said the voice told her isn't consistent. At the hospital, she says the voice said, you have to kill your children so you can kill yourself because they'll suffer without you. What she tells a lot of the doctors is, it says, this is your last chance, you have to kill the kids so you can kill yourself. And then she tells the chaplain, a third version, you have to kill the kids so you can kill yourself because they're in danger. There's these 3 different versions. Another red flag, it doesn't make sense. That the voice, she's saying the voice says all these different things. And then the fourth thing that doesn't make sense about the voice is that it's vague in its command. It doesn't tell her how to kill the kids, where, with what. Nothing. It says kill the kids so you can kill yourself. So she had to choose where, the basement. She had to choose how, strangulation. She had to choose with what, exercise ban. Choose again, exercise ban. Choose again, exercise ban. She had to choose how to kill herself. Now, if you're being compelled by this voice, and you have no free will whatsoever, you're just your body's acting on the voice, why wouldn't you just kill yourself the same way you killed the children? You strangled them, you hang yourself. That's acting on compulsion, that's no choice. She tried 3 different ways. And none of them similar to what happened to the kids. And I'll take this other quarter now and explain to you why we got into the superficiality of the wounds and why we got into the height of the window and why we got into how she didn't take enough pills to actually kill herself. We're not saying she didn't want to kill herself. We're talking about that 3rd prong of suicidality that Dr. Satoff talked about. Remember, he talked about aloneness and feeling burdensome, but that 3rd category, capability. She wanted to kill herself, but her natural instinct to live was fighting against that. So she took pills, but you heard the toxicologists, they were all at therapeutic levels or below, except the Seroquel, which was a little elevated. She cut herself, but you saw the cuts on the meaty part of her arm horizontally. No arteries, no major blood vessels. Didn't need to be stitched the next day. The one on her neck didn't need to be stitched at all. She knew as a nurse those weren't going to kill her, but she was trying. And then going out of the window, 12, 13 feet. She landed the wrong way and ended up paralyzed on the frozen ground. But, the idea that falling out of a 12-foot window is going to definitely kill you, not necessarily. And so she wanted to. She was trying in all these different ways. But she just couldn't get over that 3rd prong, the capability of actually killing herself. And that goes against it being a voice. Because if she's compelled to do it, if this voice is making her do it, she would just do it. There would be no fight. There would be no struggle. There would be no resistance to dying. But but there was. I guess the third one is Dr. Zeisel. We've never said that he told the defendant what to say. Not one witness, not one piece of evidence. The only person that said that Dr. Zeisel, that we were trying to say Dr. Zeisel told her to make up the voice, is defense counsel. He's the only one that asked about it. He's the only one that brought it up. We have never said that in this courtroom, and no witness has said that we've asked. She knew what she did was wrong. She could conform her behavior to the law and chose not to. And she didn't expect to have any consequences because she expected to die with her children. And we get to what we have to prove is that first degree is deliberate premeditation and extreme atrocity and cruelty. You know it was deliberate premeditation because of the way she killed them and the way they died. And the order also shows a rationality. The order she killed them in. Because Cora and Dawson are older. If she had tried to strangle one in front of the other, they would have known this is bad. And they would have tried to intervene or run and hide. And she had a very limited time. She didn't have time to try to find a child who ran off and hid. So taking Dawson first and moving him to a separate room, having Cora stay with Callan and having Dawson go in another room, that's rational. That makes sense. That's ordered thinking. And we didn't show you that post that she made about Dawson being a handful and not being compliant to show she was a bad mom. We showed it to you because it proves she knew that he was a handful. She knew that he was less likely to be compliant, to just go along. She knew that he might struggle. And so it made sense rationally to remove him and separate him first and kill him first. And she brought him into that room, into the office, and closed the door, and she wrapped that band around his little neck. And she squeezed until he was unconscious. As the blood's pooling in his face and causing those blood vessels to burst, causing him pain and panic and confusion. And defense calls Dr. La Posada to say, no, it wasn't 20 or 30 seconds. It was only 5 or 10 seconds until he went unconscious. I'm sorry, how many seconds is it okay for them to have been in pain and panic and confusion? How about it wasn't okay for 1 second for any of those children to feel that? And they all felt it, all for up to 30 seconds. And then she continued strangling their limp bodies for 1 to 2 minutes to make sure they were dead. Deliberate premeditation. And then extreme atrocity and cruelty. The indifference that she showed to their pain, to their struggle, to their suffering, leaving them there on the floor with the bands around their necks, completely indifferent, because she had a plan and she was following it through. Just think of that. The being strangled and the pain and the confusion that they're going through, and it's being done by their mom. Their mom is the one that's hurting them. Their mom is the one that's killing them. That's extreme atrocity and cruelty. She didn't see them in that moment as individual human beings with rights, with dreams, with futures, individually belonging to them. You heard about the 3 kids. Cora wanted to be a doctor and a mom. Dawson wanted to be a firefighter. Callan never got the chance to dream. Who knows what future he would have dreamed for himself. She killed them, and she left them there on the floor with the bands around their necks. She didn't bring them up to their beds and put them with their favorite stuffed animal and cover them up gently and lovingly, leaving them peacefully there. No. She left them discarded on the basement floor like broken toys because she was done playing the game. You know to a moral certainty she is guilty.
All right, thank you, counsel. Now, members of the jury, been sitting here for a while. Does anybody need a short break? You think that would? All right. So we're going to return now to the instructions that I have. In rereading my instructions, I just kind of want to make sure that something's clear. So I'm going to ask you to go back to page 6. I think we were talking about murder in the second degree. Everybody get there. All right. And what I just kind of wanted to make clear, that you may consider the defendant's mental condition at the time of the killing, including any credible evidence of mental impairment or the effect on the defendant of her consumption of prescription drugs, in determining any of the elements in the murder in the second degree charge as well. I mentioned that for some of the others, but and specifically for the charge in murder of the second degree, there's an element regarding intent. Okay, so I just kind of wanted to make that clear. Probably is suggested in that, but as I read through it, I just kind of wanted to remind you that you can, as I said, you can consider the defendant's mental condition at the time of the killing, including any credible evidence of mental impairment or the effect on the defendant of her consumption of prescription drugs, in determining the elements in murder in the second degree. All right, so I hope that cleared things up rather than confusing you any. But now I'm going to go to the general principles in regards to this case. All right. Now, as I said to you before, I'm incorporating the instructions that I gave earlier before the closing arguments with these instructions. So I want to talk about the presumption of innocence and the burden of proof. Once again, the indictments against Ms. Clancy are only an accusation. They're not evidence. The defendant has denied that she's guilty of the crimes charged in these indictments. The law presumes the defendant to be innocent of the charges against her. This presumption of innocence is a rule of law that compels you to find the defendant not guilty unless and until the Commonwealth produces evidence from whatever source that proves that the defendant is guilty beyond a reasonable doubt. This burden of proof never shifts. The defendant is not required to call any witnesses or produce any evidence, since she is presumed to be innocent. The presumption of innocence stays with the defendant unless and until the evidence convinces you, unanimously as a jury, that the defendant is guilty beyond a reasonable doubt. It requires you to find the defendant not guilty unless your guilt has been proved beyond a reasonable doubt. Your verdict, whether it is guilty or not guilty, must be unanimous. All right. Now, reasonable doubt. The burden is on the Commonwealth to prove beyond a reasonable doubt that the defendant is guilty of the charges made against her, as I just told you. But what is proof beyond a reasonable doubt? Well, the term is often used and probably pretty well understood, though it's not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you've compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I've told you that every person is presumed to be innocent until she is proved guilty, and that the burden of proof is on the prosecutor. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason in judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. Now, I want to talk initially about my function of the judge. My function as a judge in this case has been to see that the trial is conducted fairly, efficiently, and in an orderly manner. It's also my responsibility to rule on what you may consider as evidence and to instruct you on the law that applies in this case. It's your duty as jurors in this case to accept the law as I stated to you. You should consider all of my instructions as a whole. You may not ignore any instruction or give special attention to any one instruction. You must follow the law as I give it to you, whether you agree with it or not. That's not just because I'm the judge. It's because every person who comes to court for trial is equal and is subject to the same law. And if jurors in each case were to apply what they thought the law should be, and the jurors in different cases had different views, then the parties in those cases would not be treated equally. The law that I'm instructing you on is the law that has been established by our legislature and our appellate courts, and it applies to everyone. And you must apply the law as I instruct you. Function of the jury. Your function is to determine the facts of this case. You are the sole and exclusive judges of the facts. You alone determine what evidence to accept, how important any evidence is that you do accept, and what conclusions to draw from all the evidence. You must apply the law as I give it to you, to the facts as you determine them to be, in order to decide whether the Commonwealth has proven its case. You should determine the facts solely on a fair consideration of the evidence. You are to be completely fair and impartial, and you are not to be swayed by prejudice, by personal likes or dislikes towards either side, or by any personal view you may have the nature of the claims or the defenses in the case. Your decisions must rest solely on the facts that you find and the law that I give to you in these instructions. Nor are you to be influenced by any personal likes or dislikes you've come to feel towards any party or any attorney. In this courtroom, every person is equal and is entitled to a fair and impartial verdict in accordance with the evidence and the law. You are not to decide this case based on anything you may have read or heard outside of this courtroom. That, with the exception of that, is the observations you made at that view, and I'll talk about that a little bit later. You are not to engage in any guesswork about any unanswered questions that remain in your mind, or to speculate about what the quote-unquote real facts might or might not have been, beyond what has been proved by the evidence. You should not consider anything that I've said or done during the trial as any indication of any opinions as to how you should decide this case. If you believe that I've expressed or hinted at any opinion about the facts of this case, please disregard it. I have no opinion about the facts or what your verdict ought to be. That is solely and exclusively your duty and your responsibility. Now, I'll talk about function of counsel. It was the duty of the lawyers in this case to object when the other side offered evidence which that lawyer believed was not admissible under our law. They also had an obligation to ask to speak to me at the sidebar about questions of law which the law requires me to rule on outside of your hearing. The purpose of such objections in rulings is not to keep relevant information from you. You should not draw any inference, favorable or unfavorable, to any attorney or their client for objecting to proposed evidence or asking me to make such rulings. That is the function and responsibility of the attorneys in this case. Now, what is evidence? As I told you, you are to decide what the facts are solely from the evidence admitted in this case and not from suspicion or conjecture. The evidence consists of the testimony of witnesses as you recall it, and any documents, photographs, or videos or other things that were received into evidence as exhibits. You may also consider any observations that you made while at the view that we took earlier in the trial. In this case, there may be certain documents or photographs that are entered multiple times. This does not mean that that evidence is any more or less important than any other evidence. You, the jurors, will decide how to evaluate the evidence, that is, what weight to put to it. Now, in reviewing documents and evidence, you might find that there's some information that's been whited out or redacted. This is because the court has made some legal rulings about what evidence is relevant to this case. You should not draw any negative inference against either party based on these redactions, nor are you to speculate about what information has been redacted. In addition, a couple of stipulations were entered into evidence during the course of this trial. A stipulation is an agreement that has been made between the parties. The contents of such stipulation may be accepted by you as facts and relied on you along with other facts that you find based on the evidence. Now, of course, the quality or strength of the proof is not determined by the sheer volume of evidence or the number of witnesses or exhibits. It's the weight of the evidence, its strength, intending to prove the issue at stake that's important. Some things that occur during a trial are not evidence, and you may not consider them as evidence in deciding the facts of this case. A question put to a witness is never evidence. Only the answers are evidence. So if a witness agrees with a fact or a proposition contained in a question, then the fact or proposition agreed to is evidence. However, if a witness disagrees with a fact or proposition contained in a question, then the fact or proposition is not evidence simply because it was suggested in the question. You would have to look elsewhere for evidence about that issue. You may not consider any answers that I've stricken. They're not evidence and cannot be used by you as evidence or considered by you for any purpose. The opening statement and closing arguments of the lawyers, not evidence. They're only intended to assist you in understanding the positions of the party. My instructions and anything that I've said during the trial, not evidence. All right, so if your memory of the testimony differs from the attorney's or mine, you are to follow your own recollection. You must consider the evidence as a whole. Now, I want to talk about direct and circumstantial evidence. There are two types of evidence that you may use to determine the facts in this case. There's direct evidence and there's circumstantial evidence. The law allows both direct and circumstantial evidence in a criminal case, and circumstantial evidence alone may be sufficient to establish guilt beyond a reasonable doubt. Direct evidence is when a witness testifies directly about the fact that is sought to be proved based upon what he or she claims to have seen, heard, or felt with their own senses. And the question there is whether you believe that witness or not. Circumstantial evidence is when Circumstantial evidence is when no witness can testify directly about the fact that's sought to be proved, but you are presented with evidence of other facts and then asked to draw reasonable inferences from them about the fact that's sought to be proved. There are, however, several things you should keep in mind about circumstantial evidence. The first one is that you may draw inferences and conclusions only from facts that have been proved to you beyond a reasonable doubt. The second rule is that any inferences or conclusions you draw must be reasonable and natural based on your common sense and good judgment. In a chain of circumstantial evidence, it's not required that every one of your inferences and conclusions be inevitable, but it is required that each of them be reasonable, and that they all be consistent with one another, and that together they establish the defendant's guilt beyond a reasonable doubt. Inferences must never be based on conjecture, surmise, guesswork, or assumption. And whether the evidence is direct or circumstantial, the Commonwealth must prove the defendant's guilt beyond a reasonable doubt from all of the evidence presented in the case. Now, I want to talk about the credibility of witnesses, all right? It's going to be your duty to decide all the disputed questions of fact. You are going to have to determine which witnesses to believe and how much weight to give their testimony. You should give the testimony of each witness whatever degree of belief and importance that you judge it is fairly entitled to receive. You are the sole judges of the credibility of the witnesses, and if there are any conflicts in the testimony, it's your function to resolve those conflicts and to determine where the truth lies. You may believe everything a witness says or only part of it or none of it at all. If you do not believe a witness's testimony that something happened, of course your disbelief is not evidence that it did not happen. When you disbelieve a witness, it just means that you have to look elsewhere for credible evidence about that issue. And when deciding whether to believe a witness and how much importance to give a witness's testimony, you must look at all the evidence, drawing on your own common sense and experience of life. Often it may be not what a witness says, but how the witness says it that might give you a clue whether or not to accept that witness's version of an event as believable. You may consider a witness's appearance and demeanor on the witness stand, the frankness or lack of frankness in testifying, whether the testimony is reasonable or unreasonable, probable or improbable. You may take into account how good an opportunity the witness had to observe the facts about which the witness testifies, the degree of intelligence the witness shows, and whether the witness's memory seems accurate. You may also consider any motive that the witness may have for testifying and whether the witness displays any bias in testifying and whether or not the witness has any interest in the outcome of the case. Now, I want to talk a little bit about prior inconsistent statements. When you evaluate the testimony the witness gave here in court, you may consider whether that witness made any earlier statements that differ from or contradict in any way their in-court testimony. That earlier statement is generally admitted into evidence solely for your consideration in evaluating the witness's credibility or believability. If you determine that an earlier statement is different from the way the witness testified in court, you may decide that the witness's credibility or believability is affected adversely, or you may decide that it's not adversely affected, but that is the only purpose for which you may use that earlier statement. You may not consider the earlier statement as evidence or proof of truth of any fact contained in the statement. Now, flip side, I want to talk about prior consistent statements now, all right? The testimony of a witness may be rehabilitated or supported by showing that he or she previously made statements that are consistent with their present testimony. The prior statement is admitted into evidence solely for your consideration in evaluating the credibility of the witness. Should you find the prior statement to be consistent, you may consider the prior statement only in connection with your evaluation of the credence to be given to the witness's present testimony in court. You are not to consider the prior statement as establishing the truth of any facts contained in that statement. Now, I want to talk about the defendant's statements that were made to evaluating psychiatrists or psychologists. You may not consider the defendant's statements made to a psychiatrist or psychologist in their evaluation of the defendant as establishing the truth of any facts contained therein. Those statements cannot be used by you as evidence of premeditation, extreme atrocity, or cruelty, or specific intent to kill. Such statements are admissible only as they relate to the basis of the doctor's opinion of the defendant's mental condition. Now, I want to talk about evidence of post-incident conduct. Now, if you have heard some evidence suggesting the defendant's actions after the killings, I'm not suggesting that these are the facts, because the facts are your exclusive domain. But there is some evidence to that effect, and I mention it here to describe the legal point that's implicated. If the Commonwealth has proven that a defendant did any of these things, you may consider whether such actions indicate feelings or consciousness of guilt by the defendant, and whether in turn such feelings of guilt might tend to show the defendant's actual guilt of the offenses with which he's been charged. You are not, however, required to draw such inferences, and you should not do so unless they appear to be reasonable in light of all the circumstances in this case. If you decide that such inferences are reasonable, it will be up to you to determine how much importance to give them. But you should always remember that there may be numerous reasons why a person not responsible for the crimes charged might do the things attributed to her. Such conduct does not necessarily reflect feelings or consciousness of guilt. So please bear in mind that a person having feelings of guilt is not necessarily guilty. In fact, for such feelings are sometimes found in innocent people. So finally, remember that standing alone, consciousness of guilt evidence, if you find there was any, is never enough by itself to convict a person of a crime. You may not find the defendant guilty on such evidence alone, but you may consider it in your deliberations along with all the other evidence that was presented at the trial. I want to talk next about expert witnesses. Now, there were a number of expert witnesses in this case. This term refers to witnesses who have specialized training or experience in a particular field. Generally, in cases that are tried in our courts, both civil and criminal, witnesses may testify only to facts that are within their own personal knowledge, that is, things they have personally seen or heard or felt. Because a particular witness has specialized training in their field, does not put that witness on a higher level than any other witness, and you are to treat an expert witness just as you would treat any other witness. You may believe all of the expert's testimony, none of it, or anything between those two extremes. There is no requirement for you to believe an expert merely because they are an expert. As with any other witness, it's completely up to you to decide whether you accept the testimony of an expert witness, including the opinions that the witness gave. It's also entirely up to you to decide whether you accept the facts relied on by the expert and decide what conclusions, if any, you draw from the expert's testimony. You must, as has been explained, keep firmly in mind that you alone decide what the facts are. If you conclude that an expert's opinion is not based on the facts as you find those facts to be, then you may reject the testimony and the opinion of the expert in whole or in part. You are also free to reject the testimony and the opinion of an expert witness in whole or in part if you determine that the witness's opinion is not based on sufficient education, experience, or that the testimony of the witness was motivated by some bias or interest in this case. All right? Now, you may have noticed that Ms. Clancy did not testify at this trial. The defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that the defendant is guilty. It is not up to the defendant to prove that she is innocent. Under our system of law, a defendant has a perfect right to say to the Commonwealth, quote, "You have the burden of proving your case against me beyond a reasonable doubt. I do not have to say a word," unquote. The fact that the defendant did not testify has nothing to do with the question of whether she's guilty or not guilty. You are not to draw any adverse inference against the defendant because she did not testify. You are not to consider it in any way or even discuss it in your deliberations. You must determine whether the Commonwealth has proved its case against the defendant based solely on the testimony of the witnesses and the exhibits. Now, speaking of the exhibits, now I'm going to talk about that. You will have all the exhibits and the stipulations with you in the jury room. If there's a need to play an exhibit or view one, the court will make a computer available for you to use. The things you heard me say we're marking for identification only are not evidence, and you're not going to have those items with you in the jury room because they're not technically part of the evidence. We marked them so we could keep track of them as we went from witness to witness, and there'd be a clear record of some of the rulings I made. So coming back, however, the exhibits that were introduced in evidence, you'll have those with you. You alone will decide the weight that they deserve to receive in helping you make your ultimate judgment about whether the Commonwealth has proven its case. You're not required to believe something simply because it's written on a piece of paper or it appears in a photograph. You're not, of course, required to disbelieve it just because it appears there either. Whether to believe what an exhibit purports to show and how much weight to give the exhibit is entirely up to you to decide. Now, the view. Early in the trial, we drove by some sites and visited an address in Duxbury. As I told you at the time, we referred to that as a view. The purpose of the view was to help you better understand the evidence that you heard during the trial and to help you appreciate the location and its surroundings. The view is part of the case. The observations that you made while on the view may be used and considered in your deliberations in reaching a verdict. Now, I want to talk a little bit about some photographs. The Commonwealth has introduced certain photographs depicting the victims. You'll have those photographs with you during your deliberations. The images depicted are not pleasant. As I instructed you at the time they were introduced, your verdict must not in any way be influenced by the fact that these images are unpleasant or graphic. The defendant is entitled to a verdict based solely on the evidence, and not one based on pity or sympathy for the decedents, which might be occasioned by the images depicted. Consider those exhibits only as they may draw attention to a clinical, medical status, or nature of the victim's injuries, the cause of their death, or to the nature of the incident itself. Now, about notes. At the outset of the case, I spoke to you regarding the use of notes, and I want to repeat it this time. Your notes are only an aid to memory and should not be given any precedent over your independent recollection of the facts. Whether you took notes or you didn't, you must rely on your own memory. Do not use your notes to try to persuade your fellow jurors of the accuracy of your reflections, and no juror should be influenced by the notes of other jurors. Your notes are not official or even unofficial transcripts, all right? Now, we'll talk about the use of phones or computers. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or media, such as a computer or a phone, to communicate to anyone any information about this case or to conduct any research about this case until I accept your verdict. Kind of want to make that real clear, all right? So if somebody has a question in that jury room, you are not allowed to try and answer it by anything other than through the exhibits and evidence you've heard, all right? We said, so I just kind of want to make that real clear. Nobody is to use a phone to communicate, to try and look. Don't talk to anybody while you're deliberating. Don't try and look up anything, things like that, all right? Just kind of make that as clear as I can. Now, before I go any farther, I have to do one more duty, and that's to select a foreperson of the jury. We have a foreperson for two purposes. The first is to act as your facilitator. That's to gather everyone around the deliberation table to be sure that everyone has a full and fair opportunity to speak and to share their views, and to ensure that all of you are always deliberating together as a group as you work to reach the verdict in this case. The second purpose of the foreperson is to act as your spokesperson here in open court. So when you're ready to return your verdict, we'll bring you all back out as a group. We'll ask you to remain standing, and we'll ask the foreperson on everyone's behalf if you've reached a verdict. And if you have, we'll go through the process of having that verdict reported by the foreperson on your behalf, and then it's recorded in the case. All right? So those are the two roles of the foreperson. So in this case, I'm going to appoint in seat 18, juror number 257 as the foreperson of this jury. Okay? Now, members of the jury, if during the course of your deliberations you should have a question about the law or about my instructions on the law, and by telling me this, I'm not suggesting you'll have one, but if you should do the following, all right? You should all first agree on the form of the question, have the foreperson write it down on a piece of paper, and the foreperson should give it to the court officer, who'll bring it to me. I'll call the lawyers together. We'll consider your question and how I should respond to it, and then I'll either bring it back out here in the courtroom and respond to you here in open court with an answer, or if it's appropriate, I might just write the answer down in response to your question and send it back to the jury room. So now that process may cause a lag time between when you ask the question, get it sent out here, and I meet with the lawyers, decide how we answer it, and get the answer back to you. So if you can continue to keep deliberating while waiting for my response, by all means do so. If you cannot go further without my response, then stop, and I'll get my response to you as quickly as I can. If it's necessary to communicate with me on any matter during the deliberations, I'd ask you to do so in writing. Send me a note, and I'll respond to it. You're instructed not to talk to anyone else about any aspect of the merits of this case during your deliberations, and that includes the staff, court officers, lawyers, witnesses, parties, family members, friends, acquaintances, anyone, all right? Now, your communications with the court officers should have to do, really just matters of scheduling and breaks, when you come back to the courtroom, that kind of thing. But even with them, don't discuss what's going on inside that jury room if you can. And then while you're in the jury room, you should all talk about this case only in the presence of each other. That is, at some point, we'll have lunch brought to you. So if you'd like, you may as a group decide to suspend your deliberations, have lunch, and then return to the deliberations. Or you might decide you'd like to work through lunch while deliberating. Either way, the only thing we can't have is some of you eating lunch separate from others while deliberating, all right? So no subcommittees in a sense. What you do as a group, all right? You do it all together. Now I'm going to get to a difficult part, reducing and sending out the jury, all right? When we impanel a jury at the beginning of a trial, we never know whether some personal emergency will arise or during the course of the trial, which would require one or more of the jurors to be excused from further jury duty. To avoid having to start the trial all over again, if that should occur, we impaneled, in this case, 18 jurors, even though the case will be eventually decided by 12 of you. And we made that decision because this is a lengthy case over the summer. The time has now come to reduce that number. This is especially difficult in this case, where all 18 of you have been equally dedicated and attentive to this case during the course of this trial, but the case is to be decided by 12, all right? And so the way it's done is the clerk will draw the alternates' names, we put all the numbers, the exclusion of the foreperson, and then we'll draw out the names randomly for the alternates. And the purpose of the alternate, for those of you who are selected, is that even during the course of deliberations, sometimes things happen. You know, one of the deliberating jurors gets sick or a family emergency, and so we may, and it happens fairly regularly, that would have to substitute one of the alternate jurors into the deliberating jurors. Because if we didn't have the alternate jurors still here, we'd have to start all over again. So that's why we do it. It doesn't make it any easier, but I thought I'd just explain to you why we have to do that. As I put in here, fate makes you an alternate juror. Don't take it personally. Your presence to this point and continuing availability, if you should be needed, is an important contribution. The court officers will make you as comfortable as possible while the jury deliberates. If you're an alternate juror, you should not discuss this case with anyone at all while the deliberations are ongoing, nor discuss it among your fellow alternates, as the need might come up that you have to join in the deliberations. So in other words, the alternate jurors can't have their own kind of informal deliberations, and it's very difficult, but I just kind of want to make that clear, that you have to do that, or you cannot do that. So at this point, I'm going to ask the clerk to reduce the jury at this point.
The following jurors are chosen as alternates. Juror number 157 in seat number 11. Juror number 162 in seat number 12. Juror number 385 in seat number 14.
What I kind of forgot to talk about, I mentioned it with the foreperson and everyone in regards to the verdict, just the verdict slip. this is the verdict slip. This is what it looks like. There will be a verdict slip for each count, and it says right there's a count regarding Cora Clancy, there's a count regarding Dawson Clancy, and there's a count regarding Callan Clancy. And on each of those, there's a box for not guilty by lack of criminal responsibility, guilty of murder in the first degree by the theory of deliberate premeditation or extreme atrocity and cruelty. There's a box for guilty of murder in the second degree. And there's a box for manslaughter. So when you have reached a unanimous verdict as to which verdict it is, the foreperson is to check that box that is applicable to the decision, sign it and date it, and let the court officers know that we have a verdict. Okay, so it's pretty self-explanatory, but I just kind of wanted to let you know that. Now, I know I'm not telling you anything you don't know when I tell you that reaching a verdict in this case is not necessarily going to be an easy task. It's going to require conscientious service on your part and a conscientious approach to your duty as jurors. I suggest, respectfully, that each approach it with a mutual respect for the opinions of your fellow jurors. They have a disposition to listen to each other. Don't be afraid to change your own opinion if the discussion persuades you that you should, but don't come to a decision simply because other jurors feel it's the right decision. It's your decision, all right? Each of you must decide this case for yourselves, and you should do so only after you considered all the evidence, discuss it fully with your fellow jurors, and listen to the views of your fellow jurors. You all heard the same evidence. You've all heard it with the same degree of attention. You're all governed by the same desire to arrive at the truth, and you're all under the sanction of the same oath that you took as jurors at the start of this trial when you agreed to well and truly try the issues between the parties in accordance to the evidence and the law. Now, I'm about to submit this case to you, and I need not remind you that you have an awesome responsibility. But I believe that you will bring to bear all the wisdom and the judgment and the conscience that you possess in reaching your verdict in this case. All that we can expect from you is that you decide this case with integrity and with principle. Now, everyone has feelings, assumptions, perceptions, fears, stereotypes. Those are implicit biases that we may not even be aware of. These hidden thoughts can impact what we see and hear, how we remember what we see and hear, and how we make important decisions. Because you're making such an important decision in this case, I strongly encourage you to evaluate the evidence carefully. Resist jumping to conclusions based on personal likes or dislikes, generalizations, gut feelings, prejudices, sympathies, stereotypes, or biases. The law demands that you return a just verdict based solely on the evidence, your individual evaluations of that evidence, your reason and your common sense in these instructions. Our system of justice is counting on you to render a fair decision based on the evidence and not on biases. Please have confidence in what you're about to do, all right? I have that confidence in you. I don't think I've ever seen a more dedicated group of jurors in any trial that I've ever been involved in. You're all people of intelligence and common sense. Collectively, you're bringing a truly powerful force to determine the truth of the matters in this case. And I, as I said, have great confidence with this case in your hands. You're honest, thoughtful, and fair, and be that as you took the oath to be. I am completely confident they'll be able to arrive at a just verdict, whatever that verdict may be. So at this time, I'm going to ask if I could see counsel at sidebar just for a second, and then we'll have the clerks swear in the court officers, and then you'll be sent out to deliberate.
Do each of you solemnly swear that you will take charge of this jury and keep them in some convenient place until they have agreed? That you will not speak to them yourselves nor suffer anyone else to speak to them, except by order of the court, so help you God? As to the alternate jurors, keep your hands raised. Do you solemnly swear that you will take charge of these alternate jurors and keep them in a convenient place, separate and apart from the other members, that you will not speak to them yourselves nor suffer anyone else to speak to them, except by order of the court, so help you God?
I do.
Thank you.
All right. Members of the jury, you may now retire to consider your verdict. Thank you.
Court, all rise. Jurors, there be no votes. Construction, television.
Jurors have exited the courtroom.
All right, everybody could be seated. I just wanted to make one comment, and it really is, unless you've tried a difficult murder like this one, you may not be aware how difficult and tough it is to try a case like this. It's emotionally taxing, it's intellectually challenging, it's physically exhausting. So I just wanted to commend all three counsel for their work and their efforts in this case, in this trial. I know how challenging it's been for them, so I just kind of wanted to acknowledge that and thank them for their efforts in regards in this case. So then before we break, could I see counsel just in regards to a couple of the exhibits?
And when she woke in the hospital, and she knew she was alive and the kids weren't, she knew what she did was wrong. She said she felt horrified. And then, while still with a tube in her throat, she's asking, do I have a lawyer? And it's not what defense said. It was after surgery and she's delirious. Look at the records. She had surgery on the 27th. She's asking if she has a lawyer on the 26th. Do I have a lawyer? Because she knows what she did was wrong. And then we get the justification, the excuse of the voice. And there are a few reasons why the voice doesn't make sense. The first is she immediately obeyed it. Dr. Resnick, their expert, the one who knows everything about postpartum psychosis, he teaches other psychiatrists and psychologists. He writes books and chapters and articles about how this is a huge red flag if someone immediately obeys a voice. You heard him talk about Andrea Yates, about how she heard voices to kill her children for months. And what did she do? She committed herself 5 times. She tried to kill herself twice to avoid harming her children.
Counsel,
It is said that was all accurate.
let's move on from that.
Lindsay Clancy hears his voice one time and does it.
The prosecution saying she had to do it to end her misery, but she had a choice. That word choice of had to do it makes this an even more difficult decision, I think, for these jurors. We do want to welcome our viewers on YouTube and the Law&Crime Network channels. We are finishing up these closings, and our live coverage is continuing after this.
I love what I do, which is help people make this.
All right, in real time, this jury has the case. We are on a verdict watch. We are finishing up the last bits of the closing argument. Let's go back into the courtroom.
You know, yeah, leaving little children alone for 20, 30 minutes, not the greatest option, but it's better than killing them. She doesn't try any tactics to avoid the voice. She just obeys. Another red flag that Resnick was asked about and teaches and writes about is that she only heard the voice one time. She never heard it before, and she hasn't heard it since. So how that works. It's a red flag that she's making up the voice. Another one is that what she said the voice told her isn't consistent. At the hospital, she says the voice said, you have to kill your children so you can kill yourself because they'll suffer without you. What she tells a lot of the doctors is, it says, this is your last chance, you have to kill the kids so you can kill yourself. And then she tells the chaplain, you have to, a third version, you have to kill the kids so you can kill yourself because they're in danger. There's these three different versions. Another flag red flag, it doesn't make sense that the voice, she's saying the voice says all these different things. And then the fourth thing that doesn't make sense about the voice is that it's vague in its command. It doesn't tell her how to kill the kids, where, with what, nothing. It says kill the kids so you can kill yourself. So she had to choose where, the basement. She had to choose how, strangulation. She had to choose with what, exercise ban. Choose again, exercise ban. Choose again, exercise ban. She had to choose how to kill herself. Now, if you're being compelled by this voice, and you have no free will whatsoever, you're just doing, your body's acting on the voice, why wouldn't you just kill yourself the same way you killed the children? You strangled them, you hang yourself. That's acting on compulsion, that's no choice. She tried 3 different ways. And none of them similar to what happened to the kids. And I'll take this other quarter now and explain to you why we got into the superficiality of the wounds and why we got into the height of the window and why we got into how she didn't take enough pills to actually kill herself. We're not saying she didn't want to kill herself. We're talking about that third prong of suicidality that Dr. Satoff talked about. Remember, he talked about aloneness and feeling burdensome, but that third category, capability. She wanted to kill herself, but her natural instinct to live was fighting against that. So she took pills, but you heard the toxicologists, they were all at therapeutic levels or below, except the Seroquel, which was a little elevated. She cut herself, but you saw the cuts on the meaty part of her arm horizontally. No arteries, no major blood vessels. Didn't need to be stitched the next day. The one on her neck didn't need to be stitched at all. She knew as a nurse those weren't going to kill her, but she was trying. And then going out of the window, 12, 13 feet. And she landed the wrong way and ended up paralyzed on the frozen ground. But, you know, the idea that falling out of a 12-foot window is going to definitely kill you, not necessarily. And so she wanted to, she was trying in all these different ways. But she just couldn't get over that third prong, the capability of actually killing herself. And that goes against it being a voice. Because if she's compelled to do it, if this voice is making her do it, she would just do it. There would be no fight. There would be no struggle. There would be no resistance to dying. But there was. I guess the third one is Dr. Zeisel. We've never said that he told the defendant what to say. Not one witness, not one piece of evidence. The only person that said that Dr. Zeisel, that we were trying to say Dr. Zeisel told her to make up the voice, is defense counsel. He's the only one that asked about it. He's the only one that brought it up. We have never said that in this courtroom, and no witness has said that we've asked. She knew what she did was wrong. She could conform her behavior to the law and chose not to. And she didn't expect to have any consequences because she expected to die with her children. And we get to what we have to prove is that first degree is deliberate premeditation and extreme atrocity and cruelty. You know it was deliberate premeditation because of the way she killed them and the way they died. And the order also shows a rationality. The order she killed them in. Because Cora and Dawson are older. If she had tried to strangle one in front of the other, they would have known this is bad. And they would have tried to intervene or run and hide. And she had a very limited time. She didn't have time to try to find a child who who ran off and hid. So taking Dawson first and moving him to a separate room, having Cora stay with Callan and having Dawson go in another room, that's rational. That makes sense. That's ordered thinking. And we didn't show you that post that she made about Dawson being a handful and not being compliant to show she was a bad mom. We showed it to you because it proves she knew that he was a handful. She knew that he was less likely to be compliant, to just go along. She knew that he might struggle. And so it made sense rationally to remove him and separate him first and kill him first. And she brought him into that room, into the office, and closed the door, and she wrapped that band around his little neck. And she squeezed until he was unconscious. As the blood's pooling in his face and causing those blood vessels to burst, causing him pain and panic and confusion. And defense calls Dr. La Posada to say, no, it wasn't 20 or 30 seconds. It was only 5 or 10 seconds until he went unconscious. I'm sorry, how many seconds is it okay for them to have been in pain and panic and confusion? How about it wasn't okay for 1 second for any of those children to feel that? And they all felt it, all for up to 30 seconds. And then she continued strangling their limp bodies for 1 to 2 minutes to make sure they were dead. Deliberate premeditation. And then extreme atrocity and cruelty. The indifference that she showed to their pain, to their struggle, to their suffering, leaving them there on the floor with the bands around their necks, completely indifferent, because she had a plan and she was following it through. Just think of that. The being strangled and the pain and the confusion that they're going through, and it's being done by their mom. Their mom is the one that's hurting them. Their mom is the one that's killing them. That's extreme atrocity and cruelty. She didn't see them in that moment as individual human beings with rights, with dreams, with futures, individually belonging to them. You heard about the 3 kids. Cora wanted to be a doctor and a mom. Dawson wanted to be a firefighter. Callan never got the chance to dream. Who knows what future he would have dreamed for himself. She killed them, and she left them there on the floor with the bands around their necks. She didn't bring them up to their beds and put them with their favorite stuffed animal and cover them up gently and lovingly, leaving them peacefully there. No. She left them discarded on the basement floor like broken toys because she was done playing the game. You know to a moral certainty, she is guilty.
And with that, now in real time, a jury of 12 has the case. They've been at it 15 to 20 minutes. We have our viewers from YouTube who are watching along with us now. And next we go live to Massachusetts, where Ted Rollins is outside that courthouse as the jury is weighing their decision. These closing arguments, the last thing that they heard inside of that courtroom, and now they have a long list of things they have to weigh between first-degree murder, second-degree murder, manslaughter, not guilty by reason of insanity, which is not guilty and not criminally responsible here in Massachusetts, or not guilty of any crime.
Coming soon to Court TV.
She got 2 shots to her head.
Former American.
Yep.
can you get that little referral request I sent you?
Hey, we'll see what happens. 150, and I'm try to take a picture. I forgot. 150. There's no real lunch, so I'm just saying 150. Sounds good.
Just so you know, the alternate did not get up and leave, so I told him about the numbers. Usually it's 3 men and 3 women have been dismissed. I don't know if all times with these out of me, I gotta go through all this shit, but they usually put things out that women email on.
Hey, Tim. Is 115?
I'm not up there. I'm going to be editing, so I doubt what's anything. Keep trying for it.
Welcome back to Court TV Live. I'm Ted Rollins outside the courthouse in Plymouth, Massachusetts, where the jury now has the case against Lindsay Clancy. After hearing
All right, a bit going on with the feed there, but our Court TV anchor Ted Rollins is there on the ground outside of the courthouse after being inside of that courthouse. I'm not sure if we have his audio back. I know they'll let me know when they do. But the big news this hour is we are on a verdict watch in that area, Plymouth, Massachusetts, where Lindsay Clancy's fate is in the hands of a jury of 12. There were 18 jurors overall who listened to this case throughout this 5-week trial. We didn't lose any alternates throughout this process, and there were 6 that were dismissed, and now those 12 are added. About 20 to 25 minutes they have been deliberating in real time. We have our guests that are standing by. We are going to be talking about this case, breaking down what we heard in the closing arguments, and when we get a question, any movement, any happenings outside of that courthouse, we will take you back into that courtroom live. So first, let's bring in our guests that are standing by. We have with us to discuss criminal defense attorney and former prosecutor Jack Rice, and we will go back outside the courthouse as soon as we are able to talk to Ted Rollins, and Dr. Priya Banerjee is there as well. Jack, Your first reaction to these closing arguments?
Wow. What an amazing case this has been. We don't see this very often, where you're watching two different narratives that are running side by side, and both of them have evidence. Both of them have weight. Both of them have power. And so what you're doing is you're taking all of this and putting this in the hands of a jury of 12, and to watch where they go. The strengths were there, the weaknesses were there. We saw them during openings, and we saw them throughout witnesses, and even during direct and cross. So when we saw that disconnect, that dichotomy during closings, I don't think any of us should have been shocked. This is exactly what we expected to see. And I think sitting right now with that jury of 12, I just wish I could sit down with those 6 alternates and sit down and talk about how it felt. What did they feel? Don't give me specifics. Give me feel. That's what I want to know.
Oh, they had to have felt so much, Jack, during these closings. I mean, just how the defense started with showing these 2 photographs, one of the family of Lindsay Clancy. And keep in mind, the defense goes first in commonwealths like Massachusetts, and there's no rebuttal argument by the prosecution. It's just defense, then prosecution. So the defense went first. They were able to show that comparison of this beautiful family and then her in a hospital bed, bloody. And he's saying, what made them go from this to this? And then there was the moment of him slamming the quarters down, showing all of the things that the prosecution, in Kevin Reddington's words, used to manipulate this jury into believing that she is guilty of a crime. I mean, there were a lot of emotional moments that had to have resonated and pulled at the heartstrings of these jurors.
No question about it. Thinking about what Reddington did and why he did it was really important, because one of the things that he did is he leaned into the evidence. He leaned into what was being introduced, and he took the state's case, the Commonwealth's case, and he used it as tools. He took not just what he said during his cross, what he said during other cases. He was using their evidence, and I think that really, really was extraordinary to watch. He has been really quite masterful throughout this case, certainly through openings and what we expected to see, but his cross-examinations throughout the state's case and then through rebuttal were really something to watch. And I think for lawyers who watch, and a lot of lawyers watch Court TV, that this is where you learn how to do it right. And that was really impressive.
Really impressive overall from both sides, the kind of closings that we saw from them in front of this jury. Concise as well. We didn't have hours and hours. I'm understanding, Jack, that Ted Rowlands is back live. We can go to him now in Massachusetts. Ted.
Julia, thank you. Yeah, just picking up where you and Jack were what you were talking about. The fact that Kevin Reddington wanted just to go 30 minutes, he said on the record, and the Commonwealth said, well, I need an hour. Judge Sullivan said 1 hour, and to your point, both sides were concise. It was a pleasure to listen to, because both, I think, you could argue, had that jury captivated. But let's bring in someone who can tell us for sure how the jury felt. Sierra Gillespie, the host of Scandal, the podcast on the Law and Crime Networks, is with us. You were in the courtroom for the entirety of the session today. Take us through it, starting with Reddington. What was the jury reaction?
Yeah, Ted, I was literally in the front row. So it was me and then the jury and Reddington right there. And I think you're right. I mean, they both were very captivating. The fact that Reddington went the full hour, he took us through everything, same with the Commonwealth. And I will tell you that the jurors were paying attention. They weren't writing in their notebooks, as I've seen whenever, someone's testifying. However, they were locked in on whoever the witness was at the time. They were clearly paying attention. One juror I noticed was almost holding back tears, and this is during Reddington's closing when he was talking about the suicide attempt that Lindsay Clancy had, and she visibly looked shaken. I mean, we have to remember these are harrowing details that we're talking about here, and he mentioned that too. The jurors have seen really disturbing images. You're going to carry this with you for the rest of your lives. And so they really were taking it seriously during his, closing argument. And then the same for the prosecution. I mean, I think both sides were pretty strong and concise.
The follow-up there, the juror that was moved to tears, do you know, did she make the final panel?
See, that's what I'm struggling with, and I literally am trying to figure it out because I ran outside to come on live with you, so I need to go back and check my notes for everything because I wasn't sure where one starts and where it goes, but I will get back to you on that because I got to figure it out.
That would be something very interesting to know.
Right. I will say, I'm sorry to interrupt you, but one of the jurors I know for sure was seated because I kind of kept an eye on him. He didn't take notes at all. He, this morning when the judge said, okay, everybody pull out your pamphlets if you want to follow along to the jury instruction. Every single juror following along. This man in the back row, no, he didn't even have his pamphlet near him at all, and he was seated.
Was this the big guy with the beard?
Yes, that's him.
Okay.
I've never seen him take notes. Nothing like that. So it's interesting that we have someone like that on the jury too.
And he is on the jury.
Yeah,
okay.
Definitely.
Any other observations in terms of Lindsay? It seemed as though Reddington was pouring his heart out really to this jury. At one point saying, I love this girl, this kid.
Yeah, I thought it was interesting he kept calling her a kid, but when I was speaking to him yesterday, it's almost like Lindsay is a daughter figure to him. He literally said, frankly, I love her. I care about her. I only found out about postpartum depression and psychosis because of this case, and I'm mad at myself that I didn't know more about it before this. I think he's really, truly passionate about this case, and it shines through and the way that he's talking. But Lindsay, to your point, she was crying during closings. At one point I saw her hands were crossed, almost like she was kind of trying to center herself. She was kind of shaking at one point. She was so, really emotional during both the closings for Kevin Reddington and then again during the Commonwealth when they were talking about very methodically the way that she went through, strangled the children, talking about Patrick coming home, the 911 call. She once again got emotional and was crying during all that.
I did notice that when Rich panned the camera over to her. What about the quarter game where Reddington threw the quarters down like a billiard hall? I challenge you, Commonwealth.
Yeah.
Did that resonate?
Honestly, I don't know. I think that some of the jurors were kind of confused. He mentioned, okay, if you play pool, this is what happens, but it kind of was an offhand thing. So when he kept going back to the quarters, I saw a couple it was kind of, they're trying to make sense of it. And I do think that it was interesting that when the Commonwealth went up, started taking the quarters back. So, definitely by the end, they were clocking, okay, the quarters mean something.
Yeah, those quarters was certainly a moment inside of that courtroom. And I'm glad to hear Sierra say that it was a bit confusing for some of the jurors because when I was watching that part, I wondered why the use of quarters. We haven't heard anything about quarters throughout this trial, and now we have this demonstrative aid of quarters inside of the courtroom. And is there enough information for these jurors to understand it? But it certainly was something that I know caught their attention. I think we are going to work on the feed out there in Massachusetts. There's a lot of people there. We've heard from everyone. Sometimes that impacts the cell signal, our camera signals. Everyone anticipating what is going to happen inside of that deliberation room. Will we get a verdict today? What is going to be the response from jurors? Sometimes there are questions. Don't go anywhere. You won't miss a moment here on Court TV and the Law and Crime Network.
And then we'll end up Yeah. We're just from up here. We cover so much ground. I travel the country like 10 months a year. So yeah. I've been to all 50 states, but you chose a good route. Are you going to skip New York? It's like too much ahead of you drive.
I've been to, you know what? I let him pick the itinerary.
Okay, I like that.
Honest with you. And like I did say a couple of weeks ago, I said, hey, if Lindsay Clancy trial's still going on, I'm going. And we just got here yesterday, so I got up and drove over here today. So yeah.
Are you ready to Plymouth? Are you still in Plymouth? That's what's happening.
We're in Boston.
Oh, you're right. Okay, so a bit of a trip for you.
Yeah.
Well, good for you.
So it's I need to go. My phone is about to die.
Oh no.
Of course. No. So
So yes, apparently from what I've heard, it's 1/3. So you're at a prime. You're actually. I might be closer to you too because you can see from the other. You're actually in a very prime location. So he should be like right here.
Well, thank you. Thank you for sharing your wisdom.
If you're interested, feel free to drop a comment and say hello.
Oh, I will. Yeah. I will.
And who knows? If they take forever, they might go until tomorrow. So maybe it's tomorrow.
Okay, yeah. Have a good one. Thank you. Yes, thank you.
Welcome back to Court TV Live. I'm Ted Rowlands outside the courthouse in Plymouth, Massachusetts. Also want to welcome our YouTube audience on the Law&Crime Network and on the Court TV YouTube network as well. We are in verdict watch. This case, the case against Lindsay Clancy, is now in the hands of 12 men and women that were selected to serve as deliberating jurors. They have been at it now for over a half an hour. Likely eating lunch, picking a four-person, just getting the first steps out of the way. Of course, this group has been together for 5 weeks, a huge part of their lives. They have shared some incredible experiences of, frankly, despair. They've watched and listened to things that most people will never in their lives, and they're now having to digest what to do with this woman in the wheelchair. Sierra Gillespie, host of the podcast Scandal, is with us here on site. Also with us, Jack Rice, criminal defense attorney, and Julia Janae, Court TV host and attorney as well. Sierra, we were talking about the quarters, and Jack and Julia picked up on it. Anything else stand out to you during the closings that really seemed to resonate on either side?
I do think that the jurors were paying attention to Lindsay and her family. At this point, it's been the same people who've been in the courtroom. To your point, Ted, 5 weeks, these people have shared a lot together. And while, of course, they're not talking to Lindsay or her family, I think it's easy to pick out who they are. And at one point, her grandmother was clearly crying during some of these closing arguments, and Lindsay was too. And I think it's just really stark. When we're all standing and Lindsay is still seated, you know, when you're all rise, when the judge or the jury comes in, everyone is standing except for Lindsay. And so I think that is what's going to be in their mind as they're heading back to start their deliberations. I mean, that image, you just can't get it out of your head.
Jack Rice, it's a good point. There is basically a constant sort of message from Lindsay in that chair to the jury that this woman is, regardless of your decision, 12 citizens, is going to pay for this for the rest of her life.
Ted, you're so right. That is exactly what it is that this jury is watching. And when we think about all of the witnesses that have been put on by the Commonwealth and those have been put on by the defense, and you realize whether she spoke or not, Lindsay was the witness that everybody watched. Everybody who watched any witnesses would then turn, and all of those jurors would turn and pivot back and forth to see how Lindsay would respond to what was being said. Now, that being said, it's always interesting to see how any defendant responds to this circumstances. What we have seen from Lindsay from the beginning has been that of the grieving mother, of that person who was lost, that person who never stands up. And Sierra, that's a perfect analogy where everybody else is on their feet except for the one who can't, the one who never will ever. The price that she has already paid, let alone all of the other costs that have come along the way. And if we actually dovetail that with what Kevin Reddington did from the beginning during his closing, where he said, how did we get from this to this? How did we get from that space to the other? And that is also critical because it's the brutality of it all that isn't lost on Lindsay. She's feeling it, and the jury is watching her feel it. And I think that may very well play a very strong portion of where they go in this case, whether they get all of them or whether they get one. And of course, I'm talking about a potential hung jury.
Julia Janae, Kevin Reddington is an advocate we see every now and then here on Court TV, someone who truly is passionate, and he seems to be at a level I don't remember ever seeing, where he has a relationship with his client that being in the courtroom, you can feel it. Sarah will attest. This is a team. She doesn't say anything. She doesn't do much, but they're a team. Your thoughts on that and how it may or may not influence this jury? It may offend some.
I think it is a risk. I'm glad you pointed it out. I thought it was interesting what Sierra said about her being a daughter figure to him. There are times in closing arguments I've seen defense attorneys get emotional about their client. I saw one that cried actual tears for their client in front of the jury. And I do think that it is a risk because we're asking prosecutors to be very neutral. We want them to bring the law and the facts to this jury, to have been in their investigation unbiased, to only go where the evidence takes you. But then, as a defense attorney, you don't want to get too personal, I think, with your client. Yes, you want these jurors to understand who she is and what a wonderful person she is. He even said in the closing argument, she's a beautiful soul. The experts loved her. The chaplain loved her. Dr. Zeisel loves her. And you don't want the jurors to think, well, are you all then doing all of this out of love versus what the facts are? But it may play well with this jury. We will see.
Sprague, Jennifer Sprague, Sierra seemed to read the room, and the criticism for the prosecution up until today was that they weren't reading the room, that they were trying too hard or vilifying Lindsay too much, and it came off, it was off-putting. Today it seemed like they got the message and or just it was a different tone.
I absolutely agree. I mean, the Commonwealth brought a really strong closing argument, in my opinion. A lot of the things that they talked about were the mental health of it all. They said simply, you know, Lindsay was struggling. We're not going to deny that. We're not going to say that she wasn't going through something. She was trying her hardest at times, they even said. It's relatable. But then they went back to the choice that they said that she made, that this was intentional, that it was premeditated. I mean, they've been talking since January of 2023 about the Apple Maps. They went back to that and were very methodical about, okay, you know, she looked it up. It wasn't because she wanted Patrick back there with her to help her with the kids. It's because she wanted to have him out of the house. And I mean, they did go into kind of graphic detail talking about the strangulation. I think that's a tactic too, to talk about the kids, pull on the heartstrings of the jurors. And I do think that their closing was pretty strong.
Yeah, and Jack Wright, of course they're going to lean into that. Of course they're going to use that because it's part of the equation here. Someone said to me a couple days ago, if there was video of what she did to those kids, she would already be locked up. And the Commonwealth has every right, do they not, to remind jurors of what these three beautiful souls went through before they lost their lives.
Yes. Ted, absolutely they do. And in fact, as a former prosecutor, when I'm watching how any government entity prosecutes a case, what I'm also remembering is that they need to make sure that the jury feels the loss. And when they held up those footy pajamas during the trial, I was outraged by it, meaning it worked so well because this is the loss that they should feel. And frankly, what I want from that jury, if I'm prosecuting the case, is I want them to feel retribution. I want them to go after her for the murder of these 3 kids. And this is not just an academic exercise where they intellectually decide and weigh every piece of evidence and say, I've decided that they have met the burden, meaning the Commonwealth. Rather, I want that jury, if I'm prosecuting, I want that jury to look at this and in the end, viscerally, in their guts, feel, I refuse to allow her to leave this courtroom. I want her in a jail cell. And that takes emotion. And I think that the Commonwealth was desperately in need of it. And I think that that was one of their mistakes during openings because it felt manipulative to me. I thought it was not there and missing during their case in chief and even during their rebuttal to some degree. I've been waiting for it, and finally today, they started to deliver it. And I think that may drive this jury a different direction than they would have gone otherwise.
Julia Janae, the actions of Lindsay Clancy to you, which are the most difficult to get over if you're the defense? Is it sending Patrick to the restaurant, looking how long it will take? Is it her statements before and after? Is it the fact that she didn't hear voices before or after the children were killed? What do you think is going to be the biggest hurdle for a juror who just thinks that there's something off with Lindsay's behavior outside of killing her kids?
I do think that they may struggle with the lack of signs of psychosis. There were several experts who took the stand to talk about what psychosis looks like, that others may be able to tell because they are reacting to internal stimuli. They're talking to those voices that they are hearing. They are out of it. And I think the defense really didn't have those things that they could highlight to show that she was in this state. We're really having to take Lindsay Clancy's word for it. And that's the word of someone who the defense says was in psychosis. So is it believable? She's not got any reactions from Patrick where he says something seems wrong with her. No one who talked to her on the phone in terms of the CVS workers or the 3V workers, none of them picked up on anything different about her in this state. I think the defense tried to highlight what they could in saying that there was this mix-up with the chicken nuggets and that she started writing strange in her journal. She's writing chicken scratch, and that shows that her mind was gone. But there's no real other thing that others can point to where they can say her mind was gone. She was still operating day in and day out, handling the care of 3 children, the care of herself, the care of her home. There weren't things that Patrick could say she had started to lapse in that you sometimes see, where she's unable to keep the home in a certain way. She's not taking care of herself. They don't have that. So I think that may be the biggest hurdle. I think Kevin Reddington did a very good job of pulling out from these experts why that happens sometimes, and that you can operate normally and that you can still do this and be in psychosis. But I think when people try to relate this to anything else that they have seen in their life, if they want a reason to side with the prosecution, that may be where they hang their hat.
Here is Attorney Sprague talking about just that, the fact that Lindsay was in total control of everything leading up to and even during the killings.
And then we get to January 24th. Everything that happened that day, every person she interacted with, every situation she was in, shows you she knew the difference between right and wrong, and she could conform her behavior to the law. The doctor's appointment first thing in the morning. She's able to drive there. She's able to interact with medical professionals. She's able to seem absolutely fine and normal. Able to get home from that appointment. She plays with the kids. She takes them outside. She's sending those messages and photos to her mom and to Patrick, basically saying, look, this is a good day. I'm having a good day. Everything's good. I'm getting better. Here's proof. This is what I'm doing.
Big part of the case and a big hurdle likely for jurors. Sierra, tell us how is this going to work from what we know from the court staff, when there's a question, when there's a verdict, what kind of a lead time, and how will we know?
Yeah, there's a lot of options here, right? Because we know they're deliberating, but they could have a question. They could have a verdict. If they go until the end of the day today, they could say, hey, we're kind of tired. We want to go home. Can we start again tomorrow? I mean, there are a lot of things that the jury may need to communicate with the judge and the attorneys and whoever it may be. So I spoke to the Commonwealth, and what they told me is when there is a verdict, everyone will have a heads up. And this makes sense for the media, but also for the family that want to be there and see what it is, you know, eventually what they decide with the verdict. So there will be about a 30-minute heads up, according to the Commonwealth. And when there's a question, most of this is going through our photographer, Rich. So he is the person who's filmed everything that you've seen, whether it's on Court TV, Law&Crime, wherever you're watching. He is the guy behind the camera, kind of following who's talking, all of that. He's kind of become known throughout the courtroom. They love him, and they're going to give him a heads up as to here's the question, here's the verdict, whatever it may be. He'll let us know, and then we'll bring the answers to you.
It's safe to say, through Rich, we'll be the first to know if there's a question or if there is a verdict.
Exactly.
We'll slip at a commercial break, and then we will get back to dissecting not only the closing arguments, but the entire case, starting from the opening statements, Patrick on the stand. It has been 5 weeks of testimony. The jury's taking it all into account. We've got lots to talk about. Stay with us. Our continuing coverage of the deliberations in the Lindsay Clancy case continues from Plymouth, Massachusetts. Stay with us. Homeowners. Welcome back to Court TV Live. I'm Ted Rollins outside the courthouse in Plymouth, Massachusetts, with our continuing coverage of the deliberations of Lindsay Clancy. We're in verdict watch. They've been at it, this jury of 12, for about an hour, about 55 minutes now. There's a live look inside the courtroom and the seal. Our camera is still there. As soon as there is a question or a verdict, of course, we will immediately go into the courtroom. With us is Dr. Priya Banerjee. She is a board-certified forensic pathologist. Jack Rice and Julia Janae still with us as well. Dr. Banerjee, this case, this jury has seen some things that nobody, except for maybe someone in your profession, should see. How does that factor in when you've got the person who killed 3 children sitting in the same room?
Well, even for me, someone who's seen, unfortunately, deceased children, this is probably one of the most horrific family-oriented cases I've seen. You know, it's not, unfortunately, just the death of one child, 3 at the deaths, at the hands of their mother. And as a mother myself, like, that is so hard to even think about. I think when they see the cords and evidence, like the exercise bands, and understanding that it's not an instant death, I think that's a very traumatic thought process, and that it was repeated 3 times, right? That it wasn't just once with one child, it was over and over, and that is hard to stomach.
Knowing what you do about how the children passed away, your opinion, how long would it take to carry this out?
Right, so it's a very physical act on each child. It's up close and personal. It's going to take minutes per child. So, you know, it can be up to 30 seconds, as was said by the experts, for an individual child to lose consciousness. It's continuous pressure on the neck with the band. It's not just holding it lightly. You know, it has to cut off circulation to the brain. And then on top of that, it's 2 to 3 minutes to then have irreversible brain damage, to die from it. So it's longer than you think. If anybody tries to hold a position for that long, you know, it's very purposeful. And I think that's one of the hard things to stomach, that the mom is, you know, Lindsay's doing this 3 times. The psychosis, if it, you know, if you believe it's present, is telling her to do this continuously for that duration times 3.
And Callan, the 8-month-old, probably does not really understand anything, but
correct.
The other 2 absolutely figure it out.
Right. And I think the unfortunate part is the older children, I'm sure, had some fight in them. You know, just the nature of how we're built, the reflexes that come into when you're being strangled. You try to protect your neck, you try to get the ligature, which in this case were those exercise bands, off the neck. It's just, it's not an easy way to die.
Jack Rice and Julia Janae, Jack, does this, how do you get over this if you're a juror? And has the defense done enough to get over it in terms of their explanation of the psychosis?
I think that's the weak space, Ted, right there, is the psychosis question. If we think about this on a spectrum, right? We have the Andrea Yates case from years ago, where what we had were voices upon voices upon voices. Well, she was found guilty the first time around, but when she came back, she was ultimately found not guilty. And I think a big piece of that had to do sort of with the string of psychosis over time. And that has real power. Now, what we normally see in many cases is we have the other end of the spectrum, where there was nothing out there at all, and then after the fact, somebody says, oh, I was hearing voices, or somebody told me to do this, or I'm severely mentally ill, and there's no string, there's no line that tracks before the incident. So that's the spectrum. Well, the thing is what Lindsay is she sits dead set in the middle. And so she's in that space where there's mental illness, no question about it. There's postpartum depression, no question about it. The question is, if there is psychosis, why is it we only get the one voice? And now there's ways to look at this and say that in isolation is not what you look at. You look at the holistic view of psychosis, and that should be enough. But if you look at that strength, that comparison of those three different positions, and then you put those three babies in front of a jury and you say, she strangled them to death, and you make them look at it like it's on a teeter-totter, you may get many people who will say, I don't care. I don't care whether she was mentally ill. I don't care whether she had postpartum depression. I don't care whether she had postpartum psychosis. I don't care. And because of that, they might try to find her guilty and convince everybody else in the room to find her guilty to pay for what she did to those three kids. That's the weakness in this case, and that's what Kevin Reddington has been having to fight from day one.
And Julia tried to fight it a little bit with the intrusive thoughts, the horrible thoughts that Lindsay logged in her diary, that almost to equate that this voice was the culmination, the crescendo of these thoughts that were internal throughout the months and weeks leading up, and he tried to bridge that gap. Difficult to do, though. Your thoughts on whether he was successful or possibly successful?
Yeah, Ted, let's talk about the diary, because you asked me about what the weakness in their case was. I think the strength in this case is the documentation. Coming at this from a lawyer who's represented people oftentimes who are injured or who've been dealing with things and now they want to sue someone or want to go after someone for what has happened, one of the most challenging parts of that is, even though they've felt what has happened, they know what has happened, they realize now after many months that this is the cause of what happened, there's oftentimes not a lot of documentation. They haven't seen professionals who put it in records. They didn't take diaries or journals of things. Lindsay Clancy is this very unique defendant because she was a nurse, because she was someone who was very organized. She documented everything that was happening to her. We have her own words being used as evidence inside of this courtroom, her own journals, talking about what her mind was doing. It's a unique perspective that we don't usually have in a case that involves an argument of insanity. But here I think that helps for the defense. They can show these jurors, even though the prosecution tried to show that, okay, if she's so organized, she should have been better with how she handled things and should have done more to try and get herself better. But I think the defense can show, look, she was watching what was happening, and you can see the decline. You can see where she starts to reach out to her family for help. She is struggling. She's writing down that she's struggling. I think that's the most powerful thing for the defense in this case, that they have that documentation.
We should mention we're at the 1 hour mark now of deliberations in the case against Lindsay Clancy. Dr. Banerjee, that history is a big part of the equation when you investigate it. In your profession, it's not just an autopsy, it's everything.
It's everything.
And
Everything.
having that is key.
Oh, it's huge. So when I talk about any case, I say that we don't practice in a black box, right? When you look at this from a forensic standpoint, yes, the manner of death is homicide, okay, because it's a death at the hands of their mothers. But when we look at it sort of more holistically, right, we're bringing in not just the autopsy, not just that forensic definition, which is different than a legal definition of homicide, okay? And that's really why I think we're at court, right? Can this be in some ways, I don't want to say justified or rationalized by her psychiatric history coming into play? I mean, that seems to be the whole, right? The experts were really psychological and psychiatric experts. No one is debating why the kids died. It's under what psychiatric circumstances did that happen.
And what led to it?
Correct.
Why? Why did this
Correct.
mother with no history of anything but exemplary behavior at work as a mother? Jack Rice, the backstory of Lindsay Clancy is a huge part of this equation, is it not?
Oh my goodness, it sure is. When we think about who she is, and I appreciate the doc's description of this black box idea, which, by the way, is what the Commonwealth is trying to do. They're trying to say, there was one voice, it was one time, there was nothing before, there was nothing after, look at the black box, that should be enough for yourself. And they're trying to look at it myopically, whereas Reddington's on the other side saying, let's go holistically. But if we look at this long story of who Lindsay is, but I could even make it a short story that's a long story. Let's go to January 24th of 2023. Let's go to that day. She's in the backyard building a snowman with her babies. But she's also making sure that her babies, or at least one, is getting their meds. So my question is, and this is in some ways parallel to what Reddington did, how do you go from building a snowman and making sure that your kids are okay to strangling them with your own hands in a basement, one after the other after the other? I want you to think about that gulf. Now, that's a subjective argument, but think about just how far somebody has to go to say, I need to make sure my babies are okay when they're building a snowman and taking meds, to several hours later, strangling them to death with my bare hands. Who has the capability to do something like that? That is a strong point and a visceral point that I think Reddington might have been able to hit a little bit harder than he did, because I think big picture with who she is, but what happened to her on that day is something that could in itself drive the jury to say, nobody in their right mind crosses that gulf that fast unless they've lost it.
And we heard a tone of that from Kevin Reddington in the closing arguments, that he has put his attention on several things, the doctors, the medication, but also the Commonwealth. He made them out to be villains and made her out to be a beautiful soul with numerous references to her character. And at one point, he basically came out and said, these people have mistreated my client, Lindsay Clancy. Take a listen to a bit of Reddington's close on that subject.
And she's the evil woman that killed the 3 innocent kids. And they're going to stand there while she's chained to the bed, paralyzed. You heard testimony from Dr. Zeisel. They weren't little fluffy cuffs that were securing her to the bed. They were handcuffs, not the medical treatment. Medical treatment would be, like restraints, so you don't do whatever, pull lines out and things. We're talking about when the big men were in there with their guns and their badges and they're sitting outside the door, and they're going to make sure that Lindsay Clancy, paralyzed, chained to the bed, doesn't get up and run away from the hospital, I guess, and they just have to suffer their way through. I guess I worked 8 hours. I had another shift I had to work that night. This is the treatment.
Julia Janae, that theme, it wasn't just closings, it was from the openings and throughout, his sort of disgust at the treatment of my beautiful, lovely, souled client, who, by the way, killed her 3 children.
It was really masterful in the way that he made sure these jurors at the very beginning of his closing that he took aim at the people he believes are to blame. Not necessarily to blame for the deaths of the 3 children, which I thought it was good that he took that moment at the very top of his closing argument to have really a quiet, somber recognition of who the victims are here. But then he immediately almost did this 180 where his energy built and he started taking aim at not only the prosecution for even bringing this case, but also the investigators for not getting the medication bottles that were in the house, for not collecting enough evidence, took aim at these doctors that she was treating with, saying that they weren't getting her the help that he needs. So he gave these jurors other people to look at, even though really when you're talking about the death of these 3 kids, Lindsay Clancy admits to it. There's really not anyone else that either side is saying did this horrific thing, but he gave them other people that they need to be questioning in a case that's got so much tragedy around it. I do think that it was an effective theme in front of this jury to keep reminding them of the other people who could have helped Lindsay Clancy, even though jurors still have to grapple with, in that moment, she was the only one in charge of her children.
Yeah, absolutely. It has been from the very start a fascinating case, and we're here until the very end. If you're watching along with us on Court TV or on one of the 2 YouTube channels, the Court TV YouTube or Law&Crime YouTube channels, we got you covered. We're not going anywhere. As long as that jury is deliberating, we'll decide this courthouse. And if there's a question, or a verdict. Of course, we have you covered. Our photojournalist, Rich, is the first call that they will make if there's a question or a verdict. So let's get a break. We'll continue to mull over the closings and go back. Think about the beginning of this. Patrick Clancy, first witness out of the gate. We were riveted by him. A lot has happened since then. Back after this, our continuing coverage of the deliberations of the Lindsay Clancy case continues. Roll is outside the courthouse in Plymouth, Massachusetts. We're inside the jury deliberation room. 12 men and women are deliberating the fate of 36-year-old Lindsay Clancy. The former labor and delivery nurse admits that she killed her 3 children. Now it's up to this jury to determine whether or not she is criminally responsible. It was a day of closing arguments and instructions before the jury got the case. Both sides had an hour to use. Reddington used about 50 minutes or so. The Commonwealth right in that same area. Then the final instructions, and they were off. Dr. Priya Banerjee is with us, Jack Rice and Julia Janae. Dr. Banerjee, this case is about mental health. It's also about postpartum depression, and a lot of people have come out, they've been watching this, they've been moved by it because they've felt versions of it. They've felt, they've gone through a version of it, of course not to this extreme, but they seem to gravitate towards Lindsay's struggles. Your thoughts?
Well, as being a mom myself, you know, it's overwhelming to become a mother, have a new baby, whether you've done it once, twice, or 3 times in this case. You know, I think in some ways it's harder, right? You have other children to care for and a newborn. That being said, I find it interesting that there wasn't more medical attention to her prior history of mental health, you know, challenges like postpartum depression, and that wasn't seen as, in some ways, a contraindication to getting pregnant again. You know, and I make this analogous, like if you have a bleeding disorder where having a baby would put you at risk for bleeding to death, they would say, oh gosh, like that's not safe for you medically. And I think people sometimes, you know, separate mental health from physical health, if you will. But I look at it in totality, that it should be considered part of her health. You know, that's what really has impacted her and the family and led us to this.
Yeah. Jack Rice, the reality, though, is that mental health has always been getting better, but in a separate category. And there seems to be an optimism with mental health that you don't have with a cancer diagnosis or a broken bone. You know what you're dealing with there. This is different, and that may have played a part here with the optimism that Lindsay thought she was going to get better. Patrick thought she was going to get better. The in-laws, her parents. She's struggling, yes, but things will be okay. That permeates, does it not, into the cycle? The warning signs were there, and nobody, including Lindsay, did anything to stop this.
Yeah, Ted, I've been doing this in courtrooms for almost 30 years, and I've watched these so many times that I've stopped counting. Now, the concept that health is a wonderful and actually accurate approach, but that's not what we see in the real world. There is a wall that's 100 feet high between mental health on the one side and physical health on the other side. And in fact, and when we look at Lindsay Clancy, you look at this issue of postpartum depression as postpartum psychosis, and even generally speaking, mental illness. There was a time when we said it was the devil that did this. It was the devil that made this happen. And then there was a time where we would say, this is malingering and it doesn't exist because we can't read it on a microscope. But it does exist. And in fact, when we talked about the Andrea Yates case, that was about the bubble where you started to see more and more people shift and starting to say, yes, we acknowledge that mental health is real, that mental postpartum depression is real, and maybe even psychosis is real. I know Julia and I have talked about this a lot in studio and elsewhere about what happens when juries just can't make that connection.
Mm-hmm. Well said. We need a break. The jury has been at it well over an hour. We are here. We'll take a break and continue our coverage right after this.
I'm Vinny Politan, and this is the all-new VPI.
Welcome back to Court TV Live. I'm Ted Rowlands outside of the Plymouth County Courthouse in Plymouth, Massachusetts, where, as you can see on the deliberation clock, the jury in the Lindsay Clancy case has been out for almost an hour and 20 minutes. Not a long time, considering the 5 weeks they have been together through the voir dire process, the selection process, and then the evidence, starting with the opening statements, that horrific 911 call, and the testimony from the experts. It's been a lot. They have a lot to digest, and we've got all the time in the world. We're going to be with you until there is a verdict in this case. We've got you covered, not only here on Court TV Live, but also on the Court TV YouTube page and the Law&Crime YouTube page. We're glad to have you along with us. Our photographer, Rich, that's his camera inside the courtroom. He'll be the first to know if there is a question or if there is a verdict. Sierra Gillespie is with us. She is the host of the podcast Scandal, along with Jack Rice and Julia Janae. Julia is at the Court TV studios, Jack in Minnesota. Sierra, we've been talking about the mental health portion of this, and it's amazing how many people have come out of the woodwork. I met a woman out here today that drove from Indiana who has suffered from mental illness for a long period of time, and she's really drawn to Lindsay on the prescription side. You know, there's the postpartum, there's the bipolar, but hers was directly at the prescription meds that she says she has gone on and off of for years. It's an inexact science, and to expect this jury to come up with the answer it's an interesting position we've put them in.
Oh, yeah, I agree. And I mean, just me, myself, following this case, I was taking a look at all of the prescriptions that Lindsay was on, and I thought, okay, wait, I've tried a couple of these myself, you know, and I wonder, too, if the jurors may have, because some of them are relatively common. I mean, we talked at length about how Lindsay was prescribed Prozac way back in college when she got anxiety when she was heading towards exams. And I mean, we've all had anxiety at some point, whether it be for exams or work or whatever it may be. And I wonder if some of the jurors may have dealt with that, too, if they can relate, if they've been on any of these medications, and I wonder if they're going to take that in with them to the deliberations.
Absolutely, and Julia Janae, that is something that more people can relate to than postpartum depression or, for sure, psychosis. That medication prong of the defense is an arrow in their quiver, is it not? It's part of the full picture that they're using.
Yeah, because I think it impacts so many people across the board, even if not to themselves personally, to someone in their family, someone they're close to. That's likely why the prosecution had to come out in their opening statement and tell this jury that this case is not a commentary on mental health. This is not a case about postpartum depression or the conversation around it, which I don't know that I agree with that. And clearly there are so many people who are watching this trial who don't agree, and they believe that this case is a litmus test. It is a question of mental health and how it is handled in this country. And Kevin Reddington used that in his closing argument. I talked about the other people that he left for this jury to take aim at the investigators, the prosecutors, the doctors who may not have done everything and missing the signs. But he also took aim at the country, at the U.S. He compared this country to other countries and said that if you go to those other countries, you will see better attention on postpartum, that the DSM doesn't do a good job of making it a diagnosis, of saying that it can last more than 4 weeks. And it is a question that I think touches a lot of people. The length of maternity leave in this country, the access to mental health resources. Saying that it is not a conversation about that and it is not an indictment of that system, I think may be a bit misguided here.
Is it Jack Rice, Kevin Reddington that has put everyone else on trial but his client somehow in the death of 3 children? Or is it the circumstances as a whole?
There is a villain in this case, Ted. There is a villain, or maybe a group of villains, but there is certainly a villain. And the debate, obviously, between the Commonwealth and Mr. Reddington is exactly who that villain is. However, what it is that Kevin Reddington has done so successfully is that he has said, but for the failure of the medical establishment, this would not have happened. These poor children would not have died, and this poor woman would not have been brutalized as she has. And you take this cocktail of drugs and lay that over the mental illness. And by the way, one particular med that she was on was an antipsychotic. Now, sit with that for a second and imagine if you're sitting in the jury room deliberating right now and you're asking yourself, how good were these psychiatrists? And by the way, one of them had been practicing essentially about a month, never saw her directly in person and wasn't an expert in this and never actually saw never saw postpartum psychosis in her career, nor did the other one, by the way. But imagine being one of those jurors and simply saying, why was it that somebody gave her an antipsychotic if she wasn't psychotic? It's a question, but it's one that may resonate in the head of one or more of these jurors. And it also might be one of the questions that one of them is asking in the midst of deliberations, because there may not be a clear answer to that.
Yeah. There is no clear answer. This is an area where there are no clear answers. Every patient is different. Every reaction to medication is different, and that is being brought out in this trial as well. Both sides used Lindsay Clancy's notebook, her diary of what she was going through and the medications in their closing arguments. Kevin Reddington looked at it and said, look, intrusive thoughts, horrible thoughts, horrible thoughts. Then she goes dark. And his assertion is, at this point, her brain is gone. She's gone. Let's listen to that, and then we'll listen to the Commonwealth.
You look at her journals that she took, you'll see, as you go along, in the dates that she's recording in these journals, she's talking about the drugs that she was prescribed. And look at the first page. Look at how detailed. Dates, how she felt, 10 milligrams Prozac, and it goes on like that, goes on through November into December. December 9th, 10th, 11th. Horrible intrusive thoughts. Horrible thoughts in the AM. Horrible thoughts. Horrible thoughts. No motivation. And then finally, horrible thoughts, no motivation, deeply depressed. Then, that's around the time she went to Women and Infants Hospital, right? Looking for help. Look at this. As she runs into January, there's nothing other than little chicken scratches because her mind was gone. In January, as she's on these drugs and she's suffering from what you've heard is postpartum depression that can lead to postpartum psychosis, and you have these men coming in here that don't even know psychosis from schizophrenia as experts, telling you that if a woman doesn't have these symptoms, like it's a disease, symptoms of postpartum depression within 4 weeks. That's it. Lights out. You're not a person that can be considered.
And if you look at their journal, you look at this journal that defense counsel showed you, she's very detailed, excuse me, about when she took medication, what she took, the amount she took, what the effect was for months, starting in October and going all the way up to January. And where it stops, January 18th. Someone who's been so meticulous about everything all the way up to January 18th, and it just stops. And it's as if she's decided she's done trying. She's decided that it's too much and she doesn't want to do it anymore. And so she just stops keeping track.
Sarah Gillespie, the jury, during both of the closings, some people online are like, Kevin Reddington's act is getting old. He brings so much raw emotion. Did you feel any of that, or were they just as glued to him today as they were in the openings?
I mean, Kevin Reddington demands your attention, right? If you're watching back home and you've been thinking, wow, he's really captivating, imagine what it's like to be in the courtroom in the front row as we were watching this, or the jurors to be one of them. I mean, I think that they were all paying very close attention. It's hard not to. He makes a very compelling argument, and I think he does a good job of pulling on the heartstrings of the jurors, kind of recapping everything that he's presented so far and reminding them his points that he has. I mean, we talked about just in that soundbite the journal entries. I mean, it is a very stark thing to see her early on writing down what she took, what the symptoms were, because she was very worried about that. She had her background as a labor and delivery nurse. Of course, she knows about medications, and she wants to make sure those black box warnings aren't going to affect her. So she's being really responsible, and I do think it's stark if you look at her journal or her medical entries there, looking from the start in October or November to January. That is pretty compelling to me.
Yeah, and our cameraman Rich was right there. He zoomed in on the journal. That was compelling because you saw her writing. Julia Janae, the Commonwealth prosecutor Sprague, did something. She was on her game today. She took not only the quarters and threw them back basically at Reddington, but she took his journal and she had her own explanation. Your thoughts?
Oh yeah, use that journal to say something completely different. I'm following the viewers who are commenting in our chat on YouTube, and one of them said something that perhaps I hadn't thought of when it comes to this journal. They asked, did she write in her journal how she was misrepresenting herself to clinicians, and whether or not they're talking about her not saying to her clinicians that she had these thoughts of harming her children or had a plan in place in any way. I don't know, but it's possible that jurors are wondering about that. I do think that journal was very effective in the way that it was used. But the prosecution, as you mentioned, they seem to have a different tone in their closing than they had during their opening statement. And they also took ownership of something that they hadn't before. Throughout this trial, it seemed like they were saying that she was faking this suicide attempt. And maybe that wasn't their intent, but every time they asked a question of one of the treating physicians, the people who were there on scene, the first responders, they were asking, was there a lot of blood? It didn't seem very deep in terms of the cuts on her arms and on her neck. You got the sense, if you're a juror, I would imagine, that they're saying she did this trying to cover it up, trying to pretend like she wanted to end her life, but really she just wanted to harm the kid. So I think it was very important that during these closings, they said, look, we are not trying to say that this was not a serious attempt. We're trying to say that her natural instinct kicked in and would not allow her to harm herself. That same maternal instinct didn't kick in to tell her, don't kill your kids, in the event that she was hearing these voices.
Yeah, it was a very nuanced way to repair what many people thought was damage done in the opening statements. And I think it did translate. Let's listen to Attorney Sprague basically say exactly what Julia did in terms of explaining. Do we think it's a real suicide or not?
We're not saying she didn't want to kill herself. We're talking about that third prong of suicidality that Dr. Satoff talked about. Remember, he talked about aloneness and feeling burdensome, but that third category, capability. She wanted to kill herself, but her natural instinct to live was fighting against that. So she took pills, but you heard the toxicologists, they were all at therapeutic levels or below, except the Seroquel, which was a little elevated. She cut herself, but you saw the cuts on the meaty part of her arm horizontally. No arteries, no major blood vessels. Didn't need to be stitched the next day. The one on her neck didn't need to be stitched at all. She knew as a nurse those weren't going to kill her, but she was trying. And then going out of the window, 12, 13 feet. And she landed the wrong way and ended up paralyzed on the frozen ground. But, you know, the idea that falling out of a 12-foot window is going to definitely kill you, not necessarily. And so she wanted to. She was trying in all these different ways. But she just couldn't get over that third prong, the capability of actually killing herself.
Jack Rice, thoughts on was that enough repair for the Commonwealth in terms of if you go back and listen to the opening and the questioning throughout the trial, superficial wound, this, this was a great explanation, and in your estimation, was it a good mop-up job?
No, I don't. I don't think it was a good enough mop-up job, because if it had just come out during openings, then I would have said, okay, and then the evidence as it was introduced. But what the Commonwealth did is throughout the case question this. They basically said she was faking it. They were saying that she wasn't really trying to do this. And they acted like that through the case, and on the back end to simply turn around and say, we know she wasn't trying to kill herself, except for here's the problem. We had evidence in the middle of the trial where somebody said she code blued. So if she's going to code blue and they have to bring her back, that sure seems like she was doing a pretty good job of it. And the problem is that doesn't work. And remember, what opening statements are about, it's about telling a jury what's coming, but it's also about something else. It's about establishing credibility and say, this is what I'm going to tell you is coming and how, and you can believe me. The problem is when you make a statement like that during openings and then pivot in the middle of the trial itself, or in this case, they didn't pivot, but then they flip it over on its head during closings. What that does for me is make me question the credibility of the presenter themselves. I've seen prosecutors fail to do that when they've done this like this. I've seen defense attorneys fail to do that when they have done something like this. And I think there may be somebody on that jury who will say, that's not what you promised us. That's not what you told us. And now you're trying to tell us something different. Do you think we're stupid? Do you think we're stupid? And there will be some people who may look at that and say, I'm not real happy about that flip you're trying to make, and we noticed.
Dr. Gregory Satoff was on the stand, Sierra, when Kevin Reddington did something that I'd never seen before. He read the prosecution's opening statement, a portion of it, to the doctor and said, do you agree with that? And there was an objection, a sidebar, but he was able to read it, and it was clear. We were both in the courtroom that this was, oh my gosh, he's reading their opening back at this expert who at the end disagreed. What a moment.
Oh, I totally agree, because when you think about closings, obviously that's the last thing that the jurors have heard, right? But before that, the last thing they heard was this final rebuttal witness, Dr. Satoff. So if in opening statements, Attorney Buckingham was saying, yeah, I don't know, was this actually a legitimate suicide attempt? To which Dr. Satoff, the final witness for the Commonwealth, says, I believe that this was a legitimate suicide attempt. I agree with what Jack was saying. It undermines the credibility of the Commonwealth. And I think that Kevin Reddington pointed this out on his closings as well. He said, okay, remember way back in openings when the Commonwealth was saying she just didn't want to be a mom anymore. She was kind of over it. She wanted to end everything just because of all that. He brought it back. To which Attorney Sprague, I think, tried to correct, say, talk about the mental health of it all. We do agree that she actually was suffering, but it wasn't justifiable. I mean, I think that was definitely a big moment, and I agree with Jack and what everyone's saying here, that they're definitely going to be talking about this during deliberations.
Julia, going back to that viewer question that was on the chat that you said, it's an interesting part of the equation because she did, as much as the defense and Kevin Reddington wants this jury to be convinced that this woman never lied, she never malingered, she did withhold. She withheld information to her providers about her intrusive thoughts because she did tell Patrick and her mother that she had thoughts about killing her children. So is she criminally responsible just by default because she knew that she was having these thoughts and she didn't stop them? It's a weird line, but your thoughts on how the jury might digest this?
It's a weird line. I think it was good that the prosecution, in terms of for their case, they brought that up. The places where she had to check. Are you having any suicidal thoughts? Are you having any homicidal thoughts? I mean, it's something now that's just standard. You can go in for a dental appointment and they will still ask you about the thoughts that you have in your head. And they do that for a reason. They want to know because they want to protect the public. And here, someone who's a nurse, someone who's a former labor and delivery nurse understands the importance of that checklist, understands how important it is to report correctly. And it seems that that was something that was omitted despite the fact that she was sharing with them her struggles, her intrusive thoughts, the fact that she wanted to get better, but she felt like she was slipping away. And the prosecution bringing up this, they didn't use the word selfish, but that was the theme in their opening statement, that she was controlling, that she cared more about herself, it seemed, than her kids. I didn't hear that emphasis during this closing argument, but I think they still wanted to show that in that moment, she didn't want to lose her kids. She didn't tell them the truth about what she was feeling because she made the rational decision to not tell them that information so that she could stay in custody of her kids. We don't know what would have happened if she had shared that, but this was something that she believed, and so they really just wanted this jury to believe that she took matters into her own hands. She saw her mental health declining, and she made the wrong choice. How will jurors take that? I don't think they prove that she was this controlling mom. I don't think they prove that she was selfish and hated them. They tried to bring up that she had these issues with Dawson during his early months and first year. But I think that failed, and so that's why we saw really a different tune in closing arguments where they more so say, yes, she loved her kids, but this altruistic filicide is what their expert talked about, where she didn't want them to be on this earth without her, and she had already decided to leave this earth.
Yeah, I mean, it could go either way where, yes, she was withholding these thoughts, obviously, but was it because she was optimistic that she could get over it? She didn't want to lose the kids, and then she underestimated the power of what she was under, what she was suffering from. It's, again, mental health is not black and white, and this jury is going to have to sift through it. Let's get a break. When we come back, we'll continue our coverage as we wait for a courtroom, a question, a verdict. We've got you covered. The first call is going to our photographer, Rich. So stay with us. If there's a question or a verdict, you'll know it here. First, stay with us.
I think that's the only reason New York Times
year, but I had another internship in Indianapolis. Oh, okay. Yeah, she's very cool. Yeah, I think she started. Yeah, I was there when you started doing the videos and you reached out. Come up here afterwards, so I went straight from Western Kentucky. Yeah.
Yeah, I saw that. Yeah. I saw that too.
It's kind of weird. It's a little, kind of a smaller school. Yeah. We just have one crazy girl and brother
Tracking show. I said. I'll just get it.
One semester, I think.
Welcome back to Court TV Live. I'm Ted Rowlands outside the courthouse in Plymouth, Massachusetts, where the jury is deliberating the fate of Lindsay Clancy. After 5 weeks of testimony, 80-plus witnesses, and then today's closing arguments, it'll be up to the 12 men and women selected to sit on the deliberating panel to decide what to do with her. The former labor and delivery nurse, 36-year-old mother who killed her own children. The defense says she's not criminally responsible because she was in the throes of a psychotic event when she took the lives of 5-year-old Cora, 3-year-old Dawson, and 8-month-old Callan in January of 2023. The prosecution says this was a mother who wanted to commit suicide, but wanted to take her kids with her because she didn't believe anybody could care for them like she could, and that she is indeed criminally responsible. With us is Sierra Gillespie. She is the host of Scandal podcast on the Law&Crime networks. You were in the courtroom during the closings, and part of the defense presentation was an attack on the investigation. And there were a lot of folks involved in the investigation in the courtroom. How did that go over with those in attendance?
Yeah, it's interesting, Ted, because I didn't feel like the investigation was talked about that much throughout this entire trial, except on the internet, right? I mean, there's all those conspiracy theories on TikTok, Instagram, wherever you may go, saying, okay, I don't know if the police were actually doing their due diligence here. Now, this could be because perhaps we're only a couple of miles away from the Karen Reed trial, and that, of course, put a lot of mistrust in law enforcement here in Massachusetts. I don't know if it really is worth kind of diving into all of that, but what I will say is that Kevin Reddington, in his closings, did take at least a dive. He talked about, you know, okay, the pills that were crushed up. What were they crushed up with? Was anything ever found? No. What about the blood spatter? That wasn't tested. Hey, remember when I and Patrick Clancy, her then husband, found the Apple Watch and police didn't even collect it? I mean, so he's kind of going in on the police. And what's interesting is I'm seated in the front row, Kevin Reddington, of course, and the jurors ahead of me, but behind me, all police officers, all first responders, the people who were there the day of this horrific incident back in January of 2023. And I specifically was looking at them during this portion, and they were very stone-faced. They kind of were a little like, okay, you know, nobody likes to be criticized, obviously. We're all doing the best job we can. I don't know that they loved hearing all of that in the closing arguments from the defense's side, but with Kevin Reddington, I don't think anything's off limits.
Sure, absolutely. And Jack Rice, a criminal defense attorney in Minnesota, Minneapolis, St. Paul, if you're in trouble, you call Jack, and Julia Janae with us as well in our Court TV studios. Jack, the courtroom had for 4 of the weeks, 4+ of the weeks, had lots of people over on the defense side and just the media over at the prosecution's side. And today they filled it with the people involved in the investigation. It's an optic that works, does it not? That, you know, for 4.5 weeks, it was an optic that stood out that, oh, everyone's behind Lindsay. Having a full courtroom behind the Commonwealth is a message. Was it a message that you believe was too late?
I've seen this before. I recall trying a murder case, and during closings, the entire back row of the gallery was the entire police department, all dressed in their dress blues. And that was on purpose. That was intentional. They are doing this as a show of force for the jury. But I think when we think about what it is that the defense was doing, and the reason they didn't really go after the investigation that much in the case itself, I think is this. That's not the theme of their case. The theme of their case was never that the police department screwed up, that they didn't do their jobs. Really, because if we think about what they were saying was, she did this. She did this. She killed her kids. That was never in question. They didn't drive down that path at all. Their path was to go after those people who were responsible for taking care of her and for identifying her problem and addressing the problem. That wasn't the police. It wasn't. It was the psychiatrists. It was the other medical doctors. It was the meds that she was on. It was the cocktail of meds that were coming on and going off and coming back on. And it was her desperate efforts over months to try to get help until she finally stopped in January. That's why he spent so much time on it. And I get that the entire internet is looking at these alternatives and why it is that Patrick ended up at the CVS, or why did he go to this restaurant versus that restaurant. But from the perspective of the defense, that's not what the case was ever about. So to throw those in there, I think at the end of the day, was trying to basically say each quarter that he's throwing down is a question of doubt. But those are really on the side of the other questions that we're really talking about. And he just threw them in the mix to try to push her up over the top.
Julia, are you confident in our system as it is now, where everyone is armed with a cell phone, and in a high-profile trial, everybody knows you're on jury duty for 5 weeks? Guess which trial I'm on? That this jury isn't being influenced at home by friends and family and talking about the conspiracy theories? There's a lot of wacky stuff out there. What's your thought on the probability that jurors haven't been exposed to more than just what they've watched in the courtroom?
Ted, you know, I've talked with you about this at length, and I am confident a lot of times in our jurors and their ability to really at least try. I've seen time and time again inside of these courtrooms where jurors will tell on themselves if they hear something that they're not supposed to. They'll come to the court, and we didn't see any issues here of the jury reporting or someone contacting the court to report that a juror had done anything that toes the line of misconduct. So I do continue to be confident that there are more jurors who follow the rules than there are who do not follow the rules. But I do think it is very difficult, especially in this area, this case. Sierra mentioned the Karen Reed trial and the potential for mistrust in the system there because of the dynamics of that case and how it impacted. I'm glad she mentioned it, because I was wondering if there are similarities here beyond location. Clearly, these cases inside of the courtroom, the evidence completely different, could not be more dissimilar. But you have a split public from the people who we've talked to who are there in Massachusetts in that community. They say that people are split on whether or not this is something where she should be convicted or whether she should be not held criminally responsible. We had pink-clad supporters for a female murder defendant, which we don't typically see. And then there are these conspiracy theories circulating online. So, Ted, I feel like the jurors had an even taller order of following the instructions in this case compared to typical trials.
Sierra, Judge Sullivan, after they had the gathering here last Thursday where 250, 300 people came out in support of Lindsay for that moment of silence, people wearing pink, he brought each jury in one by one to make sure that they weren't influenced by that. But this courtroom, this courthouse, it's fairly large. However, there's no doubt in my mind this jury knows that the world is watching this case.
Oh, yeah, there's absolutely no doubt in my mind either. At the very least, they know that a packed courtroom is literally watching them. I mean, I'm from a little bit farther between me and you, Ted, watching these people, just staring at them, and they can feel it. You know when you feel somebody watching you? That's the entire courtroom looking at these jurors because the fate of Lindsay Clancy is in their hands. And I mean, of course, during voir dire, this was something that was talked about at length, but living in this area, Plymouth, it's a relatively tight-knit community. So in Duxbury, when this happened just 3 years ago, a lot of these people have been here for decades. They, of course, heard about the case back then. They at least knew some of it. At least some of them did. And so I think just the fact that this is a very ongoing trial, that they're seeing publicity outside and inside the courtroom as it gets bigger and bigger and more packed, they definitely know that there's something going on here, that the world is watching.
And Jack Rice, that can cut both ways. It doesn't necessarily help one side or the other. The fact that it's high profile and that jurors may have somebody chirping in their ear when they're at home.
Well, I look back at a couple of cases like OJ, but I'm going to go to one of your cases, Ted. I'm talking about Scott Peterson. Let's think about that case and the influence that some people have and the idea of people who are on that jury and they're reaching out and thinking about what that might do for them. And I'm thinking about one particular juror, but I will defer to you on that. But we think about the influence that they do have because we have seen cases like these. The Karen Reed case comes to mind. The Johnny Depp case comes to mind. There are other cases that are out there that really grab society. And the idea that anybody can live truly in a bubble for weeks and weeks at a time, I think simply is not the case. The idea that nobody is going to talk about the elephant in the room when everybody is talking about the elephant except you, and everybody goes silent when you walk in it. I'm sorry, all you're thinking about is the elephant. And that's the reality of being in a very, very high-profile case. And that jury has to feel it. Sierra was perfectly put as she laid out how everybody knows that they're looking at them because they are. It's not paranoia if it's true.
Yeah, that's true. Well, we got a strawberry shortcake reference from Jack Rice.
There you go. You got it, my brother.
Verdict watch, yes. Let's get a break. When we come back, we're going to talk to Rich, the photographer, the man who will get the first word of a question or a verdict. He was also in the courtroom during that 911 call, one of the very few people outside the jury who had to endure it. We'll talk to him about that. Come on up, stay with us. I'm Ted Rollins outside the courthouse in Plymouth, Massachusetts. Glad to have you along with us on Court TV, the Court TV YouTube page, and the Law&Crime YouTube channel. We are going to be with you until the end, till there is a verdict in the case against Lindsay Clancy. The jury has been deliberating now for more than 2 hours after arriving this morning, listening to some preliminary instructions from Judge Sullivan, then the closing arguments from both the defense and the Commonwealth, and then the final instructions from the judge before the alternates were selected and the deliberating jurors began the process. 5.5 weeks of testimony, over 80 witnesses took the stand. This jury has been through a lot. Very few people have been here from the very start, but one of them is the man we've been talking about over the last couple hours. Our camera guy, Rich Morgenstern, is joining us now. And Rich, tell us if you have to jump, if you get that call, if there's a question or a verdict, you'll be the first to know. Let's start with the process from here on out, what we're anticipating. They're hard at work. It might be a while. It could be several days, given this case. How will we be notified? You're going to get a call, I guess, and then it'll go from there.
Yeah, I've been lucky enough to be here from the beginning, building relationships, and I spoke with Beth Stone. We switched phone numbers, and she's in direct contact with everybody that's inside right now. So she made sure that we set up a whole text group to make sure that we get notified right away if there's a question, and obviously for a verdict.
Yeah, they'll go likely till 4:30. This courthouse closes at 4:30, and it seems as though Judge Sullivan is going to give sort of them the direction, but not too much past 4:30.
No, right? We will not be here past 4:30. Yeah, he's pretty good about making sure the jury is on some type of schedule.
And a lot of the cases that we cover that you've been in, judges will let people stay till midnight and deliberate. Not the case here.
Not the case here, and thank goodness I haven't been on those cases. So that would be something else to be there that late.
Let's talk about what you have witnessed in this case. You've watched other cases play out. In every case, there are autopsy photos. There's a certain amount of gore, if you will. This is different. This is just so different. And I want to start with one thing that we haven't seen or heard, actually, is that 911 call that Patrick made that the judge basically sealed because it was so gut-wrenching. And the description is almost worse for us than what it is, but give us the reality of what you heard, what you saw, what you felt.
Well, yeah, I mean, I've done a lot of cases, and yes, you really do kind of hit it right on the head. The judge was right in not having us play that out. I've seen a lot of autopsy photos. Some stuff sticks with you visually, but having just the audio really and it's not like you could really understand a lot of the words that Patrick was saying that day, but you could feel his pain by the sounds he was making, because he's discovering one child after the other on the 911 call, and you can just hear the screaming and the gut-wrenching, and you could just feel how it really was just tearing his soul out of his heart.
The jury, what was their reaction during that you noticed?
So as the call started getting going, it was like any 911 call, but then you just started hearing him discover, and then you could just see the reaction of the jurors just kind of sitting back in their seat, and it just coming more and more, and then the emotion came, and the tears started coming from every juror, maybe one or two that I didn't see, but everybody was feeling it at that time. And even being the camera guy, I was even emotional. So there wasn't a dry room in the courtroom besides the people that had either heard the 911 call before or that were there defending or prosecuting. The prosecutors and the lawyers were, and the judge. But other than that, the room was filled with emotion, and a sad emotion.
And your camera was on Lindsay. We had no audio, but we could see her shaking, and it was incredibly difficult to watch from our perspective as well. I can only imagine being in the courtroom. You've covered a lot of trials. What's your gut on? There's so much evidence, so much to go over. This likely is not ending today.
I don't think it's going to end today. I think it shouldn't end today because this is an important decision that these jurors have to make. you know, we'd been here a while, you know, 5.5 weeks, a little bit longer for me for getting here to set up. So let's not rush it now, you know. The jury, the judge had said some things about the jury, you know, he believes in them, and they have been. They've been here every day since they've been selected, and they're going to take this serious because as much as they've been trying to, you know, keep out of the news and not, I think they know how serious this is from the day when we had all the women here in the pink shirts. You know, you couldn't help but avoid that. So
yeah.
I think they know they have a decision that is going to probably change the world after, because now once they have a decision, it's going to become law.
Rich Morgenstern, keep your phone on, keep that ringer high. He'll give us word if there's a question or a verdict in this case. Let's get a break. Our continuing coverage of the deliberations in the Lindsay Clancy case continues right after this. Stay with us. Welcome back to Court TV Live. I'm Ted Rollins outside the courthouse in Plymouth, Massachusetts. Good to have you along with us. We are continuing our coverage of the deliberations in the Lindsay Clancy murder trial. The jury has been at it for over 2 hours. After hearing closing arguments earlier today, they were dismissed for lunch. It's unclear whether or not it was a deliberating lunch, if they worked over the lunch break, but what we do know is that they are hard at work, and they'll likely go until 4:30. So we will be with you until this jury has been dismissed for today. If there is a question or a verdict, we have you covered. We will immediately head into the courtroom. Jack Rice and Julia Janae still with us. Jack, some final thoughts here from you. 5 weeks, 80-some witnesses. How long do you think it's going, and a very complicated case with no clear answers. What's your gut tell you? Hung jury, how long? Will there be a verdict? Your thoughts?
Hung jury. Hung jury for 2 reasons. We're talking on one side about 3 dead kids, and I can't let go of that, and nobody can let go of that, and nobody should let go of that. That's one piece of that on one side, and there will be people who will really dig in with that in mind. But there are going to be people on the other side of this who look at the mental illness and the documentation, and there's extensive documentation that goes the other direction. And we look at the failures even from the medical professionals, and you realize that that side is going to dig in too. All you need is one. Do I think that they're all going to come together and agree? This is a hard, hard case, and it is going to take a long time, and I'm betting this is going to go into next week. And if that happens, that's when I think you're going to see a hung jury. Otherwise, I think you're going to get a not guilty, and that'll happen tomorrow.
Julia, an X factor.
Well, I should say by reason of
side
insanity.
would be
I should say
addition-
by reason of insanity. Let's be clear.
Yeah, absolutely. Yeah, not criminally responsible. Julia,
Yes.
On the other side, manslaughter is on the verdict form. That could make a difference here.
It could if they compromise. If they don't want to leave with a hung jury, if they don't want this to be a mistrial, they understand how much time and effort was put into this trial. We had it survive the mistrial request by the defense there towards the end. I don't think anyone wants to see this continue to be a retrial, but of course the defense is going to see it as a win if this is a hung jury. We haven't really talked about whether or not this jury could potentially say, yes, she's guilty, but this is not first degree, it's actually second degree, or it might be manslaughter. I don't know if you make that decision. If you've decided that she did this and she did this with intention that overcame her mental health episode, then I think first degree. I don't see manslaughter unless you have people on 2 opposite sides saying not guilty, not criminally responsible, and others saying yes, guilty. Perhaps they land on manslaughter.
Yeah, that would be down the line, like Jack said, after some sort of compromise in the jury room. It's very tough to predict, but one thing I think most people believe is that it's going to take some time, and we're expecting them to go until 4:30 today. They've just really begun their process. Jack Rice, as always, thank you. Julia Janae, appreciate you as always. Let's get a break. When we come back, we'll continue our continuing coverage of the deliberations at Lindsay Clancy.
Most busy I've seen it, yeah. So, I mean, I understand that it's busy. Yeah, it's nice because we don't have to bring all this stuff with us. Would be this point. You've been driving over?
Welcome back to Court TV Live. I'm Ted Rollins. We are in front of the courthouse in Plymouth, Massachusetts, where the juries continue to deliberate the fate of Lindsay Clancy. They have been at it over 2 hours and continue their process. We're expecting them to go until 4:30. This courthouse closes at 4:30. It is up to them, though. So if they want to end the day early, Judge Sullivan will surely allow them to go home. We haven't heard anything yet in terms of a question. Obviously, no verdict, but we have you covered. We're live on Court TV, also live on the YouTube channels of Court TV and Law&Crime. And we welcome all of you to this process, which could be days in the making. So we're going to go over it all. What is the jury honing in on? There's 5.5 weeks of testimony that they have been exposed to, 84 plus witnesses, the closing arguments today by both sides, a lot to mull over, a lot of evidence to potentially review as they go through this process. With us to help us along, Julia Janae is in our Court TV studios, and Philip DeBay is also with us. Philip, good to see you. Would love to get your opinion on this case overall. The evidence is in, the arguments are finished. Your thoughts, what stands out?
Well, there are several things. There is now a spotlight on postpartum psychosis. And I think for many years, if not decades, people dismissed it as the baby blues, as just a bout of slight depression, and perhaps just a bout of melancholy. And I think what people are seeing firsthand across the country is that it's not just striking Lindsay Clancy, but it is striking other women. I actually had one client myself many years ago, not in the homicide context, it was in the child abuse context. And it's a very, very real medical and psychiatric phenomenon. And the biggest problem is that it's really hard to diagnose, and it's extremely hard to detect, and it's really hard to treat. And I think the problem is that there is no one specific diagnostic tool or medicinal treatment for it, but rather it's based on an empirical treatment approach, sometimes called trial and error. And it makes a patient out to be almost like a guinea pig, where you have to try to find the right mix of polypharmacy to see what suits the patient. And before you know it, you're on and off an entire inventory of drugs that may or may not be efficacious. And in Lindsay's case, I think the evidence showed that it just did not work. One thing I will say, though, is I was slightly, as the trial was progressing, disappointed in the presentation of the state's evidence. But I got to tell you, in the final analysis, I thought the prosecutor was quite understated and very effective. And I'm telling you, I was all ears listening to her, and this could be one that goes either way, frankly. And I'm not sure if they'll even ever reach a verdict on this. I would not be a bit surprised if this jury deadlocks.
Well, I think a lot of people agree with you. Julia Janae, we were just talking about the different outcomes here. On the menu, if you will, the verdict form, the jurors do have that manslaughter, which the only way to really get to it is almost jury nullification, in that both sides give up and meet in the middle.
Yeah, I think that's why that these attorneys didn't spend a lot of time delineating for them the difference between these, because when you think of whether or not this was murder or whether she was not criminally responsible, once you get into, okay, if they agree that this was a homicide and that there was not a mental disease or defect that would have limited her in understanding right from wrong, then you're in this arena where she has done the most horrible thing you can do. And when we think about delegating things down, regulating them down to second-degree murder or manslaughter, that's when we start thinking about whether or not it wasn't intentional, whether you were in a state of passion, you were heated, you didn't have time to think about it, or if it was something that was involuntary, you were speeding and you didn't mean to kill someone and then you did. That's not this case. If you get outside of the realm of not criminally responsible because of a mental disease or defect, once you get out of that, you have a mother who horrifically killed her kids. So I agree with you. I think if they do come back with something like second-degree murder or manslaughter, it will be an indication that some jurors felt that there was a mental disease or defect, didn't feel comfortable with first-degree murder, and just as a result, not necessarily of following the law, but just as a result of not being able to come to a consensus, they choose a lesser of the murder charge. But I think it will be a hung jury before we see something like that.
Also joining our discussion is Callan Kearney. He is in New York. Callan, nice to see you on this Thursday. Your thoughts on this jury, the work ahead, and the enormous task at hand?
Oh, this is a very serious task. It's great to be here with you all today. We have to understand that essentially they have to realize whether or not this was before the medication of the defendant, or is this the after the medication taking of the defendant? Because based on the testimony, we're talking about essentially two different people. We have a loving mother from testimony from the nanny, and then we have someone that is completely outside of herself after the medication began. So the jury's going to have to decide whether it was that medication that made her not have the intent to kill her children. We know that she has discussed with her former husband previously that she had an intent and she thought of killing the children. But was it that medication that made her have not the ability to control herself from actually killing the victims in this case? And that's what the jury's going to have to work with, and that's something that I'm sure is hanging heavy on each one of those jurors.
Absolutely. Sierra Gillespie is the host of Scandal, the podcast on the Court TV and Law&Crime networks. And she's been in the courtroom for the last few days, including today during the closing arguments. You were here for the opening statements as well, and jury selection to some point. This jury, from my observations, my limited time in the courtroom, they do, 5.5 weeks into it, still seem very attentive. And we saw that play out today.
Yeah, I mean, this trial has captivated the nation, if not the world. I've had people from Australia message me, from Ireland. I mean, this has really captivated everyone. So it's no surprise that the jurors are captivated too. I mean, they've seen more than any of us. The 911 call they, of course, heard, the autopsy photos. And I think Reddington put it best in his openings and his closings when he said, "Thank you for your service. This is a trial you will never forget. This is going to stay with you forever." And I do think that the evidence is compelling. I think that the defense, of course, had the entertainment factor in a way of Kevin Reddington. We've talked about how he's very compelling to watch. Then the closings, the prosecution wrapped it up too. But I think that, yeah, the jurors have been paying attention throughout all of this. And now I'm sure if I was a juror, I'd be eager to go back to that deliberation room. If I'm going home after, hearing all this evidence and not talking to anyone about it for 5 weeks, I would be very eager to finally get deliberations underway. So I'm sure they're doing just that.
Philip DeBay, we're talking about both sides. You mentioned the Commonwealth today in their close. Very effective. You were listening. What about Reddington? What did you think of him, his command of the courtroom, good or bad, throughout this trial?
I am telling you, he's going to rank as being one of the top 3 attorneys of all time, next to the Melvin Bellis, the Clarence Darrows, the Andrew Jennings, who defended Lizzie Borden back in the day. I love his style. If you notice, he stands there at the lectern, doesn't keep his head buried in notes. He just speaks extemporaneously, making ongoing eye contact with that jury, and doesn't lose track at all of where he is headed. He has a constant recurring theme throughout, and he is weaving the facts of his defense into his argument so effectively, so masterfully, and just so extemporaneously, frankly. We don't see it very often. It's just seamless.
And Julia, he's a one-man band for the most part. He's got an investigator that he uses, a paralegal, but this is a guy schlepping his boxes in and getting out of his Ford Bronco with a not guilty as his license plate, NG. He's a character. There's no doubt about it. and he has taken over the courtroom. Sometimes it backfires if you don't bring it. But to Philip's point, he seems to just be in that sweet spot of experience and ability to communicate that it is something to watch. Your thoughts on his job so far?
Oh, for sure. And the jurors feel that, right? Defense attorneys like for jurors to know that there's this Goliath that's after their client, and they are just the one David sitting at the table, the only person who is willing to speak out for this person who's accused of a crime. So they've probably noticed the fact that there's only one person at his table compared to multiple people at the prosecution's table. They know that he was there right at the beginning. He was in the home with Patrick. He's been working this case for years, even while he's handling the other cases. But they know that connection, and he's just been able to tap into, I think, the theme of this case that is recurring even in the public. I want to read some of the comments that we've gotten from viewers online who are in the chat, because this seems to keep coming up, that people recognize that in this case it connects to them in what they've dealt with the healthcare system. One person saying, Lindsay was horribly failed, just like when I experienced a similar misdiagnosis over antipsychotics. Another person saying they were diagnosed with bipolar and you'll surely be affected by the combination of medications. And another person saying, I can totally relate to the healthcare system dropping the ball. Though the prosecution doesn't want this to be a debate on the healthcare system or mental health in this country, that is what it has become, at least outside of that courtroom. Who knows if that has impacted these jurors?
And Cannon Kearney, Kevin Reddington put the system on trial as well, and including the medications, including the treatment that she did or did not receive. He did it very effectively, and like it or not, the prosecution has had to deal with it. Today in their openings, they said, this is not about postpartum, it's not about drugs, it's not about health care. In the reality, he made it that, and that's a big part of this, is it not?
100%. Ted, it's all about themes. You have to persuade this jury that this woman who killed 3 young children is not guilty. You're going to put it all on the line. And when you put it all on the line, you're going to have to ensure that they understand that this theme of the system going against this young lady, the system failing this young lady, and that's why these children died. Not because she intended to kill them, but because she couldn't control herself, because she wasn't diagnosed appropriately. Or if she was, she didn't know how to live day to day with the diagnosis and her family. So that's what they're trying to do, is persuade these jurors to a not guilty verdict.
Sierra, the image of Lindsay in her chair, it is there all the time. And we talked about it earlier. When everyone rises, she sits. It's a constant reminder of the fact that she is paying on some level for what she did. And her emotions seem to be absolutely on cue with someone who's remorseful, a mother who's lost their kids. It's almost like she's a victim in this. And your observations of her, the jury watching her, what do you take away?
I think it is very shocking, at the very least, to see Lindsay Clancy in her wheelchair at all times. Because to your point, when everyone rises, including the jurors, she stays seated. So even if we're talking about something completely unrelated to her suicide attempt, it's always there. It's always kind of lingering in the background. And I think another thing that jurors are picking up on is the juxtaposition here. I mean, she dedicated her life to being a labor and delivery nurse. She worked at Mass Gen, which is a world-renowned hospital. A lot of people testified about how great of a student she was, how much she cared about her patients. She named Cora, her daughter, after the first baby that she delivered. So the juxtaposition of her dedicating her life to bringing children into this world and now going down in history as someone who took 3 lives out of this world. I mean, I don't think that that's lost on the jurors at all. I know that Philip Dubé just brought up the Lizzie Borden trial, also here in Massachusetts. That's a famous case. This one is a famous case too, and I think it might go down in history similarly. It's going to be monumental, whatever the verdict is.
Mm-hmm. Let's get a break. We continue to await anything out of that jury. They've been at it more than 2.5 hours now, deliberating the fate of Lindsay Clancy. As soon as Rich gets that phone call on a question or a verdict, we will head into the courtroom. But for now, we wait. We'll wait together. Back after this.
Somebody called me and was like, "You're just a friend, woman, Mom," and I was like, "Thank you." It's based on, so like, call myself a friend. Yeah, so I told them I had not really done the show and stuff. I might really now to.
Bad or this is like really new?
He gave me all of everything. So, oh no, he's the beast. He's kind of the reason why I thought, because I was watching a lot of the
Honestly, I have a hunch that I think I already kind of have like friends with you. If you look at like our generation, I mean, everybody wrote off mine. Right now, everybody in the vinyl market, we had a big benefit. And also the high moviegoers now. I think, yeah, I was wondering if like magazines or maybe
Oh, I was gonna say, it's probably not even. It's probably a bill collector anyway.
Yeah, I'm worried, like, don't write it off. Why the Wall Street Journal then? I've gotten the Wall Street Journal.
Welcome back to Court TV Live and the YouTube channels of Court TV and Law&Crime. We are awaiting any word out of the jury, the 12 men and women who are deliberating the fate of Lindsay Clancy. They are now well past the 2.5-hour mark as we expect them to work till about 4:30 this afternoon Eastern time and then call it a day. We haven't heard anything yet, no question yet, or obviously a verdict, but we have you covered. It's been a long trial, 5.5 months, or weeks, feels like months maybe for some. And we're just waiting. We're waiting, and we're taking your comments, and we're discussing what the jury's been exposed to, what they could be talking about, what stood out at this point that will make a difference one way or another. With us, Julia Janae in our Court TV studios. Cannon Kearney is in New York, and Philip DeBay is in Los Angeles. Here on site with me, outside the courthouse, is Sierra Gillespie. She is the host of Scandal on the Law and Crime networks. And Sierra's been in the courtroom for a good portion of the trial, including the closing arguments today. We were just talking about Kevin Reddington before we went to the break and the effect that he's had on this trial, frankly. Outside of the courthouse, he is also a force. He is one of these attorneys that gets swamped after he walks out, but he talks. He, at one point he got in a fight with a podcaster, calling him a weasel. Yeah. Yesterday, you had an opportunity to interact with him, as you have in many times, and take us through what stood out to you.
Yeah, so we're talking about criminal responsibility a lot in this case, right? Because that's really what it boils down to. There's no question that Lindsay Clancy didn't do that. That's part of the plea. But the defense is saying she isn't criminally responsible because she was undergoing psychosis at the time, or at least that's their argument. The Commonwealth, of course, says that she is criminally responsible, and that's what we heard a lot about today in the closings. But I know that statute was kind of confusing for me when I read through it, the Massachusetts state statute, or Commonwealth statute, rather. And I wondered if it would be kind of difficult for jurors to understand, too. So I asked Kevin about it yesterday, and here's what he said. And do you think it's going to be tricky for them to understand the criminal responsibility of it all? I mean, we've talked about it throughout this, 5 weeks, but it is confusing for lay people.
It's very confusing. I think this jury, they paid incredible attention to the trial, to the witnesses, to the judge's instructions. I'm sure they will as well. That's how the system works.
Okay, that was Reddington, one of the many press conferences. At the bottom line, he thinks it's confusing as well. And it seems as though, Philip DeBay, that a jury would also have a tough time grappling with it because both sides had an opportunity to lead the jury in each way, and then you add in the judge's instructions. It's tough to navigate.
Exactly. But the bottom line is, the law is pretty simple. All the law says, it's called the McHowell rule, that the defendant could not appreciate the quality of their act or stop themselves. The question is, what does that really mean? They need to define, appreciate. And the bottom line is, appreciate. When you cannot appreciate, it means you don't recognize the significance of your act. And that's how the case law reads in Massachusetts. If you don't recognize the significance of your act, and you could not stop yourself, then the jury has to come back with a finding of not criminally responsible. And for jurors and for the public, all that really means, it's a lose-lose for Lindsay, short of a deadlock jury. It's a question of housing. If they come back simply guilty, it just means she goes off to the Department of Corrections. If they find her not criminally responsible, she'll be housed in a mental institution until they deem her safe and ready to re-enter society. That could be decades, if not a lifetime. It could also be short term, but they're going to have to ensure that she is not a danger, that she's given wraparound services and has a discharge plan, meaning somewhere to go if and when she is ever released from the jurisdiction of the state. And I'm telling you, it is a very, very heavy lift.
To get out once you're in that system.
Yes.
Cannon Kearney, to get out, you the idea that, they're going to let her just wheel out of this courtroom a free woman, that's absolutely not on the table. And the jury's somewhat aware of that through the instructions, but there could be jurors that are fixated on that. 3 dead kids, and she's going to go free? No way.
100%, Ted. And the truth of the matter is, she shouldn't be out in the community at this point until as Philip said, it's clear that she can start to appreciate the things that she's doing. she shouldn't have the ability to go out and harm anybody else because of psychosis, or even yet have more children in her own name. So I believe that at this point, the system will work regardless. If the jury believes that this community needs to rid itself of this woman who intentionally killed her children, she will be behind bars. But if the jurors don't believe that she had the criminal ability to do this act, this heinous act, she still will get the help that she needs. It just won't be as posh at the hospital that she used to work with.
Julia, Janae, the comments on the YouTube channels, what's standing out to you? I know the polls that we've done, it seems as though people are really split, and more than that, dug in. It's almost like politics, where if you're on one side, boy, it doesn't feel like people are open to being swayed.
Oh yeah, split, but very passionate about whichever side. It's pretty civil in our chat on Court TV and the Law and Crime Network, but I do want to highlight some that we've actually answered. But I think it's worth emphasizing because this could be in the minds of these jurors. Equalizer Show is a user in our chat who said people realize that not criminally responsible means she's still in an institution for life, right? But that's not true. Philip just answered that if she's found not criminally responsible, there is a situation where she could be deemed able to be released and live on her own. Someone also saying the longer that she takes in this trial, the longer she's going to sit in jail waiting for sentencing. That's a misconception. She's not technically in jail as she awaits this trial. She's been in that behavioral center. And another question that I actually don't know the answer to, but I can talk about it, which is from user Multichick, who says, does anyone know how close Patrick's civil case is to trial? And I don't know if Sierra knows anything more definitive, but usually a civil judge is not going to put a case like this that's intertwined like this with a criminal case on the docket until that criminal case has completed. So I would imagine it is still in a holding pattern until we get a verdict in this case, and then those parties will come back in and decide what do we do next now in the civil case. And also this verdict could have a really huge impact on what happens there.
Oh, massive. Plus there's a civil case filed by Lindsay as well.
Mm-hmm. Yeah, so I do know actually a little bit about the civil cases, and it's very reminiscent of P. Diddy, right? I mean, we reported on the dozens of civil cases that he faced, but it seemed that the federal trial took precedent, and that's kind of what's happening here. It's temporarily on hold. I know that the attorneys are still working, but as of this point, nobody's been deposed. There aren't any depositions. I'm sure that Patrick, probably Lindsay, we're talking Rebecca Gelada and Dr. Jennifer Tufts, all have to be deposed for this. That has yet to happen, but to Julia's point, I do think that the outcome of this trial could definitely affect what happens in the civil litigation.
Absolutely. If she is found not criminally responsible, that will speak volumes down the line. Let's get a commercial break. We are waiting patiently outside the county courthouse in Plymouth, Massachusetts, where inside the deliberation room in the building behind us, a jury of 12 is deliberating the fate of 36-year-old Lindsay Clancy. Our coverage continues right after this. Welcome back to our continuing coverage of the deliberations in the Lindsay Clancy case. The jury inside the Plymouth County Courthouse has now been added for almost 3 hours. We expect that they'll be allowed to deliberate till about 4:30 Eastern time. If they want to leave earlier, of course, it will be up to them. We don't expect a verdict today. An hour left, but you never know. So we are here, and we will be here until the jury is dismissed for the day, or if there's a question, or, of course, a verdict. There has not been any movement yet since they were dismissed just after 1:30. They heard the closing arguments. They were instructed by Judge Sullivan. The alternates were then picked. 18 jurors sat through all of this evidence over 5.5 months, 5.5 weeks, and 80-plus witnesses. And then 6 of them did not get the opportunity to deliberate. We are going through the evidence together as we wait for any word out of that deliberation room. We have Philip DeBay with us. We also have Sierra Gillespie and Callan Kearney. Callan, the 5.5 weeks is a very long time. This jury has a lot to get to, and there's different ways of going about it. There is a chance, though, they get back there and see where everybody's sitting, and if they're in agreement, we could have potentially a verdict before day's end, correct?
That's correct, Ted. That would most likely not be in the defendant's best interest if they came back with what would seemingly be a quick verdict. You would think that they would need to sit with this for a little bit in order to, take in the breadth of all of the evidence that has been presented, good and bad. So, again, my opinion would be if we get a verdict before the end of the day, more likely than not, that's not going to be good for the defendant.
The question of manslaughter, that is on the verdict form. So the jury will have first-degree murder, second-degree murder, manslaughter, and then not criminally responsible to choose from. Kevin Reddington talked about manslaughter yesterday after leaving the courthouse. Here's what he had to say.
It gives the jury another option, and it's certainly a positive development from our point of view. Yeah.
Are you concerned though that if they were maybe going to go not guilty, they may now choose manslaughter?
Got to cover the record. If you remember back to when I filed the motion for the bifurcation, I was arguing to the judge it's difficult because a defendant on a lack of criminal responsibility defense has to basically admit that he or she is guilty before you're able to do that. So you're not able to attack the issue of whether or not the government can prove that the person did the case, but that still is in play. They still have to prove that she was guilty beyond a reasonable doubt, and then if, in fact, she's guilty beyond a reasonable doubt, then you get into the issue of lack of criminal responsibility. So that's the dilemma that we have, and that's why I filed the motion to bifurcate. So the issue is, yeah, it's still open, and it's up to a jury to decide either way.
Philip DeBay, would you want that manslaughter on the verdict form?
That's a very good question. Probably, and I'll tell you why. In theory now, the jury could come back not guilty all out on first degree, not guilty on second degree, but find her criminally responsible, in other words, convict of manslaughter. And if I had to choose my poison, if you will, I would rather go down on the manslaughter because that carries a determinate term in prison. I believe it caps at 20 years under Massachusetts law. That would be a tremendous victory for the deaths of 3 children. But that would be the worst case scenario. Best case scenario, though, is that they come back not guilty on a first and a second, and then come back not criminally responsible on the manslaughters, and off she goes then to Bridgewater, namely the state hospital. That would be grounds for a victory lap.
There's a lot on the table, Sierra, and this jury is now having to mull it over. Your thoughts on that part of the equation with the manslaughter? Let's face it, 20 is the max, but there is no minimum in the manslaughter. So Judge Sullivan, who has been here, seen everything. And I've seen judges react differently to different attorneys. He seems to not side with Kevin Reddington, but he has made more decisions that are pro-defense than I've seen in a very long time from a judge in terms of little objections, things here, admonishing the prosecutor, admonishing their expert witnesses. I wouldn't mind having him sentence my client is I guess my bottom line.
Yeah, I tend to agree with you. I mean, as a judge, it's his job to be fair and reasonable here, but I do think that he did tend to side with the defense a bit more in terms of the objections and everything that kind of came up. In terms of the manslaughter of it all, I think it's interesting to have it on the form. It's definitely an extra thing that the jurors are going to have to talk about, whether first degree, second degree, manslaughter, and then, as Reddington pointed out in that soundbite, then we can discuss the criminal responsibility of it all. And something that I keep going back to in all of this is that was she mentally competent at the time, because that's a huge part of this criminal responsibility. If she had a mental disease or defect at the time, that's interesting. And some of the rebuttal witnesses, actually for the Commonwealth, pointed out that they believed that she did, that she had bipolar 2 specifically. So me as a reporter sitting in the courtroom, I'm clocking that, and I wonder too if the jurors are.
Yeah, it's clear. 4 of the 5 experts that took the stand concluded that she was suffering at minimum of bipolar 1. And there was the one outlier from the Commonwealth that did not, the expert back, who did not agree with that assessment. But one would think that the jury is accepting that first prong of the criminal responsibility, 2-prong decision they have to make. Cody Thomas is also with us, and I should note we are over the 3-hour mark now. This jury has been deliberating. Cody, monitoring the chats, the comments, the opinions that we're seeing on the YouTube and Law&Crime YouTube channels. Cody, good afternoon to you. What are you seeing?
Happy to be here with you, Ted. Yeah, I've just got in here looking at all the comments on the YouTube page, and they're firing off very fast as people are obviously split all kinds of ways on how this jury will come out. And I'm looking at the poll here, Ted, on Court TV's YouTube channel. 51,000 votes now, just as I'm talking to you. 18% of those votes guilty. 53% of those votes, Ted, not guilty. And 29% of those votes a hung jury. So out of those 3 different options, her being found guilty is the one that people least think is going to happen. But a lot of people, over half out of 51,000 people who have voted on this thing, think it's going to be a not guilty verdict on behalf of Lindsay Clancy here. But I'm seeing all kinds of things in the comments. I mean, obviously there's been comparisons made to Andrea Yates, who was, a case early in the early 2000s that's kind of adjacent to where a mother killed her children. She actually got the not guilty by reason of insanity verdict in her favor back in 2006. Some people are bringing up, of course, we all know Casey Anthony. Some people saying you can't really compare it to that. But a lot of different comparisons being made, Ted, as I'm looking at, 25 different comments come off every second here. But a lot of people split in 3 different directions here with the guilty, not guilty, or the hung jury.
Yeah, and Andrea Yates was brought up in the closings, brought up by Reddington during his case in chief, questioning his expert Resnick, who testified in the Yates trial. Let's listen to a bit of the closings and the mention of Andrea Yates.
There are a few reasons why the voice doesn't make sense. The first is she immediately obeyed it. Dr. Resnick, their expert, the one who knows everything about postpartum psychosis. He teaches other psychiatrists and psychologists. He writes books and chapters and articles about how this is a huge red flag if someone immediately obeys a voice. You heard him talk about Andrea Yates, about how she heard voices to kill her children for months. And what did she do? She committed herself 5 times. She tried to kill herself twice to avoid harming her children. That was all accurate.
Let's move on from that.
Philip DeBay, Andrea Yates comparison. You've got the same expert that testified. What are your overall thoughts?
With that judge cutting her off, I think that was a fair analogy because remember, the good doctor rendered an opinion based upon Andrea Yates and the facts underlying her horrific crime. And to be deprived of the ability to weave that into your closing, I don't know. I thought that was a little unfair. And it gives the impression to the jury that she had done something either unethical or illegal. So I take exception to that, and I would have objected and gone to sign bar, even if it meant interrupting my own closing, just so you can get some type of curative or corrective statement on the record from the court, because that was a key distinction if we're all honest about
it. Interesting. Is it Canon Kearney, the Philip Resnick, who was brought on by the defense, Reddington was able to get the Commonwealth experts to agree that he is the authority when it comes to postpartum psychosis and also malingering. Did he have an advantage, or was the battle of the experts a draw?
I believe that he did have an advantage. I believe by them acknowledging themselves that he was someone that was a predominant person in the field, that bolstered his testimony. And just going back to what we just heard right here, I believe she was doing a great job of drawing the analogy between what was said. It's her job to literally take the facts that the defense provided to sway the jury that those facts in itself are helpful for the prosecution. So by her indicating that the voice was something that was heard and immediately she went to, by discussing how the other case, it took months and months, I believe that was a great distinction. And so, yes, I believe the prosecution did do a great job of swaying the jury in that moment. I don't know if I would have had as much fire as Philip in telling the judge about himself in that moment, but I do believe that that was something that definitely could have swayed the jury.
Sierra Gillespie, the witness, Resnick, was on Zoom, and Reddington made a point to remind the juries today in closings the reason he was on Zoom was because he had that emergency surgery and the doctor told him he couldn't travel, and he turned it around and said, yet he still made an appearance on the old TV. It does make a difference, though, does it not?
Oh, it absolutely makes a difference. I mean, just for example, watching this trial back at home is different than going in the courtroom. I myself have done both. I've watched it on the live stream here on Court TV and been in the courtroom, and you can just feel the difference when you're in person. And I think it does make a huge difference to have a witness actually there who can make eye contact with the jurors, who they can see, okay, this is a real person. Not that when they're on Zoom they're not, but it just gives it, I'm not going to say more credibility, but more relatability, rather.
Yeah.
You know, that you're seeing this person, you're talking to them. And so I don't think that it took away from his testimony because, to your point, Kevin Reddington got everyone to admit he is, you know, the front runner in terms of postpartum depression and psychosis studies. And obviously he's had a long history of, you know, testifying and education and all of that. So I do think he still was a great witness, but the Zoom of it all does make it a bit difficult.
Yeah, it forces the jurors to lean in and try to listen, and they're not experiencing the same atmosphere around them. He loses some effect, one could argue, and with the Zoom interviews. But then Reddington used it to his advantage, talking about Lindsay's care when her primary psychiatrist didn't even see her ever in person.
14 times.
Yeah, and it was all on Zoom. So let's get a break. The jury continues to work. We continue to wait. We have you covered. If there is a question or, of course, a verdict, we'll immediately head into the courtroom. The jury continues to deliberate the fate of Lindsay Clancy. Our coverage continues right after this.
Clancy trial.
Welcome back to our continuing coverage of the deliberations in the Lindsay Clancy case. Whether you're watching us on Court TV, the Court TV YouTube channel, or Law&Crime, we welcome you. We'll be together until the jury goes home for the day. And when they come back tomorrow, if they don't reach a verdict today, which it's looking more and more unlikely they will, we'll have you covered with wall-to-wall coverage as we wait for a question or a verdict. Lindsay Clancy, the 36-year-old former labor and delivery nurse accused of killing her 3 kids. She admits that she killed 5-year-old Cora, 3-year-old Dawson, and 8-month-old Callan. The question for this jury, though, is she criminally responsible? Here with us, Philip Dubé, Cannon Kearney, Cody Thomas, and Sierra Gillespie. Cody, you've been monitoring the chats, the comments, a lot of opinions in this case. This is not Karen Reed necessarily with the vitriol, but in terms of opinions, there a lot of people have them, and they've been moved by this case.
Absolutely, Ted. I mean, as you mentioned, Karen Reed, similar area of the country up there, but if Karen Reed's a number one, I figure this trial seems like a close second as far as how many people are resonating, again, how many thousands of opinions are flying out in every which way about it. Again, Ted, I'm monitoring the poll here. 53,000 votes now, a little bit over 53,000 votes. 19% of those votes, people say she'll be guilty. 53% still say not guilty. 28% hung jury. And Ted, I'm just watching the chat as it goes along. A lot of people just like putting out, statements about how they feel about it. But a common question I'm seeing here, Ted, in the chat, if there is a hung jury, do they think that the Commonwealth will try this case again? And I think that's a big question that people have, because a lot of people that have been on our shows, Ted, on our hours when we're on here covering this case in the last 5.5 weeks, a lot of former prosecutors and stuff, a lot of them have said this might not have been a case that they would have brought upon themselves, because we have to remember, Ted, that prosecutors have all the prosecutorial discretion to bring upon a case. I mean, that's a common question being asked right here. I don't have an answer to it, obviously, but it'll be interesting to see if that is the outcome. What will the Commonwealth do? Will they try this whole thing again, or will they try to work something out behind the scenes? That's just something time will tell if that is the result here.
Ken Kearney, your thoughts on what would happen if this jury was hung, assuming the split is near what the Court of Public Opinion has it at?
Well, Ted, they're invested at this point. The community has spoken, and I believe that the prosecutors wouldn't be able to back. Speaking of Karen Reed, again, we had another trial there. So I don't know that the prosecution at this point would be able to not move forward with another trial. It appears that the community just can't allow 3 young children to go unanswered unless the jury speaks. And so I do believe that there would be another trial.
Phil, quickly, we have to take a break. Thoughts on a retrial if it's hung?
Well, circling back to your comment about the ratio of the split, guilty for not guilty, that'll play into it, no doubt. And you can bet that prosecutors and the defense will be out in the halls, if not the parking lot, trying to debrief the jurors to figure out what that split was. I don't believe under Massachusetts law that the judge is allowed to ask the jury what their split is numerically. I just don't think it's allowed in their rules of criminal procedure. But be it as it may, what I anticipate, should this jury deadlock, is that the Commonwealth is going to entertain settlement negotiations with Mr. Reddington, get her to plead out, probably to the murders, in exchange for a finding of not guilty or not criminally responsible enough she'd go to the hospital.
All right. We are going to slip in a break. Ken Kearney, we thank you for your valuable time. We appreciate it. Our coverage of the deliberations of Lindsay Clancy rolls on. No question, obviously no verdict, and about 40 minutes left to deliberate today. We got you covered back right after this.
don't bring anything. I just need you. You need to come get the card.
All right. What we're going to do is I'm going to bring the jury back and just excuse them till tomorrow morning. Okay? All right. Yeah.
Court, all rise. Jurors entering. This court's now in session. Be seated.
Your Honor, present before the court, we have 12 deliberating jurors and 6 alternates in the matter of Commonwealth versus Lindsay Clancy. All other parties are present.
All right. Thank you, Madam Clerk.
You're welcome.
What I wanted to bring you in. It's been a long day for everyone. And so what I'm going to do is excuse all of you till tomorrow morning, 9 o'clock. I just want to, as you can imagine, want to reiterate those instructions. Now you are either deliberating jurors or alternates, possibly to deliberate. So I can't stress it even more than I have for the last 5 weeks. Don't read anything about this case. Don't talk about this case with anyone, even at home. Don't listen to anything. Just put this out of your head. Come back here tomorrow morning. We'll start at 9 o'clock. What'll happen is we'll have you come in. I'll bring you in. I'll ask you those questions. I'll just turn you right around and have you back deliberating. All right? And so with that, with my thanks to everyone, excuse you till tomorrow morning. Thank you.
Court, all rise.
Jurors have exited the quorum. This court's in session.
All right.
Please be seated.
Anything we need to address before tomorrow? Counsel. Thank you, everyone. We'll be in recess till tomorrow. Thank you.
Court, all rise.
A 36-year-old labor and delivery nurse who killed her 3 children. Stay with us. Welcome back to our continuing coverage of the jury deliberations in the Lindsay Clancy case. The jury has just gone home for the evening after deliberating for 3.5 hours without coming to a verdict and without having any questions. They'll be back at 9 a.m. tomorrow. Judge Sullivan will bring them into the courtroom, and then, as he just put it, it'll be back to work. 9 women and 3 men are deliberating the fate of the former labor and delivery nurse who is claiming that she's not criminally responsible, according to her defense, for the deaths of her 3 children. She admits that she killed her 5-year-old little girl, Cora, 3-year-old Dawson, and 8-month-old Callan. The question for this jury is whether or not she's criminally responsible. Let's bring in our panel. Joining us is Vinnie Politan, host of VPI, seen every night here on Court TV and on the Court TV YouTube channel, along with Claudia King, Philip DeBay, and Cody Thomas. Vinnie, good afternoon to you. We've been chomping at the bit to get your opinion on what we watched today with the closing arguments from both sides. What stood out?
Yeah, well, first of all, stand out. Look at this cast of usual suspects all gathering here at 4 o'clock after court. Amazing. What a contrast, right, in the closing arguments. I mean, Kevin Reddington was kind of like the weather outside the courthouse that is blowing Ted's hair in every which way. I mean, he was on fire. He was throwing things. He was outraged. And basically, by the end of his closing argument, I felt like he wanted to prosecute the prosecutors. Like they're the ones who killed the 3 children. That's what I took away from it. And then when you work to the prosecution, the contrast was amazing. And also effective. Like Kevin Reddington's been doing this for years. He knows how to play to the jurors in Massachusetts. But the prosecutor, she came out and just toned it down, wasn't ranting, raving until the end. The only time she showed outrage is when she was talking about the suffering of the 3 children. So at the end of the day, Ted, I think both sides, and both sides did a great job, but they were so different. I think it really depends on each juror, how they're going to accept someone who is outraged at prosecutors for even bringing this case versus a woman who says, listen, yeah, she's mentally ill. We get it. But she knew exactly what she was doing that day.
As far as deliberations, 3.5 hours, according to your theorem, the Vinnie Politan equation, it's, 1 hour for each day of testimony? It's going to be a long time in this case, if that's true.
Yeah, well, if you look at my theorem here, now this is to give you a baseline. This isn't a prediction. This is a baseline. Sometimes it does work out this way, but for each day of testimony, about an hour of deliberations. For each day of, for 1 hour for 1 day, 1 week equals 1 day of deliberation. So if you have, like we did, 21 days of testimony, 21 hours would be kind of average. 4 weeks, 4 days, right? Give or take. So from my perspective, Ted, if this verdict comes in Friday or Monday, it's a quick verdict. It's a quick verdict, and I would say advantage defense in this case based upon the way it's gone. If we get to Tuesday, we're kind of in the normal range, then I don't think it's an advantage one way or the other. But if we start getting into like next Wednesday, that's the point where this becomes a long deliberation, and there may be a problem in reaching a unanimous decision. So that's where I kind of am in all of this. And by the way, Ted, just so you know, when I came up with this theorem, really, it all started when I was covering a series of trials in Massachusetts, one of which was Kevin Reddington's. It was Mucko McDermott. It was the hockey dad. It was the first big trial in Dedham, Massachusetts. And based upon those results and other ones that I was seeing around the country, I mean, I came up with this theorem. So I think it should apply here. I mean, don't get worried that they're not going to reach a verdict until we get to like late Tuesday into Wednesday.
Philip DeBay, there could be a white flag being waved if both sides show that they're entrenched. Both sides, when I mean the perimeters of both sides, when it's clear there's no way that they're going to get over that hump, which could factor in here, could it not?
Of course, happens all the time. But I got to tell you something, if we're all honest, and I'd be curious to hear Vinny weigh in on this, if these jurors don't know which expert to believe, either the defense or the prosecutions, it means they have reasonable doubt. At the end of the day, when you cannot assess who to give the greatest weight to so that you can reach a verdict, either guilty or not guilty, it means you have reasonable doubt. As a juror, an individual juror cannot declare him or herself hung. It just doesn't work that way. It means that neither side has proven their case based on their perspective. So in other words, the prosecution has to prove beyond a reasonable doubt, not only that she did the killing, but that she was in fact criminally responsible. And if a juror is hung up on whether or not either expert proved that point, they've got to come back not criminally responsible. That is the law. And unfortunately, the attorneys don't really argue that point in their closing because it's such common sense to people in the legal profession. But sometimes it needs to be said, it needs to be hammered and articulated so that if they really are at an impasse because they don't know who to believe, that equals not guilty.
Yeah, Vinny, weigh in. Did Reddington miss an opportunity to point that out? If this was a draw, the battle of experts, we win.
Right, and that's true. But he's never going to say his expert isn't the greatest expert ever. I mean, he's never going to make that admission. He's just going to trash the other side. Here's the thing about the expert testimony in this case. The ultimate opinions of the experts in this case were basically verdicts, right? They're the verdicts. And that's really the job of the jury. So they can, to a certain extent, ignore their ultimate opinions, but perhaps zero in on their analysis of what was going on in her mind and ignore what they said about criminal responsibility or not criminal responsibility, make that decision themselves because that is their decision to make. What's interesting, though, is that other than Dr. Mack, like Kevin Reinke said, just put him to the side. Let's put Dr. Mack over there. There wasn't that much difference in the analysis of the experts. The difference came to what it all means in terms of what their verdict was, responsible or not responsible. So I think the jury can sort of accept both sides and then come to their own conclusion as to what it means.
Claudia, from start to finish in this trial, did you change your mind? Did you learn anything? What stood out to you that maybe jurors as well went on that same journey?
For me, Ted, what really stood out was hearing more about Lindsay interacting with her various healthcare providers and then learning about some of the medication issues that she was having as far as maybe not taking them as prescribed. And then hearing more about the Women and Children's Hospital that she went to, where it was told to us originally that, oh, she was just turned away. And we learned that that wasn't actually the case, that they couldn't take her, but they gave her other options that she declined to utilize. So for me, that was very interesting to learn, and I think a little bit telling as far as the personal responsibility aspect that you were mentioning earlier.
Yeah, and the Commonwealth did a great job of articulating that. Also with the suicide hotlines. Let's go outside. Reddington is addressing the media.
Never confident.
Kevin, did you get your money back from the prosecutors? The 75 cents?
That comes under you don't talk about hallway conversations with other attorneys, so I don't disclose that.
What do you have to say about this jury? The judge complimented them.
They've been great. They've been amazing.
There's a podium here, Mr. Reddington.
I don't care. I don't do podiums.
Kevin does not do
Mr.
podiums,
Reddington,
everyone.
what will it take for
institutions to realize that maternal mental health is a priority and something that needs to be funded and something that needs to be consistently supported for moms around the globe.
Somebody like you to advocate for them.
Yes, thank
Lindsay
you.
Clancy, it was obviously emotional in court. How's she doing after closing arguments?
She's doing all right. She's, she's nervous. She's scared. Watch out. Watch out. She's, but she's fine.
So what's your read of the day one deliberation?
You already got me this morning. Leave me alone.
Mr. Reddington, what do you make of prosecutors saying that this topic of maternal mental health is a distraction?
Presented her case. That's it.
I mean, what do you hope you left the jury with today? I mean,
Pardon me?
What do you hope, after hearing everything from you today, that they're left with? What's the message that they're left with?
I think that they have to weigh all of this evidence, and I believe that the government ultimately has not proven their case.
Curve here. Let them get back to his comments.
Mr. Reddington, I gotta tell you, you are absolutely a rock star. You are an advocate for moms.
Thank you. I appreciate it.
Going down follow, right?
We can cut from here. Well, actually, we'll stick up. Hang on. We'll follow him to the car.
All right, Kevin Reddington walking out of the courthouse with the sort of rock star treatment from the media. Let's go back. We've got a better shot.
Very nice person who's very, very beat up.
Kevin, you said you're never comfortable. What is it?
I don't know what juries are going to do. I mean, I've tried a lot of cases, and I don't know what juries are going to do. I mean, I'm very happy with this jury. They've been very attentive. They've worked hard. They've been involved for a month.
Mr. Reddington, why did you decide to use the photos and the props? Do you think it was effective?
We'll find out, huh?
Thank you all.
You're fighting for women's rights and women's health. Thank you.
Thank you.
Mr. Reddington, what was the bottle on the defense table? Was it pills or mints, people are asking?
Oh, it's just Altoids.
Was it
Any
really?
idea how long this jury is going to take?
Cinnamon Altoids, yeah.
Mr. Reddington, any idea how long this jury is going to take, you think?
Absolutely not. I would have no way of knowing. A lot of evidence, a lot of time on the case, a lot of exhibits, and they've been very, very attentive and working hard. I don't know.
But Kevin, you were here Monday or no?
Don't know.
And any response to those critics who say your closing wasn't as great as it could have been? Just being honest here, I don't know. Do you have any second thoughts about the closing, or you think you left it all on the table?
Put it this way. I have my fair amount of haters. I'm sure there's people that would like to comment on the fact that I'm arrogant and aggressive and a bully and all the rest of it. And so, did the best I could.
You did great.
Thank you. That was kind of a focused question.
Well, no. I mean, giving you a shot to defend yourself.
No need to.
I don't have to.
Yeah.
You did great.
Thank you.
Great advocate.
All right.
Have a good night.
Happy Mother's Day. We appreciate your hard work. I'm an OG spicy mom. I'm a co-parent of women.
All right, Kevin Reddington getting into his Ford Bronco. He'll be back tomorrow, 9 a.m., when the jury is back as they continue to deliberate. Before we catch a break, Vinny Reddington, you've seen him in action over the years. Boy, Philip DeBay earlier put him on the Mount Rushmore of defense attorneys. Your thoughts of his talents and, in this case, his heart for his client. It sure was palpable.
Yeah, it was, but he's been doing this a long time, right? So I was in the courtroom when he was advocating for a man named Mucko McDermott, Mucko McDermott slaughtered, I think it was 11 to 14 of his coworkers in cold blood. He Googled how to fake mental illness, and his defense was the same defense that Lindsay Clancy has. Not postpartum, but lack of criminal responsibility, legal insanity. And Kevin Reddington, in that case where his client literally Googled, and this was before people who Googled realized that we could get that information, despite the fact that he's Googling faking all of it, the jury was still out for days. So at that moment, I was like, this guy's pretty good. This guy's pretty good. And we've seen him, win cases on court TV where someone's charged with murder and they end up with something much less than murder. So I think he gets the accolades that he deserves, but he is he's like the quintessential classic criminal defense attorney, and he's a true believer in what he's doing.
Absolutely well said. Let's get a break. Our coverage of the Lindsay Clancy trial will continue when we return. You watch Court TV, your front row seat to justice.
Welcome back to Cora TV Live. I'm Cody Thomas, and a Massachusetts jury now deliberating the fate of Lindsay Clancy, the former nurse accused of strangling her 3 young children, of course, in January of 2023. Now, while both sides agree Clancy killed the children, jurors now must decide whether she was criminally responsible or driven by severe mental illness. Well, prosecutors argue it was a planned murder, while the defense obviously contends she suffered from postpartum psychosis. Now, the jury has been sent home today and will continue their deliberations tomorrow morning. Kevin Reddington speaking after the jury was sent home today. Let's go back in where we left off before the break.
We took a red-hour flight to be here to support the moms who's supporting Lindsay. We provided water, snacks, and food.
You guys were awesome today.
We love you, and we appreciate this work.
Take me back to California.
Yes.
We drove 17 hours from Indiana. You guys are awesome.
Appreciate this hard
This
work.
way, Kevin.
We've
Thank
been
you.
advocating for moms for the last 10 years.
See you tomorrow.
Is it a good sign, sir, that there's
right.
not a verdict yet?
Where's the truth?
They just went out.
What are you guys gonna? You will go into the weekend, and what's sort of you've been doing this so long. What's your gut say?
It's a very unusual case. It's a very emotional case, a lot of evidence, a lot of exhibits, and Lord knows a lot of time, so I don't know how long the jury's going to be.
Are you tired? You don't ever seem tired.
No, I'm not tired. Probably little Jesus thing.
Can I pat your shoulder?
Get a shot of that, Mikey.
Would you rather a hung jury than a jury that makes a unanimous decision on any of those convictions?
One jury would not be good. All because it just means that everybody has to go through it again. And there's, 16 other people out there somewhere that would have to go through it again. It'd be horrible.
Kevin, is there anything you'd do differently at this point?
Be a doctor. All right, guys.
Thank you for everything.
See you tomorrow. Bye.
Have a good night. Thank you so much.
Kevin Reddington coming out of that courthouse almost like Elvis Presley walking through that parking lot. But let's bring in our panel this hour. The man himself, host of Vinnie Politan Investigates, my good friend Vinnie Politan. Great to see you. My man, former Deputy Public Defender in L.A. County, Philip Dubé. Former law enforcement officer Claudia King. Great to see the gauntlet here this evening following a big day here, first day of deliberations with this jury in the fate of Lindsay Clancy. Vinnie, I'll start with you, my friend. Thoughts on the overall prosecution's case here? I mean, there's been a lot of online discourse that it might have been a little unorganized at times, a little shabby at times. There was a point, Vinnie, where I thought the idea of them bringing that staged suicide situation to the forefront, calling a blood spatter witness to the stand, talking about it. But then at some point, Vinnie, a couple days after that, kind of backtracking, saying, hey, we don't necessarily think it's fully staged, just that the methods were insufficient as to how she went about it. I don't know how that might resonate among a jury, but let me get your thoughts on the prosecution's case.
Yeah, it was very unusual because it was they ended in a much better place than where they started. And I don't think there should be a difference for prosecutors in where you start and where you end. Your case is your case. But it seems that they sort of changed their approach on some of the issues. And where they finished today was this was the strongest that they've been throughout the entire case. And I guess that's when you want to be the strongest. But I'm just wondering why in the beginning, they sort of had one posture towards Lindsay Clancy, and by the end, it was much different. And where they ended up, like I said, is a much, much better place and focusing on a few key issues. And I thought one thing that really jumped out at me was the fact when it came to those thoughts she had about harming her children. She told Patrick, she told her mother, but she never told any of her treating physicians. That could resonate with the jury on a couple different levels, but on the most visceral level is if she had just told the doctors, these children would be alive. And I could see a juror looking at that and saying, listen, I'm not giving her the benefit of any doubt here. She is the one that wasn't truthful with her treating physicians and healthcare providers about what thoughts she was having. And prosecutors got that in, talking that she was, she had control over what she was saying and how she was controlling information, et cetera. But to me, it's the visceral reaction to that fact that could be a real problem for her. All of a sudden, you don't feel as sorry for someone who is more concerned about what the healthcare providers might do as a result of her being honest about the thoughts that she was having.
Claudia, you and I have talked for weeks about this. I know you've kind of echoed some of the same sentiments that Vinny was making there. The aspect of this personal responsibility regarding everything that went down. You know, despite the very real aspect of mental health, we're not discrediting that at all, but you know, some in favor of the prosecution, as Vinny was saying, suggest that, you know, she wasn't as honest as she should have been to her treating physicians. Therefore, as Vinny was just making the point, these children might still be here if you were as honest or taking the medication as applied, things of that nature. I want to get your thoughts, Claudia.
I absolutely agree with what Vinny said. And as you said, we have discussed just that, because it's really hard to put the blame on the doctors or even on the mental health issue when the person isn't giving all the information that the treatment providers need to properly treat Lindsay Clancy. And so I could see some jurors having a real issue with that, because they might think, as Vinny said, well, had she just been honest, we probably would not even be here. We'd be in a totally different situation. And I think that could be very troubling for some of the jurors, absolutely.
Philip DeBay, let me get your thoughts on the defense's case here. I mean, we see Kevin Reddington, of course, he had some fanfare beforehand because he's been a very meticulous attorney in his illustrious career, but it seems like the fanfare has kind of kicked up a notch in the past 5 weeks dealing with this one. I mean, you've seen people come from all over bringing their children to take pictures with him as if he's Michael Jackson or something. We saw somebody place some little toys, like a little Jesus piece on his Ford Bronco there with a note, obviously, here. Clearly some people across this country, across the world, think he's doing something right here, Philip, on behalf of Lindsay Clancy. But it's not about the fanfare, Philip. It's about what was presented in court. How do you think the defense did throughout the entirety of this trial?
Well, for the most part, I try to disregard what I call the online jurors and certainly the buffer zone jurors, because they're all there in support of one side or the other. What I am focusing on is the 12 in the box. Remember, they sat in that courtroom throughout this entire trial and they heard every piece of evidence. And I think that Mr. Reddington did a tremendous job presenting his case to that jury. I don't think anybody could have done it any better, any more streamlined, any more efficiently, and certainly as what I call the master of economy of words. He did it with such succinctness and brevity, and it was so easily understood. I love that quality about what I call the old-timer attorneys, and we can learn so much from them. So little bravado, so little fanfare, no PowerPoints. It's just him, the lectern, his hands, and a few notes, not to mention his own modulation in his voice. I thought he was fantastic. The only thing, like I may have said in the earlier block, that I wish would have been more emphasized is the sudden onset of PPP. Remember, it doesn't present it presents incrementally, but also in a fulminant fashion where it just dramatically comes on. And it's kind of like what we talked about maybe in a previous segment, where you're on a transatlantic flight comfortably, there's a little turbulence, maybe a storm, little uneasiness, and then all of a sudden there's bird strike. And now you're in a free fall and you're in crash mode. What do? That's what PPP is. It is an emergency crisis that I don't think got emphasized. And it goes back to what I said earlier, that people tend to associate postpartum with a baby blues, a little depression, a little downtrodden, a little crestfallen. They don't truly understand the emergency aspect of it and how you need to be in an inpatient setting forthwith. Otherwise, you're a danger to yourself or others. I just don't think that that point was highlighted enough, and it was a missed opportunity from my standpoint anyway.
Well, maybe some people in that jury box, as they're back there deliberating, Philip, they'll have those same thoughts. I mean, they got to dissect a lot of this, and that's, as I've been saying for weeks, the weird, strange dichotomous line that they're going to have to walk on either side when dealing with the whole mental health aspect of this case. But of course, we're going to keep talking about it on the other side. Claudia, Vinny, Philip, stand by, my friends. Keep it right here, folks, on Court TV as we continue breaking down the first day of jury deliberations in the Lindsay Clancy case right here on Court TV.
So why did she specifically do it? She was depressed. She was exhausted. She was done. She didn't want to try anymore. She felt damaged. But those kids were her protective factor. Those kids were keeping her from ending her misery. And so she had to remove the protective factor. And I'm not saying she was happy about it. I'm saying that it was what she had to do to end her misery. But it was a choice. It was a choice. She could have kept trying. She could have, moved down to her mother's. She could have killed herself and left her kids alive. But it was a choice to take them with her. It was a horrible choice. And it's a choice that we don't want to think about that a mother could make, because that doesn't make us feel safe or comfortable in this world. But it's a choice she made. She knew it was wrong because she sent Patrick out to do it. She could conform her behavior because she waited until he was gone and didn't tell him what was going on those phone calls, didn't call 911 for help, didn't lock herself in a bathroom upon hearing this voice. She knew it was wrong. She didn't take advantage of this situation. She created this situation, this opportunity to do what she wanted.
So that was the Commonwealth's closing arguments earlier this morning. Now, the jury has been sent home for the day and will continue their deliberations tomorrow morning, of course. But for right now, let's bring in this wonderful panel of guests to discuss today's proceedings in the Lindsay Clancy trial. Host of Vinnie Politan Investigates, the man himself, Vinnie Politan, former deputy public defender in LA County, Philip DeBay, and former law enforcement officer Claudia King. Vinnie, we're listening to that bit of the closing there from the prosecutor, and something that stood out to me, Vinnie, is that the usage of the word choice. She made a choice to take these children with her. I know you've crafted up some closing arguments in your heyday, my friend. How important is that sort of verbiage, to use that word choice? Because to me, it takes everything away from all that psychiatric terminology and brings it back down to the bare bones. Lindsay made this choice, not some external voice, not this male voice, to do this horrendous thing. It was her. What do you make of that?
Yeah, this is the way the prosecutor was able to frame the case, right? And that's part of what you do in your closing argument, sort of frame the issues, marshal the evidence. And prosecutor wants this jury to focus in on the voice, because they're not buying the voice, right? The prosecution isn't. When you look at that day and you look at what it took to kill the 3 children, Patrick has to be out of the house. The evidence is, and what the defense is saying, is that the voice does not intercede in all of what was happening that day until Patrick is out of the house. But it was Lindsay who got him out of there. So she wants the jury to focus in on the things that she did before the voice allegedly came in, was giving her these vague commands, right? So to me, that is a brilliant way to do it, because she makes the choice of where to eat. She makes the choice to send Patrick. She makes the choice not to get Uber Eats. She makes she makes all these decisions that result in the opportunity for her to kill the children. And then coincidentally, that's when the voice arrives, right? So that's why she's calling into question the voice. And because the voice is not commanding all her actions, isn't telling her how to pull it off. And according to prosecutors, to pull this off, Patrick has to be out of the house. And the voice, admittedly, is not in the equation at that time. And that's potentially, if the jury understands and follows this framing of the issue, is a big problem for the defense.
Absolutely. And Philip, to Vinnie's point there, I mean, the prosecution's strongest argument has, consistently been that Lindsay made these choices, sent Patrick out on these errands, acted on her own volition, carried out these killings, attempted the suicide, made those decisions along the way. It's just the question of if the jury thinks the Commonwealth effectively connected the dots to the legal responsibility. But for right now, Philip, thank you so much for joining us this afternoon. Vinny, I'll say goodbye to you now, but I'll see you back here at 6 o'clock. Claudia's sticking around with us as we continue our coverage of the Lindsay Clancy trial. That's next, right here on Court TV Live. Welcome back to Court TV Live. I'm Cody Thomas. Deliberations are done for the day in the Lindsay Clancy trial in Plymouth, Massachusetts. Now, after 5 weeks of emotional testimony and closing arguments, 12 jurors are deciding if Clancy was legally sane when she took the lives of her 3 young children. The jury will return tomorrow morning, but let's go back for now and listen to those crucial closing arguments from earlier today.
About 5 weeks ago that we met like this, and I indicated to you that thank you for incredible service. That, all of us mean that sincerely. You took literally more than a month out of your lives and sat here attentively, incredible, through some of the toughest, most gut-wrenching things that any person can be subjected to. And I indicated that, sadly, jurors carry this struggle with them for years. And the service that you have performed, I have never seen before. You have listened to evidence. You have been fair. You have been objective. You've listened to the judge's instructions, and you've carried them into your heart, consistent with your oath, which is a very, very solemn oath. Passed between government and Lindsay, who has placed herself on her country, which country you are, as a jury of her peers. When you consider what's at stake here in the sense of what we've been dealing with, Cora, Dawson, Callan. She knows loss. And that's why we think of Cora, Dawson, Callan. For a minute. They are the victims of this case. They are the victims of the horrible, horrific act that has been laid at your feet as jurors to decide whether or not Lindsay is guilty. Beyond a reasonable doubt, as His Honor instructed you and will instruct you, what that means, that standard of proof that we as citizens in this country are so blessed to have, proof beyond a reasonable doubt before the government charges any citizen with a crime. I don't care how many cops you have in here, how many DAs are sitting here, how many people are sitting in the front row, and they're all going to sit there and be proud of this prosecution. I told you in the opening statement that this is a prosecution that has ripped the soul out of this girl. This is what they had. This is their family. How does this turn into this? How? Because of the damn medicine and the lousy medical care that she got. You can troop as many paid experts as you want to come in here and tell a jury, oh, well, she didn't say that she heard voices inside her head. She said she heard voices from outside her head. She said she was making chicken McNuggets. There was a bowl on the sofa. She wasn't making chicken McNuggets. She said something as I think and I muse and I try real hard to tell you what my opinion is, that this woman was acting in her right mind when these children were killed. So, when you consider the evidence in this case, you consider the person who is in front of you, who is the defendant, as the government refers to her, and as His Honor will than likely tell you, even though a person is a defendant in our system of justice, you don't have to defend against anything. The government has the burden of proof. When the DA decides to charge someone with a crime, he has the burden of proof. His assistants have the burden of proof to prove, number one, that Lindsay is guilty of this offense beyond a reasonable doubt, and then prove, number two, that Lindsay, at the time, killed her children, was not suffering from a mental disease or defect that caused her to have a lack of substantial capacity to appreciate, to know, to realize that what was being done while she was in a psychosis. But we'll laugh about that. It's just another woman. I guess it's just going to make an excuse. She's depressed. GAD, general anxiety. Give her a couple of pills, she'll be all right. You know from looking at the objective evidence in this case, this young lady, believe me, I don't have many clients like that. This young lady did nothing wrong in her life. She was a nurse, a daughter, a wife, and a darn good mother. You can see from the objective evidence, you can see, and you'll have all the exhibits for you to look at, and you can see by looking at these photographs, which you will have in the jury room. You can see the Facebook postings. You can see what she indicates about, for example, I just randomly grabbed this one, a son, my prince, that they would have you think she killed him first, cruelly, because she didn't like him. That is repulsive. So she's living her life with Pat, her kids, having a great time that summer. Life is good. She had to go back to work. In an opening statement, I told you, I said, watch the evidence. Watch the manipulation. Because that's what this case was built upon originally, and how it developed as the case progressed until it's in front of you. And how does that happen? Well, in the very beginning, going all the way back to when the first 911 call that you had to suffer through was made, you could hear in the voice, Pat Clancy, the horror, what he had obviously experienced. You can see from the evidence that's before you the injuries that she suffered. You will have in the jury room the exhibits that indicated the extent of the injuries from, I don't have to go through all of them, the extent of the injuries to slitting her throat, to slashing her wrists, throwing herself out a window, blood all over the bedroom floor, window open, screen slashed. Oh no, the screen wasn't slashed, my bad. That's what she thought. It's called a delusion. She was in a psychosis when she thought that. Probably right here, sitting here, believes that she slashed the screen. She didn't. It's objective evidence. And why did we spend almost a week showing you the extent and the severity of that suicide attempt? The reason that we had to do that is because they were arguing that it was a fake suicide. Dinky little cuts, no bleeding. She didn't mean to kill herself. She's just going to throw herself out the window, I guess, and slide down the house. Remember that one? Hanging off of the window, sliding down the house, and Lindsay screwed up, and she hurt herself bad. You know that's not what happened. You know that she made, the testimony of Dr. Velkovich, that she made a very, very significant suicide effort slashing her wrist, slitting her throat. And isn't it interesting when you consider objective evidence? Googling slitting a throat. Googling suicide. Googling drugs. Googling side effects. Googling ketamine treatments. Googling all of these drugs. Googling the effects of Tufts medications. Lorazepam, sertraline, hydroxyzine, lorazepam, buspirone, trazodone, fluoxetine, zolpidem, myrtazine, clonazepam, quetiapine, diazepam, quetiapine. It goes on and on and on and on and on. You have the chat, you have the descriptions to see. And obviously, she wasn't consuming all of these at the same time, because one thing this kid did was try to do what she was supposed to do. She took the drugs as she was told to take them. She was religious in her obligations to take care of her health. She went to Dr. Tufts when she was a young lady living in a house with a husband and her babies, respected nurse, wife, friend, mother. Should have kept drinking, huh? That was a big deal, wasn't it? Remember that? We're just going to assassinate this young lady in every which way we can. Remember that evidence? Oh. I was concerned. She was drinking 5 drinks a day. She was worried about, you heard the evidence up to 2019. What are they talking about? She wasn't drinking while she had her kids. She wasn't drinking while she's breastfeeding. She would have a couple of beers with her friends. That's bad. Put that over in the bad pile. Right here. We spent all that time showing through Dr. Laposada's testimony that this was a legitimate, dreadful, horrific suicide attempt. You think about this beautiful young girl throwing herself out a window. That's a quarter. I don't know if you ever played pool. I challenge you to tell this jury why we spent a week showing that she committed, your witnesses.
Counsel, address the jury, please.
Said, their witnesses, serious suicide attempt. Remember that? Tried to kill herself. So now they'll back off on that, and they'll agree. A serious suicide attempt. That's why I say, watch the evidence. Watch the manipulation. Remember the argument with the bands. She took the bands out of the bag, put the gloves on, talks to Dr. Laposada on the Zoom, slams the bands down out of the paper bag, does the movement of the bands and yells at Laposada and says, wrapped. They were just wrapped. They weren't knotted, because you gotta get Lindsay tightening the band, right? You gotta hold it. You gotta hold it for a minute. You gotta hold it for 2 minutes, 3 minutes, 4 minutes. That's why she needed the bands not knotted. And then she said, it's like this. And they sprang open. Remember that? Dr. Laposada said, yeah, I saw what you did. And she walked away like if the glove won't fit moment. Quarter number 2. What did Patrick Clancy testify to? You heard his testimony. He indicated clearly, unequivocally, that they were knotted around the necks of those children, to the point where he had to struggle. And it's your memory, not mine. If I say something you don't recall, forget it. It's what you remember the evidence to be. But clearly, I would suggest, he struggled to get it off of Dawson's over his head. And a police officer saw through the window. This is horrific stuff. But it's objective, and it shows the manipulation.
All right, let me bring in my guest this hour. Still with us, Claudia King, and joining us, trial attorney Mackenzie Joy Brennan and family law attorney Randy Kessler. Mackenzie, Randy, great to see you guys, my friends. It's been quite some time since we've done this dance, but I'm happy you guys joined the program here. Randy, let me start with you, man. Talk to me about the contrast of these closings today, prosecution versus defense. Who do you think won the day? I know you and I talked earlier about Reddington kind of being like the grandfatherly, softer spoken. You know, he got his passion in there, but really speaking to the jury versus the prosecutor kind of being a little bit more ambitious. What did you make of today?
Yeah, I mean, our conversation earlier today, I think, was right on target, which is, you know, he got away with calling her the kid. This guy, I mean, there were 3 kids that were victims, right? This woman was the mother, the adult in the room, and all of a sudden he pivoted and changed the focus to trying to make her the victim. This poor kid, she was suffering from all these mental illnesses, from all these medications, from all these healthcare providers. Have some sympathy on my client. And the way he did that was beautiful. And he did it in a grandfatherly, mature, sophisticated kind of way. He's an authority. He's definitely sophisticated. He's been around the block. I want to believe him, right? The jury hasn't been in the courtroom as long as he has. Nobody has. And he's been in that courtroom and he's been in our system longer than the prosecutor. So I think he gets the edge there. And on the prosecutor side, you know, I almost feel bad for her. I feel like, well, she's got this job to do. She's got to prosecute a woman that's, you know, close to her age that did something horrible. And I think they know she's an employee of the state having to do her job. So I think he had the, not that it's easy, but the better inroads to connect with the jury and to say, look, you know, I'm the only one standing up for her. This whole time they've been, you know, pointing the finger at her. She pointed the finger at herself. She tried to jump out the window. And the best thing I think he said, she's got a clean history, right? This isn't a convicted felon, and this is 5, 6, 7 times in front of the jury, in front of a judge, in front of a criminal, you know, prosecution. This was a one-time thing, and she's going to suffer the rest of her life. She's had enough. Please, just enough already. I mean, I like being in his position. I give him the odds on to get the verdict that they're looking for versus the prosecution.
Mackenzie, let me get your thoughts. Me and Claudia have talked about it in earlier segments. I want to get your thoughts on the closing arguments as a whole, and you know, specifically since we listened to the defense here, do you echo the same sentiments that Randy echoes about how Kevin Reddington carried out his closing argument today?
Yeah, I agree with Randy that Reddington really carried the day. The few things that I do think weighed in favor of the prosecution in listening to the closings, I do think them pointing out that she could control her behavior on some instances was a powerful point. And then just the horrific nature of everything. I think that that's why this case has borne out a lot of conspiracy theories is just people cannot sit with the reality of what happened. Now, on the other hand, to the controlling her behavior, women do mask more than men with mental illness. That is a documented phenomenon. I don't know what you do with that. But it is true. And I did think the juxtaposition of Reddington showing that this is, you know, the healthcare system on trial, especially for women, mental health, postpartum, all compounding. And then the prosecution came in and said, she had health insurance, she had maternity leave, when we all know that that is woefully insufficient in a lot of cases. And this has shown that.
Claudia, let me ask you, you know, do you think that the points that Mackenzie just pointed out there, you know, women in the healthcare system being marginalized, and sometimes, you know, it's a greater conversation to have. We've seen all these crowds of people outside the courthouse. I mean, it's adjacent to the Karen Reed crowd. I mean, we're seeing the same sea of pink, but for different reasons here. Do you think this is why it's resonating so much with people across the country? Of course, we're here for the 3 young babies that were killed. We're here on, you know, on behalf of Lindsay Clancy's case. But some people are outside the courthouse bringing up larger conversations. Is that the reason that you believe that this is connecting with so many people, whether it's online, in person, traveling from across the country just to meet Kevin Reddington? What are your thoughts on that?
I think you're absolutely right, Cody. That is the reason that it's really connecting with a lot of people, because there are a lot of problems with our healthcare system, and a lot of people don't have good health insurance. They don't have access to good care, and women do sometimes get marginalized when they're trying to get care and they can't get it. And I think that really connects with a lot of people, and it makes them feel for Lindsay and what she may have gone through for months and months, and really even years if you look at issues she had with her previous children even, and it just got worse with each child. So I think it resonates with people because they want a system in place in our country that treats everyone equally and has access for everyone to get the care that they need. And mental health care has suffered for so long. It's improving, but it definitely needs to get better. And that really resonates with people. They want people to have access to that treatment.
And of course, it's not the specific reason we're here. The healthcare system is not who is on trial. But again, I think in years to come, this will be a trial people look back at to, be the martyr of this larger conversation. Stand by, my three friends. We're going to listen to more of this defense closing argument after this short break right here on your front row seat to justice. The month-long Lindsay Clancy trial featured more than 70 prosecution witnesses and 10 defense witnesses, including top forensic psychiatrists. Now, the voluminous evidence covers hundreds of pages of medical records, prescription drug logs, text messages, and recorded interviews conducted in the months following the January 2023 deaths of the Clancy children. Now, all of that led to today's closing arguments, where the attorneys gave their final statements to the jury before deliberating. Let's go back inside for more of the defense's closing from earlier today.
This government, this prosecution is a mess. They would take their evidence and argue to you that she did not tie a knot and walk away, because as Dr. Laposada said, you're talking about 4 or 5 seconds, so somebody passes out. No, they got to have the 4 minutes, and that's not what the evidence shows, is it? So, as we move on, Lindsay's in the hospital. And this whole thing about conversations, and she's talking to people, and the kids are in the basement. Her throat was crushed. You heard the 911 team. You draw the inference whether or not there's a conversation about where the children are. I tried to kill myself, the kids are in the basement, all that. You determine whether or not that was something that could be discerned. And the police investigation, because as His Honor indicates, there are two things here. Number one, proof beyond a reasonable doubt that she's guilty, and number two, proof beyond a reasonable doubt that she was not suffering from a disease or defect, as His Honor instructed you at the time of these killings. Those are the two things they have to prove. And when the police charge somebody with a criminal offense, they have an obligation to investigate. At the end of the day, when you're talking about, well, we've got the charges before the court, you can sit there in the court, you can feel proud of yourself. Did you do a good investigation? Do you even know what this, you'll see the photograph of the cup and the powder. What is it? They don't even analyze it. Did they take pictures? Did they analyze? Did they test the blood? Lousy investigation of this. Well, that's okay, because she was guilty, and they put her in the hospital, and she's the evil woman that killed the 3 innocent kids. And they're going to stand there while she's chained to the bed, paralyzed. You heard testimony from Dr. Zeisel. They weren't little fluffy cuffs that were securing her to the bed. They were handcuffs, not the medical treatment. Medical treatment would be, like restraints, so you don't do whatever, pull lines out and things. We're talking about when the big men were in there with their guns and their badges, and they're sitting outside the door, and they're going to make sure that Lindsay Clancy, paralyzed, chained to the bed, doesn't get up and run away from the hospital, I guess. And they just have to suffer their way through. I guess I worked 8 hours. I had another shift I had to work that night. This is the treatment. And what's important about that is what kind of treatment did this young lady get from the health care providers? Remember Meg Collins? She came in this court, Meg, you might remember. Tall woman, short blonde hair, squared away. Unbelievable. Unbelievable. She was not only a nurse taking care of her in the hospital, she advocated for her. She stood up for her patient. She protected her. During the pandemic, you know that Meg Collins was in that emergency room when half of us were hiding at home behind our computers, hoping that we're not going to die in a week, drinking that Chardonnay at 11 o'clock in the morning. Meg Collins was in a hospital treating people and advocating for them. That's an example of what nursing is all about. Not having attitude, not treating somebody like they're to be disdained. And what's even worse, she comes out of a coma. She is intubated. She has had major, major surgery of her broken, crushed spine, vertebrae, rib, thyroid, massive Massive, not my words, medical records, massive testimony, blood transfusion for the blood loss. And when someone, you've heard evidence, comes out of surgery, they're delusional. You've had anesthesia. You've had think about having your tooth pulled. Think about the trauma that somebody has when they're in a hospital bed laying there paralyzed, unable to feel the lower half of their body, but able to feel with the meds and the pain medication and everything else, the damage to the spine. And then the hospital has a meeting. Remember the other doctor, I think it was Dr. Shah, the Indian woman? Wicked impressive. She was amazing. She had the facts. She was able to tell you exactly what she observed. She was able to tell you what they were doing to treat Lindsay. She treated her like a human being. She was a damn good doctor. Came in here and told you all of her observations about her and told you one of the things that ultimately that they were concerned about is they had to have this big confabulation about, we're going to take her off the, the health care process. They had to have lawyers. They had to have people there. They had to have her signing documents. They had to determine whether or not she was going to be signing something to have her parents take over because Pat was not going to be responsible for her care. Lawyers, cops, handcuffs. Do I need a lawyer? Write that down. Where are you? You're out there somewhere. Write that down. Boy, she wanted a lawyer. That's a bad thing. Must be guilty. Let's put that in the guilty pile. That's why she said that, in a delirious state, dealing with all of these people about that issue. But what's even more nefarious, is you think about it, as I said, your eye on the ball because of the manipulation. Paul Zeisel, big deal. I'm friends with the guy. You heard evidence that I called him. I was with Pat a night or two after this incident in the bedroom with all the blood. I was with Pat taking evidence that the police didn't even see in their thorough investigation. And I was able, as you know now, certainly, to grab this. Why wouldn't the police have grabbed this? They're all empty. You can see when they were prescribed. You can see what they are. You can see what she took. You heard the testimony. It's tough to take a handful of pills. Remember the guy saying that yesterday? Tough to take a handful of pills. Well, no. They were crushed. Oh, shit, they were crushed. Okay. Where's the residue? Where's the crusher? Where's anything? Doesn't matter. Doesn't matter. Great investigation, guys.
Kevin Reddington with that passion there during his closing earlier today, and we're going to listen to more of it after this short break. Keep it here on your front row seat to justice. Proceed to justice. Welcome back to Cora TV Live. I'm Cody Thomas. Now, a point of contention during closing arguments was Lindsay Clancy's jump from a second-story window following the killings of her 3 children. Now, defense attorneys described it as a desperate, near-fatal suicide attempt proving severe madness, while prosecutors framed it as an attempt to avoid accountability after executing her planned crimes. Now, the jury has been sent home for the day and will continue their deliberations tomorrow morning. But for now, let's go back inside the courtroom for more of the defense's closing arguments from earlier today.
So you have a situation where they leave this behind. They don't even look at it. One of them, and again, your memory, not mine, one of them testifies, well, they might have looked at it and saw it and just didn't seize it. Seriously? They go down to the kitchen, they seized every pill bottle that was in the cabinet, along with the books. And speaking of books, one of the things that they found, smoking gun. Good moms have scary thoughts. Hallelujah. Put that in the guilty pile. We're going to put this in a plastic bag. We're going to show it to a jury so they know that this young lady had scary thoughts. Turns out that Jolada gave it to her. So you have this evidence. You have evidence of sleep aids. You have evidence in the bag, because obviously this stuff was just thrown in there. It wasn't in a bag when I saw it inside this thing here, and we seized it, and we held it for 3.5 years. Anybody care about it? No. You had evidence that police knew that I had it. They could have it, they could look at it, they could analyze it, do whatever they wanted. They didn't have to. This here, you heard evidence. This is a little wish jar that they bought on their honeymoon in Hawaii many years prior to even having kids. And when you look inside it, you see that there's all sorts of little folded up pieces of paper. Some of them are dated, some of them aren't. They go all the way back to 2017, 2018, 20. And they reference her wishes to have healthy kids, her wishes for her kids to be successful, her wishes to have a good birth, second time around, hoping for a good birth, worrying about the child with I forget, where they rub the thing like. This woman lived for her kids until she had the pleasure running into Dr. Tufts of her 2 months experience. And after she ran into Dr. Tufts, it was not a wonderful life anymore. And what did Dr. Tufts do? And everybody laughs at me. I said the television. Okay, I know it's a telemedical thing on your telephone or on a Zoom. Take more pills. You have the medical records. You heard the testimony. You know her concerns. You know her fears. Does this seem like a young lady that didn't care and wanted to score more drugs off somebody? That's another repulsive allegation. I think the evidence is pretty clear. There's no basis for that at all. She was scared. September into October of 22, young, vibrant, hardworking, you've heard all this, not my words, witnesses' words, holding goals for herself. Hardworking nurse, hardworking mother, would take the kids to the Kingsbury Club. That's another thing. Sounds pretty snooty, doesn't it? Oh, they're at the Kingsbury Club. It's a swimming pool and a place where you can exercise. Watch the manipulation. Because now you've got a situation where you've got manipulation with the Kingsbury Club, you've got manipulation with these other items here, and you've also got manipulation of Paul Zeisel told Lindsay what to say. Say that you're hearing voices. Think about how ugly that is. Because you know, beyond a reasonable doubt, even though we don't have any proof, we have no burden. You heard from Sheila. Remember Sheila, the woman that's the reverend or whatever, she's the chaplain at the Brigham and Women's Hospital. She didn't know Lindsay from anybody that night when she came in all broken up. And she told you that she continued. She was there when Lindsay came out of, was extubated. She was there when Lindsay was going through her treatments. She was there for 8 days before Paul Zeisel even knew Lindsay existed. But they would be in here telling you that Lindsay saw the psychologist because the lawyer went and got the psychologist to go and speak to her. And then you have these guys here, the cops. They're having meetings, talking about it. They're talking about it. Must have been the shrink. Must have been the psychologist. Must have been Zeisel. He's the guy that told her what to say, and he did not. How can you ruin a man's reputation with the career that he has had and still has, thankfully, to put him in a position where he tells a broken young woman who is vilified by our society for killing her 3 children, that he goes in the hospital and tells her to say she heard voices. Disgusting. So now you know that she told Sheila first that she heard voices. Command hallucinations. She didn't say command hallucinations. I heard voices. It was a male voice. Told me. You had these other guys that came in. The government's rebuttal witnesses. Very, very impressive. Very, very impressive. The first 2. Mac, put him aside. You've got the other doctor as well. So Mac is, why he was freaked out when I asked him where he stayed. And the other guy looked at me like his eyes were bugging. Why did I ask where he stayed? Whatever. Point is, they don't see her for years. Years. And why? The other guy, Halburn, I think it was Halburn, he had to wait until maybe it was the last man, I forget. They had to process his payment from the DA's office through the school. Who cares?
All right, still with us this hour, trial attorney Mackenzie Joy Brennan, family law attorney Randy Kessler, and former law enforcement officer Claudia King. Mackenzie, let me ask you something. It's something I wanted to bring up here. On that verdict form, Mackenzie, manslaughter is on there as a lesser included. I feel like that changes things up a little bit as far as what this jury has to consider.
Yeah, I think all the options at lesser. I believe you have first degree, second degree manslaughter, and then not culpable for mental disease or defect. I think that on the one hand, that might move towards a hung jury because you do have so many options, but more likely it does give some grounds for compromise. And I think that manslaughter being on there is, if I were a betting person, that would be the place where I'd put my money. You know, Reddington is super conversational. He makes it really, really hard to take the prosecution at face value. And so I think manslaughter, if I were on the jury, would be the best that I could give.
Randy, I want to get your thoughts on this manslaughter lesser included on that verdict form. To me, that kind of seems like it could be an easier path to a conviction on behalf of the prosecution versus the first-degree murder.
I think it's sneaky, right? If she didn't have the mental capacity to do this, then whether it was murder 1, murder 2, murder 15, she didn't have the mental capacity. What did she have the mental capacity to shoplift but not to commit murder? They're saying, the defense is saying, she didn't have the mental capacity to commit a crime. I agree with Mackenzie. This is an out if the jury wants to compromise and somebody doesn't want to do murder 1 and somebody doesn't want to give her not guilty, they can compromise. But to me, my money's on a not guilty or not guilty by reason of insanity, not guilty by reason of mental incompetence. You know, Mackenzie said something earlier, which I agree with, which is, you know, we want somebody to pay for this, right? That's in every criminal case, every murder case. And so that desire to make someone pay for it, and why they spent so much time on the gruesomeness of this crime, which is really irrelevant, right? No matter how gruesome it was, is irrelevant. She did it. The only question is, why did she do it? So if the jury can't get their heads around the fact that maybe nobody's going to really pay for it, there might be a compromise verdict and they might have the manslaughter charge. But my money is on the fact that I think it's hard. The only thing that makes it a little bit harder to get a not guilty is I think women are tougher on women. I think women have a harder time believing that other women could do this, just in my experience in jury trials. And that's not uniform, it's not unilateral, but you know, women hold other women to a standard that, you know, listen, I wouldn't have done this and she's not going to get away with it. So we'll see where it ends up.
That's interesting, Randy. I was talking to one of my female friends, and she said the same sentiment because I was in the mindset of, you know, more women on the jury, 9 women, 3 men. Maybe the women will empathize with her more. And she told me, you know, the same sentiment that you're saying. She's like, yeah, that could be true. But at other points in time, especially if there are some mothers there that can't understand how a mother could harm her kids in this capacity, you know, let alone maybe some of them can't even give them a spanking sometimes, you know. So that's a very interesting point there. Claudia, let me get your thoughts just on this jury in general. I mean, the work ahead, you know, the tall task they have ahead of them, whether that verdict comes down tomorrow, whether it comes down Monday, Tuesday, Wednesday. I mean, look at all the different viewpoints we have here just on this panel. And can you imagine if you had, there's 4 of us here, 8 more people to discuss and talk about all the different branches off this tree trunk that we're talking about here and recognizing mental health in this capacity. But on the other hand, Claudia, we still got 3 dead babies here. I mean, it's going to be a loaded deliberation, I would imagine.
I agree with you, Cody, and I've always wanted to be on a jury, but this is the one jury I would not want to be on in any way, shape, or form because it is going to be very emotional. They have so much evidence to go through if they do want to go through it piece by piece and line by line and report by report, and it probably will get very heated because I think there will be people on that jury with very strong opinions one way or the other. So I agree with what they said earlier, that there could be a compromise with the manslaughter being available to them because I just think this is going to be a tough one and it will take a while.
Absolutely. And again, I've said it multiple times over the last few weeks, I do not envy anybody on that jury given everything they have to consider here. Thanks for joining us this evening, Randy Kessler and Claudia King. Great to see you as always, my friends. Mackenzie, you're sticking around. When we come back, more from these defense closings. Keep it here on Court TV.
This is what they had. This is their family.
Lindsay Clancy's fate now in the hands of a Massachusetts jury. 5.5 weeks of testimony, over 80 witnesses called between the prosecution and the defense. The jury has just been inundated with all kinds of emotional testimony, psychiatric testimony, medical testimony, and it's a tall task. They're going to have to dissect all of this. But folks, coming up next hour, Vinny Politan is going to join us to help break down today's closing arguments and deliberations. Keep it right here next hour on your front row seat to justice.